Okay, so we have your W-2 and mortgage deduction, your receipts, charitable deductions, mileage claims. Let's see, are we missing anything else? Oh, do you owe any use tax?
What's use tax?
It's usually owed when you buy something from an out-of-state company or website that didn't charge you California sales tax. So do you think you may owe use tax?
Gosh. You know, I did a lot of online shopping this year. I think I have some receipts from a few things I bought.
Oh, that's easy to add in on your return. Let's see what you have.
Oh.
The revenue collected from use tax helps pay for important California services like public safety, healthcare, and schools. Remember, when you file, pay your use tax. To learn more, visit boe.ca.gov. Paying your use tax. Good for you, good for California.
Take that as an indication everybody's ready.
I've arrived.
You're techie and ready. Yes, I'm set. I don't know why they got all the fancy stuff. Or everyone else.
I just don't even want to
gets
see it, but for some reason it just pops up all the time. I mean, yesterday it went away for a little while.
By the time we get that Blackberries, it'll be it's
Oh, that's what you guys did, my stuff. Yeah. No, you know what? I live with it. I'm fine. Appreciate it, but I don't know.
You ready?
Mm-hmm.
Go.
it's quiet.
Bet. Ready? Okay. Good morning, members and guests. Let us reconvene the meeting of the Board of Equalization. Ms. Richmond was our first matter.
Good morning, Chairman and board members. Our first matter on today's agenda is item C, Sales and Use Tax Appeals Hearings. Item C2, Jantex Inc. and Beyond Inc. Please come forward. Board Proceedings has received contribution disclosure forms for today's hearings from the parties, participants, and agents. All forms were properly completed and signed. No disqualifying contributions were disclosed. All parties, participants, and agents are on the alpha listings provided to your office. Each person sitting at the table will be asked to introduce themselves and, if necessary, their affiliation with the taxpayer for the record. 10 minutes is allocated for the taxpayer's opening presentation, followed by 10 minutes for the department's presentation, and 5 minutes is allocated to the taxpayer for rebuttal. Mr. Horton?
Thank you. Chad, this is your first time before the board?
Second time.
Oh, second. Oh, okay. All right. In that case, would you please introduce the issues of the state? Please commence with your introduction first.
Good morning, Mr. Chairman and members. I am Chad Backus on behalf of the Appeals Division. The appeal before you presents one unresolved issue, which is whether adjustments are warranted to disallowed claimed non-taxable sales for resale.
Thank you. Welcome to the Board of Equalization. It's a pleasure to see you. You have 10 minutes to make your presentation. We would ask that you commence with your introduction. For the record, please be advised that the board will return and allow you 5 minutes on rebuttal after the department's had an opportunity to testify.
Thank you, Chairman Horton and members of the board. My name is Jesse McClellan. I'm here with Jan Springer, President of Jantex Inc., and Opal Mehta, the Vice President of Jantex Inc. As she informs me, she's also the General Manager, the Operations Manager, and the Chief Bottle Washer and Trash Emptier. The issue that we're going to address and ask you to decide upon today is whether or not the items at issue and that are under dispute were purchased for the purpose of resale. And with respect to the purpose of resale, what we mean when we say that is whether or not the purchasers at the time of the transactions intended to resell them, and whether or not Jantex, the petitioner in this case, understood that the items were for resale and acted in good faith in that regard. And if you do conclude that, we believe that you should grant the petition. The petitioner, Jantex Inc. and Beyond, is a manufacturer, retailer, and wholesaler of ink and textile-related products. There was an audit performed for the period of 2008 through 2010. This was their first audit. Now, the audit department conducted a test of the exempt sales for the month of October 2010. There were approximately 250 transactions that were reviewed under that test. At this point, there's 13 purchasers that remain in the test, and we're contesting transactions related to 7 of those purchasers. Now, during the audit period, the practice of the business as it pertained to sales for resale was when there was a new customer that was set up, an order was placed, the standard practice was to simply send out an invoice with tax charged on the invoice. If the customer thereafter came back and explained that the items were for resale, they would at that time request a resale certificate, remove the tax from the invoice, and go forward without charging tax. Now, this was their first audit, and during the audit period and periods preceding the audit period, they would accept seller's permits as a resale certificate. And for the 7 purchasers at issue here, there's 4 of them that provided seller's permits as resale certificates. Now, all of the 7 purchasers that we're addressing did provide a timely resale certificate or a timely seller's permit, which we believe demonstrates and supports the petitioner's claim that at the time of the transactions, or really prior to the time of the tested transactions, their customers represented to them that these items were for resale. And they provided the resale certificate, or they provided the seller's permit to support that these items were purchased for the purpose of resale. And that under the circumstances, because the customers were in the business of selling these sorts of items, they were in the printing industry, that these were accepted in good faith. Now, upon audit, these 7 purchasers were questioned in the audit because there was some fault in the resale certificate, or at least in the department's opinion, there was some fault in the resale certificates, or the seller's permits were accepted as resale certificates and therefore didn't contain all of the elements of a standard certificate. So the auditor had XYZ letters that were sent out. And I should add that all of these documents are before you as Exhibits 1 through 7. And then there's a summary of those exhibits titled Summary of Disputed Transactions and Exhibits, which summarizes the documents that were provided by each purchaser at issue. In any event, the auditor had the XYZ letters sent out, and each of the purchasers responded that these items were purchased for the purpose of resale. There was one purchaser that did not, and that's Moda Industry. That's under Exhibit 4. But Moda Industry provided a valid resale certificate in 2007, well before the transactions at issue, and that resale certificate was not revoked in writing prior to the transactions at issue. So in summary, we have a situation where the policy in place was to charge tax unless the customers represented that the items were for resale. In this scenario, that's what happened. All of the customers provided either a resale certificate or a seller's permit to confirm their purpose of the purchase. And then upon audit, we have XYZ letters that are signed by the purchasers that confirm what the seller's understanding was, confirm what the purchaser's intent was at the time of the transactions, which was that these items are being purchased for resale. If that representation wasn't made, then ultimately Jantex charges tax, and apparently we're not going to have a problem. So under the circumstances, we think that the fair thing to do is to hold the purchasers responsible for the tax. And the law provides an avenue for that path here. In particular, Revenue and Taxation Code Section 6244A provides that where a purchaser issues a resale certificate, or in that law section is very important. It's not only where a resale certificate is provided. So where a resale certificate is provided or the items are purchased for the purpose of resale. And it says that if the purchaser subsequently uses those items, then the purchaser owes tax at the time of the use. Now, Regulation 1668 that addresses sales for resale also provides authority that is supportive of the petitioner's case. In particular, under subdivision F of 1668, it says that the seller may use any verifiable method of establishing that it should be relieved of the tax liability. And it provides an XYZ letter as being a particular option. Now, F3, subdivision F3 goes on to state that a purchaser responding affirmatively that the items were for resale will be regarded as confirming the seller's belief that a sale was for resale as it pertains to subdivision G. Now, when you go to subdivision G addresses the purchaser's obligation for the tax when they purchase an item under a resale certificate or for the purpose of resale. In essence, it echoes 6244A. And subdivision G says that a purchaser who issues a resale certificate or purchases for resale is liable for use tax if used. And it says that the tax is due at the time the property is first used and must be reported and paid by the purchaser. There's also a board memorandum opinion that allows for the purchaser to be held responsible under these circumstances. Under Edward Spurlock, the board considered a case where the purchaser issued a certificate to a seller. It didn't contain a description of the property to be purchased. It didn't contain a signature of the purchaser. It didn't contain the name of the seller or a signature of the purchaser. In that case, there was no XYZ letter that was provided by the purchaser that confirmed the purchaser purchased the goods for resale. So in other words, the evidence in that case was less than the evidence that we have in this case. Nonetheless, the board ruled that under 6244A, because the purchaser represented to the seller that the goods were purchased for the purpose of resale, that it owed the tax. And we believe that the same result is appropriate here. Now, part of the board's mission is to administer the tax fairly. And in this case, we have a situation where my client, Jantex, acted in good faith. They relied upon their purchaser's representation that these goods were purchased for resale. And they're not just saying that. There's documentation that really leaves nothing to the imagination. The purchaser themselves have signed documentation during the audit period that corroborates the seller's permits, that corroborates the resale certificates that were provided prior to the transactions. So I think it's abundantly clear that the purchasers understood that these items were for resale. And under those circumstances, we think the tax is more properly placed with the purchaser. We believe that's the equitable thing to do. We think that's the fair thing to do. We think the law fully supports that course of action. And for that reason, we ask that this board grant the petition. Thank you.
Thank you very much. Members, let us go to the department. The department has 10 minutes to make their presentation. We'd ask that you introduce yourself for the record and then commence at your convenience.
Thank you. Good morning, Chairman, members. Monica Silva, and with me, Robert Tucker and Kevin Hanks, representing the department today. Staff agrees with the recommendation of the Appeals Division in this matter. Contrary to petitioner's argument, no further adjustments are warranted to the disallowed claimed non-taxable sales for resale. Petitioner did not obtain proper resale certificates to be relieved from liability for the sales tax, and after review of each of the sales and additional evidence, none of the remaining sales at issues were in fact sales for resale. As the board is aware, the law imposes sales tax on a retailer's retail sales in the state of tangible personal property, unless the sale is specifically exempt or excluded from taxation by statute. A retailer's gross receipts from the sale of tangible personal property are presumed to be taxable unless the retailer, timely and in good faith, takes the certificate in the proper form from the purchaser to the effect that the property is being purchased for resale. Where a retailer does not secure a timely, valid resale certificate, the retailer can be relieved of liability for the tax, but only if the retailer can show that the property was in fact resold without any intervening use, or the property is actually being held for resale by the purchaser without any intervening use, or the purchaser consumed the property and paid tax to the board. One method that the board does provide to assist a seller in satisfying its burden is the use of the XYZ letter. The XYZ letters are in a form approved by the board, which are sent to some or all of the seller's purchasers, asking as to the purchaser's disposition of the items purchased from the seller. It's important to note, however, that Regulation 1668 provides that a response to an XYZ letter is not equivalent to a timely and valid resale certificate and does not require relief from the seller's liability for tax. In this case, the department used an agreed-upon test period and examined 264 of petitioners' claimed exempt sales for resale that were not supported by valid resale certificates. The department worked with petitioner to send XYZ letters to its customers and to gather supporting documentation to establish that these transactions were in fact non-taxable sales for resale. After evaluating the XYZ letter responses and other supporting documentation, the department disallowed 50 of the 264 transactions. Of those 50, 25 were removed in a recent re-audit as in fact purchases for resale. So while petitioner was able to show that the vast majority of the transactions were in fact sales for resale, there remain 25 transactions for which ultimately petitioner has been unable to meet its burden. Of those 25 transactions, 7 had invalid resale certificates on file. But I note that of those 7, 4 of the purchasers said in their response to the XYZ letters that they purchased the property for their own use and not for resale. The bulk of the remaining liability consists of sales of JetCoal 2000 transfer paper. Transfer paper is a product used by printers to transfer a design to another surface. After the transfer is completed, the paper is discarded. While petitioner did obtain XYZ letter responses from customers, some responses were marked purchased for their own use, and the department contacted other purchasers in order to verify the XYZ letter responses and found that for those transactions, the items had not in fact been resold. The department confirmed that the purchasers were printers. Printers consume transfer paper, so the department correctly determined that the paper was not in fact purchased for resale. The same applies for the remaining transactions at issue that were not in fact sales for resale. Petitioner mentions Board Memorandum Opinion Spurlock. That memorandum opinion stands for the proposition that a buyer cannot issue a resale certificate to the seller and then deny the validity of the resale certificate. There's no discussion of relieving the seller's tax liability. This case involves a sales tax transaction. Therefore, since petitioner has not met its burden, the remaining 25 claims sales for resale were properly disallowed, and as appeals has recommended, the petition and claims for refund should be denied, and petitioner's liability should be redetermined without further adjustments.
Thank you. On rebuttal, please.
Thank you. The department's focus in this case is really on the technical nature of the resale certificates. And that's why I emphasized the word "or" under 6244A. Now, if you look at Regulation 1668, subdivision G, it says the same thing. It says that where a purchaser issues a resale certificate or purchases goods for the purpose of resale and then subsequently uses those items, so it contemplates this exact scenario. If it subsequently uses those items, then the purchaser owes the tax. So there's no question that the purchasers absolutely can be held responsible for the tax. Now, were there some technical deficiencies in the documentation that was received by the taxpayer? Yes, there were. And in some cases, there weren't any documents received, and we're not contesting those transactions. But in the transactions that we are contesting, there was a representation that these goods were purchased for resale. And the customers presented resale certificates or seller's permits that were accepted as resale certificates to confirm that. And Jantex relied in good faith on that representation, which is typically the case when you're trying to sell somebody something. You're not going to call them a liar or call into question the purpose of their use of the goods. And then after that fact, and in some cases, 9 years after a resale certificate was provided, an XYZ letter was sent out that addresses the particular transactions that are at issue. And all of the purchasers, with the exception of one, responded that these were purchased for resale. Now, the one exception is Moda Industry. It's under Exhibit 4. And in that case, it provided a resale certificate that we believe is without fault. The department says that there's no description of the property included on that certificate, so therefore it's invalid. But if you read the top of the certificate, it says this: unless this certificate is marked below as single purchase certificate, it shall be considered part of any order given to you and shall remain in force until revoked by written notice to you. So it says it shall be part of any order given to you. It's signed by the owner. The XYZ letter is also signed by the owner that says that the purchase is taxable. Well, the law says, and this certificate actually says on it, that a certificate remains in effect until it's revoked in writing. In this case, the certificate was not revoked in writing, and we believe the petitioners reasonably and in good faith relied upon it. At the end of the day, we don't think the purchasers acted in bad faith, necessarily. And aside from what the department said, it's my understanding that, in fact, some of these goods were resold. The majority of the items at issue was jet-cooled paper, and a lot of these purchasers, by my understanding, would print images on it. It would cut the paper into a smaller portion than the large roll that's purchased, and then print it to somebody else that would then transfer the ink to the fabric, and they would transfer the title and possession of the paper. But at the end of the day, even if the purchasers consume these items, the law provides a path to hold them responsible because they conveyed to the seller, to Jantex, that these items were for resale. Jantex reasonably relied upon that representation. There's evidence to support it. There's no question that was the purchaser's intent in light of the evidence. And we believe that the proper path is to hold the purchaser responsible for any liability that may exist and to grant the petition. Thank you, and we'll take any questions that you have.
Thank you very much, you both, for your presentation today. Discussion members? Member Harkey.
I'll lead off, but I may come back because I've asked for a couple sections. Okay. For the department, I'm sure you have this printout exhibit
Yes, we received it this morning.
Okay, now I've reviewed all of these items, and I did notice that MODA said that they had not, that they should have been taxable, but they were the ones that did have the timely resale certificate, because this listing says timely seller's permit, timely resale certificate after the fact, means that that Jantex actually went back and got them, probably as a part of performing audit due diligence after the fact. And then there's XYZ letters. So all of the XYZ letters, except for MODA, came back that, yeah, we're resale. And then, as I understand it, there were phone calls made on each XYZ letter.
Correct.
Is that usual practice?
Yes, that is usual practice.
I'm told by my district principal auditor that now works for me that's not.
I think it depends on what the XYZ letter says and what the product is, because it may be something right off the bat that the auditor can tell, oh, yes, that would be something that would be sold for resale. Yes, that's a person who would purchase it. Maybe Kevin can give you the more details. I probably...
Okay, but I know that the seller's permit is not a resale certificate. I understand that. But
Correct.
Given it was a first audit, they had the seller's permit. They went back in all except CAD Fabulous. They went back and got the resale certificate after the fact to confirm that they were resale items. And then the XYZ letters came back confirming. So I think that it's pretty apparent from my read of this that they were under the assumption, and they were being told, and we were told 3 times by the verifications here, that yes, in fact, these things were for resale. So shouldn't we be going after those that are selling after lying about resale?
I think one of the problems, Ms. Harkey, is that this transfer paper is not incorporated into the product resold. And that's what would have triggered staff's, and Kevin can go into it in more detail, but that would have triggered staff's inquiry after receipt of the XYZ letter. Because it's not actually incorporated into that product that's resold, and the petitioner would have been in the best position to know that as a seller of the property.
Well, they sell a lot of printing supplies or print equipment, so to speak. And this was a roll. These are rolls of paper that, as I understand it, the purchaser could put their print on it.
Correct.
And then sell. They could sell the print to be used elsewhere. And I'm getting yeses over here. And so I think that's where we're getting into for resale or not. Because if you're telling me that you're going to sell for resale, yeah, because this is a piece of paper, and you can either put your print on it, as I understand it, and use it on your own materials, your own design, your own product, or you can sell your prints more in bulk to be used elsewhere. And I think that's what they're claiming, is that the prints were that the paper was bought on a big roll, and in fact, all of these various clients said that yes, it was for resale, except that maybe when they got pushed by the BOE on the telephone, they got a little frightened. But I think they had verification here that it was for resale. I think I understand the process, that this was a roll of paper or what, and it was subsequently, reduced in size and pieces and maybe sold off as prints that could go elsewhere. And to the extent that MODA did not do that, I would think that MODA should be responsible to pay the tax. So if it weren't a first audit, and I really thought games were going on here, I'd be really inclined to, because you did a lot of work and you gave a lot of credit. You really did. I appreciate it. But I've still got some problems here with some of these. And I asked for section, let me see, what is it? Resale certificate, sales and use tax, regulation 1668G. and I do have it in here, the board is not required to relieve a seller from liability sales tax collection based on a response to an XYZ letter. The board may, in its discretion, verify the information provided, which you did, including making additional contact to determine whether the purchases were for resale or whatnot. When the board accepts the purchaser's response to an XYZ letter as a valid response, the board shall relieve the seller of liability for sales or use tax collection. So that would tend to me to say that, you know, you got the letter, came back saying that this was for resale, and then you verified and found out that whoever signed the letter really wasn't telling the truth. And I would think they should be more responsible. We did have one XYZ letter that came back that they checked that they had paid the taxes in the section that says, yes, part of this was for resale, we paid the taxes. And then there was another one, MODA, that said, no, this was, you know, totally should have been taxable. So I think there's, I think that there's a variety of ways to prove up what they're trying to do, and I think because it is a first audit, they certainly showed cooperation in providing all of this information, going back to their customers, asking for the resale certificates and all of that. So I will let this kind of go here, and if I have questions, I'll ask, but I've been digging into this because it's a little bit complex if you don't understand the processes. And that was the big thing that I had to fully understand. To me was the process is, do you sell a roll? And yes, you sell a roll. So what happens then? Is it used in the production? It could be or not. You could sell a design on a piece of paper. You could sell those by volume. So yes, you seem like you want to.
I think that's just contrary to our understanding. And generally when sales are made to printers and printers of apparel, we're not aware that they're selling off designs or they're piecemealing this transfer paper and then selling it off in that fashion.
That was a new piece of information to me. I've never heard that.
Okay.
Now, certainly it could happen.
Right.
I could understand, you know, in my
I know it was
in my new understanding of printing, that certainly that makes sense. That could happen. But in these cases, the auditor would have confirmed if in fact that happened. What he confirmed was that these were being used to transfer ink onto items. Because it would have been a whole nother ballgame if it was the other way.
Right, which is why we're here. So that was the way I understood the process. So if I can go back to the appellants.
Yeah, I'm going to actually allow my clients to answer that because they're the experts in the room on this process. But I would just say this, that we don't know what the auditor said or what the customers said. We weren't privy to those discussions. So we don't know how those discussions played out. There's very small comments about the size of a silver dollar on the XYZ letters that comprise what was discussed. So it's difficult for us to say what was discussed. What we do know is that we have documents that were signed by the purchasers. So signed documents that say these were for resale. And as it pertains to how these products actually were used or if they were resold, what was explained to me, and you guys can add where I leave out, that these are sold in bulk, they're sold in rolls, and that in some instances there would be a printing that goes onto the paper.
Correct.
And then cut and then sold to another that would then
Transfer it onto the garment or to the piece of fabric. Let
So-
me just say, in the very end of all this, let's just say that the piece they print on paper gets sold to somebody else. They put it on the, let's say, T-shirt for this sake. Goes to the store, you're getting your tax. I mean, it's not like you're not getting something. At the end, you are. But needless to say, our customers told us they were reselling. We have about 200 customers. We don't know what they all do. This is a process. It could go many directions. We do go on site. We do see them. We do see them do this. So at what point do we have to be the judge and jury? The auditor certainly didn't help us in this. All they kept doing is stomping us, stomping us, stomping us. We're just a small business. We were doing everything we could to help. And all we were getting, well, that's interpretation of the law.
Okay, what I really want to stick on, I understand how you feel. You've been through a lot, and I believe me, and I'm trying to help you here. So
I understand.
can you explain the what I understood was the process of selling the roll,
Uh-huh.
and then what happens then? Who buys the roll?
We sell the roll to a customer that has large format printers, and then they will print onto the roll. Sometimes they sell the whole roll after being printed, sometimes they cut it, and they sell it to another party that really does the fabric side of this. It's all
Okay.
textile. Generally speaking, that's how it goes.
Okay, so that's a sale. It's not a finished good. It's a sale for a resale.
That is correct. There's some, I guess, like Moda, that maybe they did the whole process.
Right.
But for the most part, what you just said is correct.
Okay. So, Department,
Harkey, if
did
I
you
could-
understand that?
Right. I think what the petitioner was saying, though, is that Moda was doing the entire process.
Right.
And so our understanding of the transaction is that the paper was sold to Moda. They were using it in their manufacturing process to transfer ink onto this paper and then onto the products that got sold. But in the process, you're actually consuming that paper, so that paper gets discarded after it's been used and after the ink has been transferred to it and then transferred to the garment that's sold. And so Moda would be the consumer of that property. They wouldn't be the reseller of that property.
Right.
And that's what our auditor was trying to establish.
In the case of Moda, I agree with you. But the only thing I'll say about Moda is they did provide timely resale certificates. They did have them for Moda. So I think I agree with you on Moda, that Moda was a sale. It was consumed. The rest of these, Major Textile, CAD Fabulous, AMA, Sublimination Factory, those were where you would put the print and then sell the prints. Those weren't actually consumed in the process. They did an additive process, as I understand it, to the paper that they purchased.
I'm sorry, Ms. Harkey, I'm not certain that I understood or heard your entire
That's okay.
question, but we're discussing one other element here. It dawns on us that if these are new descriptions of how this property is used, and so I'm wondering whether or not a 30-30-30 decision might be best for everyone, so we could go back to the purchasers and determine exactly how they use this property, because we've never heard that this property may have been resold by these purchasers. It was our understanding always, based on the AutoWork paper comments, that these folks are consuming the paper and the other supplies that are in question today. So we'd be happy to take another look at it, try and confirm, if this is indeed happening. Because we don't want to be in a position either of taxing anything that was ultimately resold to another party.
Well, my concern is that I think they've been through a lot. I'm not going to discount that, but I think they've been through a lot here, and we're down to kind of the last few. One more question. Your assertion that the product is not one to be resold, why would you then send an XYZ letter? Why would you bother to send one?
The staff sent an XYZ letter statement because in many of the instances we didn't have complete resale certificates on file. For instance, some of the resale certificates we're talking about this morning were incomplete, or they didn't identify what property they wanted to purchase for resale. So in that instance, Regulation 1668 suggests that we assist the sellers through this XYZ letter process to determine more information regarding how the property was either consumed or resold. And so that's why the audit staff suggested to the sellers that they send the XYZ letters to customers.
Yeah, I wanted to go through this thoroughly because I wanted to be sure that the department understood the case as I understand it, and it's got explained to me, because I was confused too. I was very confused. I had to have this all explained as to what is the process that this would be for resale? How would it not be consumed? And this is the explanation, and I think you heard the appellant verify that they sell the rolls. So I will stop at this point and let somebody else have some. But thank you very much.
Thank you.
Thank you.
Member Stowar.
Just real quick, The notion that it was for resale, I kind of think a 30-30-30 would be in order. I don't want to have to put the petitioners through it, but it sounds like the department will be contacting their customers, so it wouldn't be any burden placed on the petitioners. I'm looking at some of the purchasers' website, and just by the website alone, it looks like they're actually using it. I don't want to really make that assumption without further verification. It seems it may be a combination of resale and a combination of what they're actually using, and I'm thinking that the 30-30-30 would verify that. With respect to motor industry, Department, can you clarify, we have a timely resale certificate?
It's timely, but it's not valid.
Can you explain to me why you believe that?
It's missing the description that's required by Regulation 1668. The description piece is missing. And also, there are other parts of the I engage in the business of, that's missing. The list of products. When I say description, I meant the list of products is missing. Some other lines above, I'm engaged in the business of, that's missing. It's not completely filled out, so it's not considered a valid resale certificate.
So just checking the box as a blanket certificate is not sufficient?
No, not under the regulation.
Thank you.
Member Runner.
Yeah, let me kind of, it's always interesting to try to go to a 30-30-30 and get some more information, but I just want to kind of identify how necessary that is in this case. Let me just, number one, how many transactions did we start with?
290.
And how many are we down to?
264, and we're down to 25.
Okay. I'm a little concerned that we started with that many, and now, and therefore, the taxpayer has approved their case, or they've one way, or I guess some approved their case, some of they have identified as tax paid. Is that a fair description? They've kind of split, or has the taxpayer? Let me ask the taxpayer, of those cases, how many of those did you end up identifying a tax due versus how many of them then were?
Well, we've actually broken it down by purchaser because that's really what we see as being the relevant question. So there's 13 purchasers that remain, and we're contesting 7. So there's 6 where we concede that there were errors that were made in making sales.
So those 292 or 206, I'm sorry, 200 what?
64.
264 were of 13 purchasers?
No. So that would have been probably hundreds of purchasers.
And did you concede any of those?
Those were accepted as being valid.
Okay, that's my question. So of those, all those, the vast majority have been accepted as valid. Is that a fair
Yes.
summary?
Yes.
Okay. So now we're down to these last few contested.
Correct.
Okay. The point I'm making here is I'm a little concerned that we're trying to go back to what the auditor meant to do when the auditor apparently missed a lot of stuff. Am I missing that?
Yes.
Am I? Okay, help me understand that then.
The problem was there wasn't sufficient documentation to support these sales for resale, so we had to use extraordinary methods to do so. Had the petitioner maintained valid,
so the XYZ
timely
letters and whatnot were used then to help
Correct.
justify. Okay, that's fine then.
So that was.
Can I just add something there?
Hang on just a minute.
Okay.
Let me go somewhere else in a different direction here on this. Let me just ask, part of the reason I'm concerned about going to a 30-30-30 on this issue is that we did the XYZ letter. And the XYZ letter came back, and these individuals then said, hey, look, the customer said, yes, these are for resale. I'm a little concerned now about going, because again, I don't know, the only way I think we're going to go to a 30, or it seems to me the only option we have in a 30-30-30 is you're going to go back to these customers again.
Correct.
Ask them a question that I believe we should have asked them the first time. And that is, did you actually sell this paper? To me, that would have been a pretty fundamental question to ask them the first time. And now all of a sudden we even have more time that passes. And so I'm a little concerned about then going ahead and kind of trying to correct the record, if you will, after all this time has been asked, when we should have asked that question in the first time. I understand that you're telling me right now that this is the first time that you've heard that sometime this transfer paper would actually be sold to another consumer. It seems to me that would be a basic issue that the original auditor should have identified. And so let me go back to the taxpayer again, just to clarify. What would happen with this transfer paper is this transfer paper would be bought by the retailer,
Correct.
and the retailer would then use it,
Print it.
but then would resell that.
Correct. Into somebody that did the fabric side, then to sell it to such as a retail store.
It seemed to me that would be such a basic part of the audit that I just don't understand.
There were actually a couple transactions, at least that I can recall, where we did allow the transaction because the purchaser did say they resold the transfer paper.
Well, but
So
the
I mean-
XYZ letter says many of them said they were for resale.
And they resell it.
In the XYZ letter, a number of these said that it was for resale.
No, when we followed up on the XYZ letters for the transfer paper, there were purchasers, while they said they resold it, our auditor must have asked the question, did you actually resell it? This is transfer paper, and the sellers did say they resold it because we did allow, I can think at least one or two, where we did allow the sale for resale because the
Right.
purchaser said they resold the paper.
But what I'm trying to figure out here is that in some of these follow-up, the XYZ letter, they said it was for resale. And again, apparently, in the follow-up from the auditor, they called them up and said, hey, look, you said this is for resale. Was it really for resale? Right?
Yes.
And then the
verify.
answer must have been no, or must have been no, because then we chose to go ahead and apply the tax.
Except for in the instances where they
Except-
said yes and described that they had resold it, in which case the auditor allowed them.
Yeah, see, and this is sometimes our challenge when we're sitting here and we don't have the auditor with us. Because we're right now thinking about what the auditor probably asked, right? We don't really know what the auditor asked.
Oh, Mr. Renner.
Do we?
I think we do. I mean, we can make an inference.
You were aware of those exact conversations?
I didn't sit with the auditor when he made the telephone calls.
Right.
That's
Have you
correct.
talked to the auditor in regards to this case?
Well, I'm just.
Have you talked to the
reflecting-
auditor in regards to this case?
No.
Oh, well, then how in the world? I appreciate that you may think you know what the auditor says. You may even know what it is that our processes and procedures should be. But the fact is, you don't know, and you have not talked to the auditor.
Ms. Silva explained to us, though, that the auditor was asking questions of the purchasers, asking
We don't know what those
how they used that product.
Again.
I mean, it looks like we've made a couple of allowances. So I would think that would be fundamental to what the auditor was asking.
But we don't know if the auditor asked this really specific question, and that is, were these transfer papers resold? Right? Do we know if the auditor asked that question?
I haven't talked to the auditor to be able to respond to that, but.
Well, if he
the
did ask
base-
that question and the answer was yes, then it would have been removed, right?
Correct.
Okay.
And some were.
And some
Yeah.
were.
Right.
I mean, we worked
Well,
down a lot of
and
these
some
transactions.
were based upon
because
our
there were
conversations
no-
with the auditor?
Based on the auditor's conversation, pardon me, we know that the auditor, following up on the XYZ responses, determined that the transfer paper was actually resold in a couple at least, circumstances, which would imply that the question was asked.
And was that question asked as a result of the XYZ letter?
Yes. And that, going back to Ms. Harkey earlier, that's the whole point of the XYZ
See,
letter.
here's what my concern is. Again, I don't know what to do exactly when we go through this process. We send out an XYZ letter, they answer the XYZ letter, then we go back and say, did you do your XYZ letter correct to the retailer? I don't know about you, but my concern is when the BOE calls a retailer, okay, and the retailer is trying to think, man, are they trying to stick me with this tax, or are they trying to stick somebody else with this tax? I'm concerned about how relevant that answer really is when we're trying to, again, question, because we're basically questioning their answer when we call them. And I just think that puts that retailer in a very defensive posture, because they're trying to figure out, man, the last thing I want to do is be responsible for this tax. I guess I really don't care if my supplier is responsible for this tax, but I know I don't want to be. And I just am concerned then with that follow-up and then the pressure that puts on then that retailer. So anyhow, I'm concerned about that, and that's why I'm especially then concerned about going to a 30-30-30 where we go back once again to these retailers. and start asking them some more questions. The other issue I want to talk a little bit about is the MOTA issue, and that is, I'm just concerned at what point then, and I understand that it was a partially filled out certificate, but I think at times, in my opinion, it becomes a pretty gray. Well, let me ask the taxpayer. As you get a reseller certificate, what do you believe your role and responsibility is to make sure that this description is absolutely correct for that description? What do you see your role and responsibility there?
I'll let Opal answer.
Okay.
Prior to the audit, I would say our responsibility was in just accepting whatever they provided to us initially. Because up to that point when we were audited, we didn't have a real good understanding of what the difference between an actual resale form was, which is what the state required, and what a resale permit was. And when we accepted resale permits as face value of having the ability to resell your products, that was as far as we went. But since the audit, we learned a lot in regards to how much information needs to be required from the purchaser. And we've done what we feel is our due diligence to really require all of that information.
So prior to the audit, your understanding was, hey, they present us a resale certificate, it's on them.
So they're saying that, you're right,
it's on
they're
them
buying
to
for
demonstrate,
resale. Correct.
if they're audited, that they indeed.
But I also want to add that that resale form in itself sometimes is even a little confusing. And we've had a lot of customers check the wrong box that we've had to question, well, why are you saying, because this means you're taxable? And they're like, no. So even the form, I think, was a little confusing.
Yeah. And I think that's the challenge that sometimes we face, and that is those who live in this world, think they understand and are asking the right question. But again, and I appreciated the description of your jobs, because I think this is the reality. The reality is business
in a
people,
small business.
a lot of business people,
Exactly.
they are not only filling out the tax forms, but they're also cleaning the bathrooms. They're also doing all those other things. And so it becomes one of what is our true expertise, and our expertise is not necessily.
But may I also ask a question?
Well, hang on just a minute. So then it comes to me to be the issue of the intention then of the seller. Was the retailer really trying to pull one over on the state, or was this just plain old trying to do business and we just got caught up in something that was unclear, and we tried to do our best in the process? I'm sorry, what were you going to say?
Well, when the board was speaking, they kept mentioning the auditor. He said, he did, he this. But the auditor was a woman, and to our understanding, retired before our audit was complete, and we never met another auditor beyond that point.
Let me just ask one follow-up question of the staff, because I'm a bit concerned in terms of process here. And it was to one of the answers. When we get an appeal, and it's coming all the way through here, we've gone through all the processes and whatnot, I'm a little stunned that we haven't gone back and had some conversation with the auditor. Is that because the auditor was not available to us?
Mr. Renner, I don't know if there was a need necessarily for us to communicate with the auditor, because
you don't think this was a dispute?
Oftentimes, the audit work papers speak for themselves, and any questions that we have are actually answered just by our review.
Well, let me give you some advice at this point then. When we come to a hearing, and you guys may think this is all wrapped up and easy to understand, it's not your opinion in regards that you're trying to make, who you're trying to convince, it's us. And I would suggest that if you think there's still something at dispute that you think would help make your argument, that it would be wise for you to go back and check with the auditor to clarify the questions, regardless of how clear you think it is.
Mr. Renner, we frequently contact the district staff, the district principal auditors, the auditors, unless they're retired from state service or whatever the situation might be. If we've got fundamental questions regarding what transactions, were deemed to be taxable, which ones that they've scheduled in their audit work papers. We certainly contact them. We ask them questions.
But in this case, you didn't.
In
right?
this case, it was our understanding that the purchasers were using the contact paper and that they weren't reselling the contact paper. So we weren't in a position to
Well, all these
to
weren't
go
about the
back to
contact paper,
auditor.
right? All these disputes are not about the contact paper.
A lot of them
A
are.
lot of them are, but not all of them.
We've got other consumable type
Right.
supplies that were sold that are in contention
Right.
today. And I think what that raises in my mind actually is I can empathize with the challenge posed by the taxpayer, in trying to determine what resale certificates they need to have on file. I think this was certainly an educational experience for them to find out if they're making sales to people that might be consuming these products, that they have to have specific resale certificates to cover those resale transactions. Just providing a copy of a seller's permit, for instance, that you've got in your records isn't sufficient to exempt these sales. And I think fundamentally that was part of the challenge posed by the audit staff, was to determine, just with the seller's permit, was this in fact
Again, let me
a sale for
just end with this, and that is, as you guys are presenting cases, honestly, I think your best response is, we probably should review our ability to go back and communicate to our auditors. That would be your best answer. The ongoing justification doesn't help me, and it doesn't help you. Thanks.
First, let me share. I have been, I've worked for the board for some 22 years and served as an auditor for a number of those years. In review of the audit working papers, it's clear that the auditor, well, first, the testing that the auditor has done is just normal. It's not extraordinary as provided by the department. It is normal. In the case of the law simply says that it has to be a resale in fact, and so the presumption is that it's taxable until proven otherwise. The law goes one step further to try to protect the taxpayer, to say that you can rebut that presumption. You can, if you receive a valid resale certificate. And so in the case of Modem, the resale certificate was not a valid resale certificate. And so when the auditor is faced with a resale certificate that's not valid, then they're required by the Field Audit Manual and the directions they've received over the years they've been serving, they're required to go to the next step. It's not extraordinary, it is a requirement. The next step is to issue an XYZ letter. And in issuing the XYZ letter, or third-party confirmation, if it comes back, the law specifically says that they don't have to accept that XYZ letter if there is evidence that it's not a resale in fact. Each one of these transactions were sales to individuals who sold fabric and textile. So in this case, you're not selling it to someone who could actually resell it. So the presumption of the auditor, as indicated by the description of why he denied these sales for resale, the presumption is that you're selling it to a person that can't resell it. As if though I was a car dealer and I sold a car to a company that doesn't have a license to sell cars. That is enough of a presumption for the auditor to take the next steps in the process. And that's simply what the auditor did. It's clearly described in the audit comments, and it's appropriate. It's in the Field Audit Manual. They did the right thing. I understand the confusion, and I appreciate that there isn't a penalty associated with this, because if it was, I would be supportive of removing that penalty, because there's a confusion here. And certainly after being in business for a number of years, I would hope that that confusion is cleared up. I understand the confusion of my colleagues, but the law is relatively clear. And the Field Audit Manual is clear. And the audit itself is clear. And the resale certificate is missing the information. Even if you had a resale certificate that was completely blank, totally wrong, and it was a valid sale for resale, the department would have to allow it, because the law says it's a resale in fact. So the determining factor is not the resale certificate. The determining factor is what actually happened, the reality. And as much as I appreciate the hypothetical that's been injected into this, in the request for a 30-30-30, I don't think it's necessary because it's a hypothetical that leads us into the weeds. Because the reality is, these are all fabric and textile manufacturers. You can Google them all. They'll tell you what they do with this stuff. They'll tell you they don't resell it. Just go on the website and Google it. I don't see the need for a 30-30-30, but as a courtesy, I would be supportive of that, but I think we're just prolonging the inevitable and the reality, and I think, clear testimony. So it's unfortunate, though. It's unfortunate. It's a confusing law in some cases. I hear the department hinge on this sell for resale, the resale certificate, as opposed to resale in fact. And we have to focus on whether or not it was a resale in fact. If I go into a toy manufacturer, and the toy manufacturer is selling toys to a toy store, and the resale certificate is blank, they don't even have one, I'm required under the law to accept that. If you send out an XYZ letter and the XYZ letter says, it wasn't for resale, I'm still required to accept it. If I call them up and they say, hey, I resold it. I'm a toy store. I bought from a toy manufacturer and I resold it. They told the department that. The department still couldn't accept it, and they have to say that it's a sell for resale and allow it. So these documents, this form over substance, I think if we focus on the essence of the law, we'll be able to get this right. And we'll be able to provide the taxpayer with some guidance that they can use in the future in order to make sure that they minimize their tax liability. Because it's always a burden to have an auditor come in 3 years subsequent to a transaction and say, you owe this tax. And now the real unfortunate thing is, it's so difficult to go back because it's a percentage of error. It's a projection of a test. So you don't even know who to go back to in order to recoup the tax. And that's and that's disheartening to me, but unfortunately it's one of the realities of the laws of the state of California. Mr. McCone.
And thank you, Mr. Chairman, for the opportunity to respond. And I don't know that I'm going to convince you otherwise, but I'm going to give it a quick shot. Really what you're focusing on is the portion of the law that says that where a resale certificate is provided. But then after that, there's the word or. And then it says purchase for the purpose of resale. And it doesn't say we'll accept it if it's purchased for the purpose of resale and it's in fact resold. That's not what the law says. The law says if it's purchased for the purpose of resale and then subsequently used as you suggest that it was, I don't know that we're sure that all of this was used. I don't think it was based on my client's understanding. But even if it was, what the law says is that if it's used and it was purchased for the purpose of resale and it was represented to the seller that it was for resale, and they relied on that representation in good faith, what caused the tax not to be charged? Well, it was the purchaser's representation. So the law says that under those circumstances, the purchaser pays the tax. And I think that's the just result, and I think it's fully supported by the law. There's not just one avenue here. I understand the avenue that you explained, but I don't think that's the only avenue.
Well, let me explain that avenue. The or refers to the liability of the purchaser, that
Yes.
the purchaser has these responsibilities. And that shifts the liability to the purchaser.
Right.
The first, and it's a condition subsequent, which is indicative of any law when you say this happens, or it's a condition subsequent. So the condition that has to be met first in order to rebut the presumption is the receipt of a valid resale certificate. That's the first thing that has to occur. Then it says or, which refers to the liability of the purchaser. The purchaser will incur a certain liability. Now, and so, the purchaser could have, and in this case, may have fraudulently represented themselves in this case, but, the auditor looks at this and says, no resale certificate, sold to an individual that could not resell it, And that distinguishing factor is difficult for an auditor to do. In fact, it's much easier for the appellant to make that call than it is for the auditor. And the reliance of the law is that the appellant will make the call, and when they don't, the unfortunate part of it is, and don't have the resale certificates, which is the only thing that can really relieve the seller. And so in order for the board to transfer the liability to the purchaser and now say the purchaser's liable, the purchaser has to issue this certificate and make that fraudulent act of filling out a valid resale certificate, valid, means completely fill out full description, what they're going to purchase, their resale certificate, and so forth and so on. That is the act. That is the act referred to in the OR that shifts the burden to the purchaser. That hasn't happened.
I guess probably my best course of action at this point is to agree to disagree. And I would just
Okay.
say that the Edward Spurlock decision is inconsistent. That published memorandum is inconsistent with what you're saying because
Well, I
there's not a
think the
complete and valid
Spurlock decision is very consistent, and it's a decision that has been applied by the courts, been applied by the board for a number of years.
certificate's not complete.
The exact same way that I'm articulating.
Okay,
But anyway,
well,
let's
I
agree to
understand.
disagree.
Okay.
Let's go to appeals, and maybe, I'm only doing this just to sort of clarify this discussion and have them provide an understanding of, what the law says in this regard.
And if I might, Jeff Angija on behalf of appeals, if I might clarify and amplify on what you said, the Spurlock Authority and 6244A do put liability on a purchaser, but do not relieve the liability of the retailer. The retailer's liability under 6051, 6091, 6092 is to either get the resale certificate valid, timely, and in good faith, or prove a sale for resale in fact. And if that isn't done, they've got a sales tax liability. In addition to that, a user who purchases under a resale certificate that's defective or for the purpose of resale and then uses it is
I agree
added
with
to
that,
and
Les.
also on the hook. It's analogous to a predecessor and successor. The predecessor incurs a liability. Successor can get put on the hook also if they fail to get the tax clearance certificate. It doesn't relieve the predecessor's liability. It adds to it. And of course, the board will only collect that liability once, but nothing in those authorities negates the liability of a retailer who has a sales tax obligation.
And I would just add that, in essence, I agree with what Mr. Angie just said. And
Okay,
that's
we're good to go then. Member
Okay.
Harkey.
I would just like to state that I believe that we allow the XYZ letter to kind of complete the steps that the chairman just articulated. That's the purpose of an XYZ letter. And in this case, I mean, I understand under an audit, a first audit, that there were timely seller's permits rather than resale certificates, but the resale certificates were obtained after the fact. The XYZ letters all came back in the affirmative, except for MODA, which did have the timely resale certificate that may have had a section missing, and I understand maybe that's because we can't pursue without everything completed down to, it's a legal form of document, and we would use that to pursue. Is that the reason that that has to be so meticulously completed? I'm asking the department.
Reason why the regulation requires
Why
each of
the
elements?
resale certificate has to be, because you were saying MODA did not complete the resale certificate.
Right, as the regulation requires. The regulation requires that it be fully completed with the information.
Right, but if they had it and then they filled in the XYZ letter, said, yes, they're taxable, then why wouldn't we go after MODA for that tax? If they admitted on their XYZ letter that it was taxable, sold for resale, and they did not complete a certificate, wouldn't we have a case then to pursue MODA for the taxes?
Under these circumstances, they had not provided a timely and valid resale certificate. And because the retailer did not accept a timely and valid resale certificate, these were subject to sales tax. That's why the liability would be on.
Well, that's because they did have a resale certificate that was presented to them that they accepted. It just had a section that was not completed, as I understand the
Right, which
argument.
means it would not be valid.
It would not be valid. But then that's why we sent the XYZ letter.
In essence, to show that it was a resale in fact.
Right. So if MODA is admitted that, yeah, they were consuming these items, then they should really be on the hook for the tax. But you're saying we can't do that. Why?
The law is structured that the tax falls upon the retailer.
Well, I just,
If I might
Ms.
clarify.
Harkey, with your permission,
I'd like to chime in if I have an opportunity as well, please, on that.
Ms. Harkey?
Let's
Okay,
him and then.
so
sorry.
No.
the department is saying that the only path is to go after the seller. Mr. Angija just clarified that that's not the only path, and I've attempted to present this case that way, to say, look, there is a equitable path here. What's the fair thing to do? They reasonably relied on their purchaser's representation, and it's not just their word that we're relying on. We have documentation that goes well beyond the preponderance of evidence standard that shows that the purchasers represented to them these were for resale. It's corroborated by the XYZ letter. The XYZ letter is not only used to show that it was in fact resold, it can be used to demonstrate the intent of the purchaser at the time of the purchase, which goes to subdivision F3, which specifically references subdivision G, which is quote unquote the purchaser's liability. So it says that if a resale certificate, if an XYZ letter is accepted, which affirmatively responds by stating that the items are for resale, that will be considered as confirming the seller's belief that the items were for resale as it pertains to subdivision G. And then subdivision G says, well, the purchaser is responsible. They have an obligation if they in fact use this. So it's not only if they actually resell it. If they in fact use it, then the purchaser has the obligation for the tax, and they report the tax at the time of the use on their return.
Okay, this is it's kind of a good faith issue. Were
I think
these
so,
accepted
yes.
in good faith? I
Absolutely.
think that's really the crux of the argument here. And that's why we keep going back. I mean, I understand the specific form, but I do also say this is first audit. They managed to prove up, the majority of the transactions, probably 98% or whatever. I don't know, I'm not doing, maybe 94% of all the transactions. And so we're down to these few, which, I other than Moda, I could see maybe considering that they did act in good faith, they did do the best they could, and they tried to verify. So I'll let.
Yeah, I think the department's wrong and Mr. McCullen is right. Because in the Sherlock case and as well as in the law, you can hold the purchaser liable.
Yes.
The I see you itching over there.
We
So
do agree
don't
with
leave
that.
it out next time. You can hold the purchaser liable. The unfortunate thing is you can't shift the liability of the seller as a result of that. So at worst, at best, both parties could be held liable if in fact there was a fraudulent act in the absence of a valid resale certificate. And I think it's important that the department clarify these things in the future. I mean, when these things come before us and there even is the appearance that the taxpayer is not fully aware of what the law says, and then the testimony doesn't provide clear definition of what the law is, and particularly when a member asks. I mean, Member Harkey asked, and the response should have been, yes, you can hold the purchaser liable, but it doesn't shift the liability of the seller. And so it doesn't change the outcome of the audit at all, but if the fraudulent act is there, the department should look at those fraudulent acts and see if they're doing it elsewhere, and creating even more problems out there for honest taxpayers who are trying to do their best, but anyway, with that, any further discussion? Hearing none, Member Stowart moves to take the matter under submission. Member Runner seconds. Without objection, members, such would be the order. Thank you so very much for appearing before us.
Thank you.
I truly appreciate this because it gives us an opportunity to kind of give direction to staff and hopefully in the future avoid this from happening. The board will make its decision later on and share the results of our decision. Members, let's take a 5-minute break. Welcome back, members. Let us reconvene the meeting of the Board of Equalization. Ms. Richmond, what's our next matter?
Our next matter is item C4. Brian Scott Gerstein, please come forward.
Mr. Bacha, as the taxpayer comes forward and settled in, would you please introduce the issues in this case?
Mr. Chairman and members, the appeal before you presents one unresolved issue, which is whether adjustments are warranted to the amount of disallowed claimed non-taxable sales.
Thank you. Welcome to the Board of Equalization. As you settle in, I would advise that you will have 10 minutes to make your presentation. We'd ask that you commence with your introduction for the record, and you can start at your convenience.
Thank you very much. My name is Jim Garbo, and my client is Brian Scott Gerstein. I'll start off by saying, and I hope I don't offend anybody, but I'm pretty passionate about what's going on here. About 30 years ago, when I had my first sales tax case, my client called me up and said, I'm being audited, and I think the auditor wants to punch me. And I said, no, that can't be right. He's just doing his job, and he doesn't really have any interest in you at all. So he says, no, you're wrong. He really wants to hurt me. And I said, okay, let's have a little meeting with his supervisor. So this is my very first case. So we sat down with the supervisor, the four of us, and as it turns out, I'd gone to school with the supervisor. His name was Bill. So Bill and I, we'd been out of school for about 12 years, and we were doing a little catching up. And the auditor stood up. The client was sitting right across the table from him. He stood up, he pointed his finger right in the client's face and said, I'm going to get you. I'm going to make you pay. Well, he obviously was taken off the case, and that was the end of that. I bring this up because I think this case has a lot to do with that mentality. And I know you probably heard this before, but I think that's what I'm dealing with here. I'll talk about the issues. The first issue is we had 4 invoices. They called them invoices. They were really items. One was for $100. The other one was for $100. Another one for $100. And another one for $150. I would like to point out that in all the testing they did, there was never an invoice presented that did not have a corresponding cash deposit or deposit into the bank. Every single invoice that they looked at and they had, there was a corresponding cash deposit into the bank. Every one, 100%. There was no issue that that this was not true, except for these 4 little items. The board has decided that these 4 items were invoices, where in fact what they were was insurance on a shipment. My client sends out shipments. Sometimes he has warranty documents in there. Sometimes he has a repair issue in there. In fact, in one of these incidents, he was just sending back some headphones to Monster. They have the exhibits, Exhibit 3, 4, 14, and let's see, the last one was Exhibit 8. Now, I think most of us know that if you're going to ship something, they'll ask you, what do you think the value of the contents is? And they give you free insurance. You can get insurance up to $100 for free. It would be shipping malpractice to send out a shipment and say that it's not worth $100 if it doesn't cost you anything. I mean, how good is that? If the package is lost, you get $100, and you get to send your warranty documents out again, and it kind of meets up his burden of going through the process again of sending out that shipment. So that's what Mr. Gerstein did. He simply put a value on the documents that he was sending, or the item that he was sending, and just put a value on it, and that's what they're picking up on the shipping document. It was a value of $100, $100, $100, and $150. The next item in the circumstances was the muscle motor sale. I think he just spent 2 hours on dealing with that, or an hour and a half, or whatever it was. Same situation. We could spout code all day, but Mr. Gerstein showed an email, and his email said to Muscle Motors, do you have a resale license? The response was yes. Check out the following link. And so my client went to the Lincoln, son of a gun, here's the resale license. And so he went ahead and sold the watch. It was a watch. And when the XYZ letter went out, the same thing happened. They called, and the consumer said, oh, I used it, and I told them I used it. And so we're in the same boat as you just went through. I can try to go spout that off again, but that's what we're in there. The third item in the problem solving area here was a drop shipment. I don't really have too much I can say about drop shipment as far as that goes. It's the law. He should have collected the tax on it. He was wrong. He admits he was wrong. I have a pet peeve with that because I think that we have a legal responsibility as the seller of a drop shipment to collect tax. And the retailer, or the receiver of it, the customer of the item, also has a legal responsibility to pay the use tax. So I don't imagine the board's going to change that law anytime soon where they can collect twice the tax, but that's here nor there. We are guilty of that. The issue there really becomes in that one is that that's the only item that we see they have left to dispute with us. And we think that because it's an isolated issue, that they should not put it throughout the entire population and charge the client up to 50 times what the normal tax would be on that transaction. Now the board will try to pull in tests that were done in prior periods. Mr. Gerstein is not a businessman. He worked for a company, was doing quite well, but he decided that he wanted to go into business and earn a little extra money. And so he went to his bookkeeper at the time, and the bookkeeper said, all you need to do is deposit all the money you make into the bank account. If you do that, then I can file your tax returns and I can take care of your business for you. So unfortunately, Mr. Gerstein did deposit. I mean, not unfortunately he did deposit, but fortunately he deposited everything. But unfortunately, there was a lot of times where he didn't write up a receipt for it. He simply got the money, deposited it into the bank, and sometimes he didn't write a receipt. We had a lot of instances of that in the first test. And so the board came up, well, you owe us $100,000. And then when I disputed that a little bit, they came back and said, well, you owe us $1 million. So I said, well, there's $1 million, obviously, he can't afford that. We got to do something that'll correct this or something that would be more reasonable than that. And so it was the board's suggestion that we take, since I met Mr. Gerstein in December of 2010, and I told him what he needed to do and how he needed to report it, Mr. Gerstein, the board said, well, we'll take his transactions from January 1st through June 30th and use that as our test period, and we'll throw out the old period. We'll not use that. So these errors that they found, as they call them errors, were in the test period that they did. So if we take out the shipping documents, because it wasn't a sale, it was simply insurance, and I think our precedent for that is that there's no dispute that Mr. Gerstein deposited all of his money on sales that he had an invoice for, every one of them. If we can deal with Muscle Motors, and you look at the email and you see the same situation there, Muscle Motors gave him a resale number. They communicated with him through the email, and the board says, well, we don't know who you were communicating with. We don't know what the person's name was. Well, they managed to get his name because they sent out the XYZ letter to him. So somehow they know what his name was. So finally, we request that we only be responsible for the one invoice, the one that was drop shipped.
Thank you very much. Members, let us go to the department. The department has 10 minutes to make their presentation. We'd ask that they commence with their presentation with their introduction. I would also ask that they respond to the non-reoccurring nature of the transaction that has been presented by the taxpayer. I think that's where the issue was, relative to the statistical sample, I guess, or block.
Good morning, Chairman Horton, members of the board. I'm Scott Claremont from the legal department. With me are Robert Tucker and Kevin Hanks, also representing staff. And I believe when I'm done, Mr. Hanks is going to add something about that issue of the non-recurring, or the claimed non-recurring errors. Petitioner is a seller of high-end watches and jewelry who claimed all of his sales during the audit period as exempt sales, either for sales in interstate commerce or sales for resale. He did not provide documentation with regard to 90% of the sales during the audit period, and he did not provide any resale certificates whatsoever. He first provided an incomplete set of invoices from 2009. After audit staff's initial findings, which did find 3 errors in those invoices, he did provide a block of 2 quarters of 2011 in which he provided both the sales invoices and shipping invoices. From that, audit staff created an error ratio of 2.38%, which came out to approximately $23,000 in tax from the over $10 million in sales during this period. This was based on the 6 errors that petitioners discussed: the sale to Muscle Motors, the drop shipment, then the 4 smaller transactions. I should point out that even though this is in the 2011 sample, after the boards contacted him, there are no sales invoices for any of these transactions. These were all picked up from the shipping invoices. With regard to the sale of the NASCAR logo watch, the purchaser, Muscle Motors, is not a seller of watches or jewelry. It did not issue a resale certificate. And then upon appeal, petitioner has provided this portion of an email string which clearly picks up in mid-conversation about the sale of this watch, in which he asked for a, quote, resale number, and the representative or the employee of Muscle Motors provides the seller's permit number. As you've already discussed today, pursuant to Regulation 1668, the retailer is liable for the tax unless they timely take a valid resale certificate in good faith, and if they, absent that, they need to show that it's a resale in fact. 2 of the requirements of a valid resale certificate are that it contains the seller's permit number of the purchaser, and that it contains a statement by the purchaser that the item is being purchased for resale. So here, there is a valid seller's permit number that was provided, but there is no statement by the purchaser, and that's sort of the bedrock element, and we're willing to take various documents and put them together, but there needs to be a statement by the purchaser that this was purchased for resale, and that just does not exist in this case. There's no evidence that it was a resale. In fact, we did contact the purchaser, we did talk to him, and they stated that it was not purchased for resale. And again, they are not a seller of watches or jewelry. With regard to, there doesn't appear to be any dispute with the drop shipment. So with regard to these 4 smaller transactions, again, we don't have sales invoices for any of the transactions that we're discussing today, any of the 6. So the fact that there's no sales invoice for them isn't necessarily evidence that they're not sales, because we know that the MMP sale was a sale and the drop shipment was a sale. We also don't have evidence of any prior sale to any of these recipients. Prior to today, the taxpayer has argued that this was the shipment of replacement parts or a repaired watch or documents connected to a sale, but we don't have any invoices for a sale to these recipients with which that type of shipment would be connected. So it was reasonable in the absence of any evidence to the contrary to support petitioner's claims that these shipments of tangible personal property to California recipients represented sales of tangible personal property in California. Therefore, we concur with the Appeals Division that no adjustment is warranted to the audited measure of tax. Thank you.
Thank you. On rebuttal, please.
Mr. Chairman, if I could add and address
My apologies.
your question. And this relates to whether or not there's an isolated sale and a non-recurring error that needs to be treated differently in the sample, the block sample that the staff conducted. We have an audit manual section 405.20 that actually defines non-recurring transactions. Generally, it describes circumstances when the product sold or the types not ordinarily handled or the size of the items occur only at rare intervals. Examples of those types of items would be, for instance, the sales of all the business assets of the business, or perhaps multi-million-dollar purchases of equipment for that business. That would be the type of transaction that we'd regard as a non-recurring error and something that we'd typically stratify and remove from our block samples and examine on an actual basis and look at separately. With respect to drop shipments themselves, just wanted to address that we never treat drop shipments differently than any other sales. In fact, it's pretty routine for us to see drop shipment type transactions handled by businesses, the ones that we're auditing. So those are generally just typical sales that we encounter. So we just wanted to share that for the members' information. Thank you.
Thank you very much. On rebuttal, please.
Yeah. Okay, let me just see the rebuttal. On the sale to Muscle Motors, he says that they were not in the watch business. Well, that's true. They were in the NASCAR selling business. They sold NASCAR paraphernalia. This watch was a special NASCAR watch. So there was no reason that my client would not think that it would be resold in the normal course of that person's business. As far as the property that was in the envelopes, they made the statement, I don't know how they get this, but they made the statement that there was tangible personal property in there. And I don't know where they're getting that from, that it was tangible personal property. We have no idea what was in there. And secondly, I'd like to add that, as I said before, in December I met Mr. Gerstein, and he started doing everything the proper way, and that's why the test period went into the following 6 months, the 2 quarters in 2011. But I'd like to add to that, Mr. Gerstein was re-audited again for the following 3 years, and he had a no-change audit. So he's doing things right. Yeah, you wanted to say something?
Sure. From my perspective, because it may not be your area of expertise, not your area of expertise, in the drop shipment, the individual, there was an invoice that existed pertaining to that. My invoice would be with an out-of-state individual that I continue to do business with. In the essence of time, he requested that I ship the item to his client for him. So there was documentation of my deposit from him and an invoice. It was my shipping record that identified I shipped something in the state of California. So I wanted to clarify that. The Muscle Motors transaction in my communication with the individual was never my indication, or it was never my pursuit to ask him, what are you planning to do with it? It was only my concern that I cannot and will not sell it to you in the state of California if you do not have a valid seller's permit or ID. And that's the thread of communication that I held strongly to, is that it was not my intention to sell it to someone who was not planning to resell it and had valid proof of such. Those other 4 smaller items, I think, are they there? Mm-hmm. I could probably just remember them anyway, sure. But another gentleman from your board was very courteous and forwarded to me the 4 exhibits that were in question that had to do with basically insurance coverages. Is almost, almost a default on a shipping process, that it costs me no different to ship an envelope, 0 coverage, or $100 worth of coverage. It costs me the same $15, $18, $20 to use a UPS overnight label. One of the individuals is a company called West. West is actually West Time, which is a jeweler in Los Angeles. Our labels eliminate the word diamond, jewelry, watch, time, anything that can identify that there might be something valuable. So in that particular exhibit, it says just West. If you Google the address, you'll see that it's Westside Pavilion, I think is the mall. I have never sold anything to them. I have only purchased from them. And what I overnighted to them at their request was a check for payment of a product that I bought from them for resale purpose. The Monster cable, I had some damaged headphones. I used my personal, for my own personal use, I used my business shipping so that I could insure it inexpensively, and I shipped off a broken pair of headphones to Monster Cables that I wanted to put $150 worth of coverage on. You can see that I sent it second day, and it cost me $18 to ship it. Two more. One of them is to Fortress Supplies, because again, the nature of my business, shipments from me or to me to Hill Street, the jewelry district, downtown Los Angeles. Fortress Supplies is the address of a company called Parcel Pro, which is what many of us use for our insurance coverages, our secondary or our third-party insurance, because we use UPS and FedEx and such. So if anything is going to that address, it is rerouted to Fortress Supplies in Torrance. What it was in this particular case was a watch strap. There was no invoice provided because I was not being paid for it. It was a courtesy. Through a couple of emails, it was clarified, and the other individual who forwarded this to me, I shared my emails with him to clarify that the company that received this watch strap recognized it as a courtesy. I didn't charge them for it. It's someone that I've done business for a dozen years with. We do favors for each other once in a while. It's an insignificant value of an item so that they can make a sale. I gave them a watch strap. I insured it for $100 in my UPS envelope. That's what was sent. The last one would have been for a company called Affinity. Affinity Jewelers is one of my customers. I've been working with them for quite some time, not frequently, but occasionally. In fact, I recently did, and I contacted them to ask them to please look up their 2011 transactions with me to see what I might have sent to them, which may very well have been, as Mr. Garbo indicated, perhaps a warranty document or additional paperwork associated, manuals associated with the product that I would have sold them. So that would have identified all 6 of those things from that.
Thank you. Discussion members, member. I'm not quite clear of the department's explanation on the non-reoccurring nature of the transactions. My recollection of the audit manual encourages us to assure that there's a equally known probability of the transaction reoccurring. It not only speaks to the size of the transaction, but it also speaks to the nature of the transaction, such that you could have a transaction of a small amount that is still non-reoccurring by the nature of the transaction. And so in reviewing the transactions before us, are there any that are unusual to the test period that should have been isolated and treated on a non-reoccurring basis?
Mr. Horton, we haven't identified any transactions that are of a non-recurring basis such that they needed to be removed. However, one of the limitations that the audit staff had in this case was actually conducting the test of recorded sales. The petitioner did not have sales journals that we could look at. In many instances, there were no sales invoices. It was represented to us that oftentimes sales are made without the generation of a sales invoice. So I think ideally what the audit staff would have liked to have done would have done a statistical sample where we could have entered the random nature of a stat sample into this selection process, and we could have stratified the larger dollar sales from the smaller dollar sales. That's what would have happened in a stat sample. In this case,
I get that, but that's not a justification for what you did do. And it doesn't necessarily respond to my question or concern. Let me ask the question of the appellant. Of the items that have been disallowed, which one of them do you believe is non-reoccurring and why?
Well, the drop shipment is the item that we're claiming is non-reoccurring. He's obviously going to continue to insurance his shipments for $100. That's a gimme. He's going to do that.
Okay.
he in good faith receive the sales certificate for Muscle Motors. He checked the guy out. He asked him, if he was going to resell it. The resale is right there. It's all in the email. Do you have a light? Yes, I do have one. Now, that was the taxpayer, excuse me, that was the retailer's responsibility to do at that point, let my client know that he wasn't going to resell it. Instead of saying, I'm not going to resell it, no, he gives him the number.
Yeah.
So, okay, so go ahead. I'm sorry.
My apologies. What you just described was that it's not non-reoccurring. And so let me see if I can be helpful and allow me to finish. Might be helpful to you. Non-reoccurring is would be a transaction in the test period that may not have occurred in the population, and so therefore you can't project and you have to isolate it. And so the transactions themselves are not indicative of a normal transaction that you would have had. The drop ship, as you describe, is something that occurs on a regular basis based on your recent testimony.
No, I didn't say that.
Okay, so
I didn't say that.
let me ask again. Help me understand. I mean, I think there may be some non-reoccurring transactions here. I just need you to put it on the record. And so that's why I'm trying to be as descriptive as I can as to what they are.
Well, the one item that would be non-recurring is the drop shipment. And also we think it was just an error on the board's part that we have Muscle Motors included in the test. But the drop shipment, we have admitted that was wrong, and he knows it's wrong. The following 3 years that he had an audit done, it was no change audit, no drop shipments in those test periods. And so, and again, I reiterated that the insurance, I can't say that that's not going to happen again, because he's going to insure his packages. Now, I think the board wants to bring in, and they're considering the total test that they did, the 2009 testing they did, which was thrown out as far as we knew, that they were no longer going to rely on that test, that they actually went in and took a new test period and started over. And that 2009, as far as what I was told, was that was no longer going to be of an issue. We never researched any of the items in that test period anymore because it was thrown out. And that's what they're trying to bring in, is errors that were in that original testing.
All right. I'm going to leave that alone. Further discussion, members. Member Harkey.
As I understand, you said the non-recurring was the drop ship. Okay, don't elaborate, because that's what you said, and that was the question you were asked. So you don't typically drop ship?
No.
Okay. And for the department,
well, that's what we're talking about.
did that drop shipment, was that an aberrant dollar amount?
It was not an aberrant dollar amount, no.
Ms. Harkey, we should also mention that we have seen other lower dollar sales that the business made. So the $100 sales that we're discussing today are obviously relatively small in comparison to some of the other transactions that we're talking about.
Right.
But we have seen other lower dollar sales items sold by the business.
Well, the $100 sales, I think there's a good case. Those make sense. There's only 4 of them. 100 and then 3 at 100 and 1 at 150, and that kind of makes sense for the insurance. You would just you get that choice when you FedEx or whatever you use. So that kind of makes that makes a very solid explanation, because there was no deposit associated with those. Or
I think the difficulty in this case is we didn't see any invoices necessarily associated with that transaction. One of the things that we noticed in looking at some of the accounting records that the petitioners supplied to us are these UPS receipts. And we're just mindful that one of the ones that we're looking at identifies a tracking number, and it shows the insurance coverage on that transaction was $500. So it's very similar to the $100 transactions that we're looking at. But we were able to trace that tracking number to an actual sales invoice for this sale. And actually, this sale represented a sale of a Rolex watch for just under $6,000. And as I say, the tracking number for the UPS document is identified on this sales invoice with the UPS certificate, even though the UPS certificate identifies just an insurance coverage of $500. We're noticing it relates to a watch sale, a pretty expensive Rolex watch sale for $6,000. So we're thinking these types of transactions happened. In the current case where we have the $100 transactions and the UPS identifying a coverage amount of $100, we're simply lacking possibly the sales invoices that match up to those sales. So we can't say that they didn't represent sales. That's staff's difficulty.
Okay. Well, how do you explain those two?
Well, I'll let Mr. Gerstein say what he wants to say about it first, but let me just say something. You notice in their explanation that they did trace it to an invoice, and I bet they traced it to the deposit also in the bank. If there was no deposit in the bank, there is no invoice. The invoice does not exist unless there was a deposit into the bank. And they never found any invoices. 100% of all the invoices had a corresponding deposit into the bank. These items don't have it because there is no invoice. That's as simple as that.
Just a shipping. Yes.
I had contacted to the best of my ability and researched to the best of my ability and shared emails with the gentleman that had forwarded these to me of what those 4 items identified clearly and why there would be no invoice for them is because they were not sales. They were simply overnighting of a check, selling or sending back of some broken headphones of my own personal, the sending of a watch strap of which there was no invoice for, and the 4th one was the
okay.
I don't know, an insured value of $500 on an item that I sold for $6,000. In some of my earlier bookkeeping, I have a cost. Why not just insure it for my cost? Because therefore that's what I would be out. And then I realized in my paperwork, I should probably insure it for what I'm selling it for so that that number will also identify with my deposit. It will also identify with my invoice. $500, I could only say I hope I don't make that mistake often. I think in 12 years of doing business, I've had 1 or 2 insurance claims that have occurred, but $500 should have been $5,000 and should have been my cost on the item.
That's what I was wondering, if the 500 should have been 5,000.
I hope I don't make that mistake often.
Yeah, that would have been tough to recapture, because a $6,000 Rolex watch at $500
I'd be
you'd have
reimbursed
been
$500.
Yeah, you don't make that much. Okay, thank you.
Chairman,
Member Stowar, please.
to the petitioner, you referenced some documents there. Is that in the record? May we get a copy of it, please? And is it the documents
The
that?
exhibits are in the record.
The 4 items with the,
Yes.
those are in the record?
Yeah, these are in the record. They're
Okay, so when you
exhibits,
get copies of
let's get
that.
copies, let's get copies anyway.
4, 8, 13, and 14.
Let's get copies, please. And of those exhibits, you're saying that you spoke with the individuals? And they verified what those exhibits stand for?
To the best of my ability, I contacted Fortress Supply in that one instant to ask them if they could please identify the tracking number and who I actually addressed the envelope to. And they identified that it is a company that I've done business with since inception and continued to. And I asked that company to please identify to the best of their ability, because they keep a file on me of what do I buy from them and what do I sell to them. the best of my ability to the best of their ability, they returned an email to me that I forwarded to this other gentleman just for clarification that I had sent an item to them as a courtesy.
Okay.
It was.
They sent you an email saying that?
Yes.
Is that in the record?
No, I
mean,
don't believe it's in
you
record.
Do you want to put it in the record, sir? What you sent to another person that was probably asking questions?
If you want to put it in the record, you can read it, or you can.
It would be helpful for me to see everything. It'd be
Understood.
helpful for you.
Understood. I didn't know whether or not I should, Mr. Mr. Oakes communicated with me regarding these exhibits, and I corresponded with him with emails of the follow-up of clarification of what these 4 items were.
All right, I understand. It's totally up to you. If you would like for me to look at it, or I can consider it, I would appreciate it, but
That would just been that one.
you don't have to.
It's this one?
Yeah.
Well, that's the only one that I have anything in writing.
Yeah. He does have something in writing from one of them.
Okay.
If you want that, we can make copies.
If you want me to consider it as part,
Yeah,
I
why don't
would
you
like
have
to
me
see it.
copies of
Board proceedings, someone would get it for us. And then,
The other ones were fairly simple to identify simply because for West Time, the existence of West Time, I've never sold them anything. They're only a vendor that I would have purchased a product from. So the envelope that I would have sent them would have been a check, a payment. And then Affinity Jewelers is a jewelry company. It only says Affinity on the label because I would have been sending them some documents or something. They were, I liked how Mr. Runner put it initially, is when they get a phone call from somebody and it regards anything to do with State Board of Equalization, they get afraid. They weren't real helpful in trying to dig up their 2011 records to match up something that I followed through with. But I do have an invoice from them, or for them, with a deposit from them around that period of time.
okay, that's good, thank you.
Thank you.
To appeals on this drop shipment, if it is a non-reoccurring transaction, what do we do? Do we pull it out and do it on the actual?
And Mr. Hanks might be able to answer better than me, but my understanding is that would be handled separately and not part of the error percentage that's projected to the remainder of the sales.
Thank you.
Just for clarification, department the drop ship, any evidence that that's a non-reoccurring item?
We never regard drop shipment transactions as non-recurring items.
Why?
We just don't do that
that's
because they're
not- why?
I think they do. Staff does not do that because it's a generally seen business practice. So I think when we look at non-recurring errors, we're looking at things that are of the type that don't generally get sold by a business. Let's say instead of making a sale of a watch or jewelry, let's say that this sale represented a sale of display cases within the business. Let's say it represented a sale of a vehicle or something of that type. It would have to be outside of the normal type of product that's sold by the business. But generally, we do not regard drop shipment transactions as non-recurring errors. It's just not a practice that we do. The one thing I wanted to mention too is that there were 2 tests conducted in this case. One was from 2009, one was from 2011. There are 3 errors that were associated with the first test period. And in fact, there was one $23,000 sale that the petitioner made where he charged and collected $2,000 of tax reimbursement. That isn't included in our current test. For some reason, it was decided not to blend the 2 tests. Generally speaking, the staff blends tests, but I just wanted to bring to the members' attention that we have at least one transaction where tax reimbursement was charged on one sale and not reported because the taxpayer hasn't reported any taxable sales to the board. But we note that there are 3 errors within that 2009 test period, and there are 6 errors associated with the later test period from 2011. I believe staff wanted to look at the later test period because they thought that might be more representative of the petitioner's business. They were mindful that the audit had started, and so there was an understanding that maybe the records were more complete in 2009. But generally speaking, what staff does is blend the tests so that we can look at as many transactions as possible. Had that been done in this case, the factor of error would actually be double what we're looking at now. The understatement would be twice what's in contention today. We're not suggesting that we necessarily should do that. We're just mindful that generally that's the practice of the staff, is to blend these test periods so that we're looking at as many transactions as possible.
I appreciate that. However, in this environment, if staff fails to do something, the presumption is that they did the right thing, and I think it's inappropriate to argue that because the liability would have been higher because of a mistake, that mistake is a valid mistake at this point. I don't see the substance of that argument. Now, if the argument is that subsequent test that was not blended supports the final test, and that those items are reoccurring based on that test period, then you're going to the point of law and point of contention that's before us. If the taxpayer failed to jump over a hoop and you didn't catch him, then quite honestly, he's innocent of that. So, Mr. Runner.
Yeah, I just have some questions on the transaction with the NASCAR logo watches. The email communication that is included here. From your perspective, what's missing in that email correspondence that that basically does not make the argument for the taxpayer that this was for resale?
I mean, it's the last element, that there's a statement by the purchaser.
One more. One of the primary concerns, it has to state the property was purchased for resale, and all that is a seller's permit. And we also have the case that, go on. That's what I was going to say. Okay. Sorry, I jumped in.
It's okay, we got the answer.
Okay.
So we
Is there another one?
No, there's a response, and clearly there's a little blurring of the line because he uses the term resale number, which isn't a real term.
Right, but is that a fault of? I'm trying to figure out if that is then a fault of this taxpayer, or I'm trying to figure out. It seems to me the goal of this email correspondence is he's trying to figure out what the intent of the use of is for this watch. Right? Why would he even be asking for a seller's permit, or a resale permit is what he's asking for, and then he's provided a seller's permit? Why would he even be asking that? If the core of his concern was, are you purchasing this for yourself, or are you purchasing this for resale? What would be the nature why this correspondence would even take place?
Well, I would say that I don't think there's, it might not be that he's not asking that question, but we don't see in this document a satisfactory response to that question.
I see that. But I'm trying to get to the intent issue. I see that, it would have been right if all of a sudden he would have presented the rights to resale certificate and all that. But I'm just trying to think, it seems to me this whole correspondence is the seller trying to explore what the use of this watch is.
Right. The problem that we're faced with is the law is explicit, and it says that the liability for the tax is upon the seller unless they take a resale certificate. And merely because one might indicate they intend to, it's presumed subject to tax by the law unless they take a timely and valid resale certificate. And between the statute and the reg, it lists the exact elements that are necessary in order to protect the seller under those circumstances.
Let me go to the taxpayer representative. In your consideration on this issue, was this to be believed that this was your final answer and consideration in regards to that this was for resale? And why didn't you follow up then on the more specific resale certificate?
Well, perhaps because the transaction was already completed. I don't know that I could go back and get any more information. They did send out the XYZ letter, and we had nothing else to submit that we could show that there was any other correspondence at the time.
And that's where I'm kind of struggling with this particular one, is I can see, I mean, here's what I'm concerned. What I'm looking at here is, indeed, was this a seller, or buyer, excuse me, was this a buyer who was trying to basically avoid a tax? Was this a buyer who was trying to avoid the tax? The seller began to ask these conversations, tried to protect themselves in regards to, well, what's your intent with this? And then they says, well, here's my resale, or here's my seller's certificate, which then the buyer in the seller's mind here would say, okay, then they do have a valid seller's permit, so that's probably going to be for resale. And so then he goes and does the transaction that way. And then it's clear to me what happens then if the seller was again trying to avoid the tax. When he gets the XYZ letter, he says, oh, no, I was always going to buy this. It's not me who should pay the tax. It's the guy who sold it to me. Which is, I think, again, unfortunately normal response for the guy who's trying to avoid the tax. So, and again, I do appreciate the fact that there is the fact is that I understand that this seller isn't necessarily, the buyer isn't necessarily somebody who does watches, but it certainly is in the realm of possibility that if you are selling and involved in NASCAR and you are indeed buying a NASCAR watch and you have got a seller's permit, that indeed that could be something that you do indeed retail. So I guess I'm just trying to kind of get through that aspect of it and try to see what kind of parameters do we have for the seller at this point? And maybe I'll go back to appeals. When the seller is actually trying to do their best to justify, to make sure that they're doing is proper, and they mistakenly take a sales tax permit for what should have been a resale certificate. At what point what options do we have in helping then the taxpayer, the seller here, to say, hey, he was trying to do his due diligence, but there seems to be, but the exact paperwork was not exactly the one that was used, but clearly he was trying to open the door to see what the purpose was. What abilities do we have to interpret the actions of the taxpayer?
So when there's not a valid, timely resale certificate, then we look to whether the property was resold in fact. And part of that process is the XYZ letter process that we've gone through today, and also in contacting the purchaser. Really, the only way for
we can see right away. We see the conflict there if the purchaser is trying to avoid the tax, right?
Right.
Right. And again, this is an expensive item, so I mean, we can see in that particular issue where it's to the purchaser's advantage.
Sure.
To kind of, if we will, throw the taxpayer under the bus. So what I'm trying to see is what the options are if we've got those in regards to that set aside, knowing that the purchaser has a personal gain in regards to how to answer those questions. What options do we have when it is that the taxpayer is trying to do the right thing? Clearly, this correspondence, I mean, if he was just trying to sell it, he'd just sell it. He wouldn't have this correspondence back and forth, right? So what options are there?
So The only thing that I can come up with is Regulation 1668, subdivision C, talks about good faith. Unfortunately, in this case, good faith doesn't apply because there isn't a resale certificate in this matter, so that good faith doesn't really come into play. One thing with the email correspondence that I noted is that the seller, taxpayer, asked initially for the resale number.
Mhm.
It wasn't necessarily the purchaser offering that information up without first being prompted. So other than an actual finding that the watch was resold, in fact, there's nothing that, in this case, can relieve taxpayer of that sales tax
Let
liability.
me go back to the taxpayers and taxpayer representative. What's your response? What do you see and believe our options are in this regard when it is that the correspondence clearly did not include the necessary resale certificate?
I think so. I learned early enough on that there is a proper way to conduct business. I learned by having bad paperwork. There's a proper way to do business, and I do not engage in transactions with private individuals for sales in the state of California. My business is strictly wholesale, and I have to adhere to communications with people if I have any indication whatsoever that they're not in the business and have resale permits, that I don't engage in a transaction with them. Additionally to that, in the case of drop shipping, I do business domestically in every state as well as internationally. And on many occasions, I will receive full payment from an individual in the state of Texas. And I said, would you like me to ship it to you? And they would say, no, if you don't mind shipping it to my customer in Maine, send me the address. My documentation, my bank receipt, my invoice, my shipping identification is all there together that identifies I sold it to the individual in Texas and I shipped it to the state of Maine. Never will I drop ship in the state of California because I learned from my one mishap that I'm not allowed to do that. Even though I received payment from the state of Florida from my customer who had asked me to drop ship it in lieu of delays to his client. So I know better than to do that ever again.
Let me ask then just to follow up, and again, I think sometimes, again, I think people get caught up in systems and processes to which they don't fully understand. But let me just ask you, in regards to, in Regulation 1668, where it talks about resale certificate, and then it says the form of the certificate. And it talks about the form of the certificate. Any document such as a letter, purchase order, timely provided by the purchaser to the seller will be regarded as a resale certificate. Why doesn't that apply?
Mr. Runner, that would have applied if we had had a purchase order that had all the elements of a resale certificate. That would have exempted the sale. I think what we're trying to say
It doesn't say purchase order. It says document or letter or purchase order, right?
Right. It could be a purchase order, resale certificate,
So
and if it has all the elements of a resale certificate,
it doesn't say
that's
all the
acceptable.
elements of a resale certificate here. It doesn't say that. It just says, any document such as a letter or purchase order timely provided by the purchaser or the seller will be regarded as a resale certificate. Doesn't talk about the elements that it has to be included. And so I'm just wondering, why is that email not sufficient?
I think it does go on to say if it contains all the following essential elements. And I don't think, even though this is just an email, I don't think we would dispute, if it did have, I think, that one element that we think is lacking, I don't think we would get hung up on some of the more formulaic elements.
And the element that's lacking, remind me?
That would be D, a statement that the property described in the document is purchased for resale. And I think we just keep going back to that because that's where we find that it's lacking.
Yeah, the signature of the purchaser and whatnot obviously is not relevant to
And-
emails.
and you can combine-
Obviously, that
right,
doesn't
yeah.
that doesn't work in the way we communicate these days. The name and address of the purchaser, that clearly was in there, right?
And you can go
This-
combine documents too.
The number of seller's permit by the purchaser, that was, seller's permit was included.
Correct.
Right?
Correct.
If the purchaser is not required to hold a permit, a purchaser only
Not
property of
necessary.
kind, not tangible. And then it goes to D, which is the statement properly
Correct.
describes as a purchase for resale. So the question is, I guess for me is, it didn't ask that question, but the only reason it seems to me the correspondence exists is to try to figure out if he intended to resale it. Because why else would he ask the question? So, okay, thank you.
Question of the department, and I thought it was testimony of the taxpayer indirectly, that there may be some out-of-state sales where the property was shipped out of state. Is that correct?
Right. I believe that we've documented that they're in-state as well as out-of-state sales.
Did you take those under consideration?
We did. So where there was documentation to show the property was shipped out of state, we accepted that was an exempt sale in interstate commerce.
So the base of your projection is void of any out-of-state sales?
I think we used
Correct.
all claimed exempt sales, so the percentage is low because we compared the errors that we found against both claimed sales for resale and claimed out-of-state sales.
Oh.
So I think ultimately what we're saying is that we've established that there are recurring errors, for the periods that we've spot examined in 2009. We continued that test from 2011. We determined that the errors of the available transactions we sampled showed that there were taxable sales made to consumers in California, and so we've calculated projection of error based on that limited sample.
And I would add, this doesn't go to the drop shipment issue, but in that 2009 sample, there were 2 disallowed claim sales for resale based on either the response to or no response to the XYZ letter. So it's not included, and we're not saying it should be included, but it is evidence that at least the disallowed claim for resale is a reoccurring error.
All right, thank you.
I would just like to add to that test period was thrown out. It was agreed that test period would not be part of this sample. And that was agreed with the supervisor. And now they want to bring that back in. And we have no evidence of what they're trying to talk about as far as these errors that they're talking about in that test period. Nothing was done to help us or to allow us to dispute those errors that they're talking about right now.
They are not bringing it back in. They have not been allowed to and will not be allowed to bring it back in.
I know you
And
said
we're
that,
at
but
a-
he keeps repeating it away.
We're at a point in time where the liability couldn't go up if they wanted it to.
Right. And then I'd also like to add that if we take out the 4 items, the small items, if we take those out, we only have 2 items in the test period that are at dispute still, or possibly at dispute. And that lends itself to not putting it in the entire population either. They have to have at least 3 items in order to put it throughout the population.
I have one question.
Member Harkey.
I was back trying to figure some of this out, and you saw me probably leave the dais and go back and speak to one of my staff members. I don't have the invoice with me, but he indicated that the invoice that goes along with the muscle motors was to sales at MMC. So it kind of indicates that it was not to Muscle Motors, but to the sales for the resale. I'm just throwing that out for.
Yes.
Has the department examined that?
Yeah, we did notice that in that email string that was said, and that it's almost like reading tea leaves, because really we only have one little string of email. There's more, but that is a factor in what we looked at, but we still don't think that, like I said, gets to that burden of a clear statement.
Okay. Thank you.
Further discussion, members? Member Law? No? Hearing none. Member Runner moves to take the matter on submission, second by Member Ma. Without objection, members, such would be the order. Thank you for appearing before us today. We appreciate your testimony.
Thank you.
And the board will take your matter under consideration later on this evening and send you a written report of our decision.
Thank you.
I'm gonna break, keep going.
You want to do?
You want more? I'm good. Whatever you.
I could do one more too. I don't care. I'm okay. We might miss. Depends on how hungry you are.
I'm all right. Ms. Richmond,
It's always
what's
nice.
our next matter?
It's nice to live in the garage.
Our next matter is item C5, PCS Wireless, Inc. Please come forward.
Greetings, Ms. Cummings.
Hello?
Please introduce the issues in this case and yourself for the record, please.
Good morning, Chairman Horton and members. I'm Deborah Cummins for the Appeals Division. This matter was previously heard by the board on June 24th, 2015, and the hearing was continued. The issues in this appeal are whether adjustments are warranted to the unreported taxable sales and whether petitioner was negligent.
Thank you. Welcome back to the Board of Equalization. Please be advised that you will have 10 minutes to make your presentation, and we will return and allow you 5 minutes on rebuttal. We would ask that you commence with your introduction for the record.
Yeah, my name is Dan. I'm the representative, and next to me is Andrew Mai. He's the president of PCS Wireless. Thank you very much for giving me a chance, and for the last meeting on June 2015. And, and we did the request for the re-audit, and we did provide all the information, all the documents, and the department request, and all the, but, and I don't believe we come up anything, and significant can help the liability. And after a long talk with the petition, and we decide go forward for the settlement division, and hopefully the settlement division be able to reduce the liability. And because this case is never been audited, and this case and the department is always taking the estimates and assumptions, and come up the liability. And we, basically I did forward the settlement request to the settlement division, last couple of weeks. We talk about the settlement, and hopefully, and we can come up something very soon. And we want the board, be able to extend the time, and so we can have more time to talk with the settlement division. Okay. Yeah, that's all.
Thank you. The request is somewhat of an administrative request to allow time to negotiate with settlement. I'm going to deviate just a little bit. Does anyone know, are you in settlement?
Yeah.
Yes.
Yeah.
Settlement considering your case now? Does the department know?
I received an email from settlement this morning, and it says, I would just like to indicate that Mr. Mike Hilbert was in touch with Mr. Hai Dang, and we were unable to reach a mutual settlement agreement. Accordingly, we are not accepting the case in the settlement program at this time. That was this morning.
Such that that's the only issue articulated by the appellant thus far. Would you like to, we would grant you additional time if you would like to deal with the substance of the audit instead of the administrative request of continuing this to allow you to engage with settlements. It's your call.
The reason I'm here, is because, and I don't know why the settlement divisions is not taking our settlements offer. Basically, we're not making an offer. We just accept the settlement. Is back in 2013. the settlement division did give her an offer. It's a $70,000. And we rejected at that time. But after a long period of time, I talked with petition getting, it's too much costly, and to run the audit further, and that's why we decided we take the offer. The offer in 2013 is $70,000, and that's why we're going to take the offer. I don't know why the settlement division come back instead of deny the offer.
Sir, we could put this matter over until later on in the day to allow the department to provide some clarity on whether or not settlement is saying they will not accept the 2013 offer, or we could take the case up. I need some clarification from the department.
Pardon me, Chairman Horton, settlements are confidential, and the department is not a party to any of that, so we would have no...
I understand the
Right.
confidentiality. I understand the restrictions that we have as members, that you have. The only party can do that is the party before us. Settlements can communicate to you that they are not accepting the case, and I'm presuming they have communicated that. I just don't know if they are aware that the taxpayer is prepared to accept an offer that was provided to them in 2013. And did you communicate this to the settlement division? I'm speaking to the taxpayer.
Yes. Yeah, I did talk with Mike Gilbert, and we've been back and forth.
And when did you do that?
I did it about 2 weeks ago.
And what's the date on the communication from settlement?
6:58 a.m. this morning.
Okay. All right.
Can I ask a follow-up question
Sure.
on that, just for clarity for me?
Sure, Mr. Runner. But there are no other issues. Can both parties stipulate to that fact? Otherwise, I have to continue to hear from the department.
I don't.
That's your only issue before this body?
Yeah, that's my only issue. Yeah, I want to get
Does
this
the
done.
department have any other issues that they'd like to present to this body?
As far as presenting the case?
Yes.
Well, we presented at the last hearing. I can present again if
I can't tell you what to do. I mean, you can say yes or no.
Okay, I'll present then.
Can I ask?
The answer is no.
Can I ask a question then? Before we start the case, I do have a question in regards to the process.
Okay, this is what we're going to take up, the issue of process.
Right.
And Mr. Rudder, let's just make sure that we are kind of clear. Mr.
Yeah,
Rudder.
and that's real. I just want to ask, and again, just define for me. I think I get what it is in regards to firewalls between settlement, between us, and between the staff and whatnot. I just need to understand a phrase, and that is when settlements doesn't take a case. I just don't know whether that meant, we don't even want to talk about settlement, or does that mean we have, that we are not in a, when they don't take a case, then they have not taken what it is that the taxpayer has offered. I just need to understand what the difference is.
I think that means that there's been some preliminary discussion of numbers, but they're so far apart that they don't want to pull,
Good.
I think
That
that's
helps
what it
me,
means.
because when they say don't take a case, that almost sounds like, we don't even want to talk to them. But that, we would not believe that's what took place here.
Yeah.
I think. Right.
So we would believe that basically settlement is saying we're too far apart at that point.
Yeah, they're required by law.
Okay, I just wanted to clarify for myself at that point.
It seemed to me then satisfy me, and I just took the settlement offer, and from the 2013, and Now it's how come it's too far apart? You know, and now
again,
2013
we don't know.
they
Again, our
did,
issue is we don't know what the issues are. We don't know what your ability, what the House settlement looked at the case. We don't know any of the facts. We're not supposed to know any of the facts.
Okay.
So we can't engage in that part of that discussion. The only thing I can at least, and the challenge that we have is, again, we can't say, well, why don't you guys go in the back room and settle that now, because again, settlement isn't here to do that with you. So the problem is that we've gone this far. We've done a 30-30-30, which actually turned into many, many months, to try to get resolution to this. And at least what I'm hearing is now you want to go to settlement issues. And we can't, like, I think, as we would like to say, okay, go work it out and come back at the end of the meeting, but we can't do that. The only option that I would see in front of us, which is one that I'm not even sure I would agree with, because there's been plenty of time to get this resolved, is we say, okay, we put the case over and we hear it again next month, and we tell you, you best get this thing worked out.
No, that'd be the same as.
Hold on. What do you mean? Be the same as what?
That'd be the same as putting it over to allow them to have that discussion.
No, it wouldn't be, because if we put the case over, then it allows them to go ahead and continue any discussions that they could have a settlement. Isn't that correct?
Actually, our chief counsel created this one time as well, a few months ago, where you declared that this hearing did not occur.
Yeah.
And then
Okay.
it gets rescheduled later, because once the hearing happens,
Okay.
it forecloses settlement. So in this case, if we were to say this hearing never happened.
So it's not an issue of continuing the hearing, it's an issue of just saying this
it
hearing never took
happened.
place.
The other option would be if the board reaches a final decision, and then it has a final liability that they could take to OIC.
That would be correct.
That
That would
opens up-
OIC, but OIC is different, obviously, than settlement.
And they keep me in the dark for settlement, but I know
Right.
that OIC can take into account the ability to pay, whereas settlement does not. So it may actually open some doors that are currently
Okay.
not open.
Okay, thank you.
So, just for the record, we're still considering the administrative issue and not continuing the hearing, as I previously stated.
So at this time, I just want the board.
Members, based on the information provided, the taxpayer appears to have had a conversation with settlement 2 weeks ago. Settlement has communicated to the board as recently as this morning that they're not taking the case up. Pursuant to the law as well as the policies of the Board of Equalization, settlements required to consider all reasonable offers and to go through their due diligence in order to determine that. We have to presume that settlements is in compliance with the law, particularly based on their history. So, appears that settlement is not a consideration. The best consideration here that we may have is the offer in compromise, which will require us to finalize the transaction in order to do that. But I am open to the members. Just wanted to provide that direction, if you will. Otherwise, we would have to hear from the department, take the matter over, make a ruling, and then he could go into offering compromise.
And I forgot one. If this board were to reach a decision today, they could also file a petition for rehearing, which reopens the settlement doors. So that would, they could let it go final and go to OIC, or petition for rehearing and then go to settlement.
If he asked for a postponement.
Yeah, I did ask for postponement.
If he asked for a postponement, and we were to agree, would we have taken the case up?
Yes.
Okay.
Because at that point, we would have considered the merits, I believe. Even if not, I wouldn't want to have us get close to that line.
Okay.
Yeah.
Okay.
Member Harkey.
If the taxpayer didn't accept the offer in 2013, it's probably been taken off the table. 3 years later, settlement, if settlement were to, would the does anybody know, can you tell me, would the taxpayer be probably in a position of, it's just, it would be very difficult after 3 years and nothing transpiring.
I'd like us to not speculate, and I'd like to echo what Mr. Runner says. We're not supposed to know, because what goes on in settlement for conflict of interest and undue influence, that type of thing, settlement is independent.
I will be happy to leave that alone. So we have two choices here. We either negate the hearing and let them go back where they were, or we hear it and then try to get them to OIC, maybe, whatever. And that would, is that?
Yeah, you're right. Members, we had the testimony from the appellant. We will now go to the department. The department has 10 minutes to make their presentation. We'd ask that you open with your introduction for the record.
Good afternoon, Chairman Horton and members. My name is Scott Lambert. I'll be representing the Sales and Use Tax Department today. To my right is Stephen Smith with the Legals Department, and to Mr. Smith's right is Mr. Hanks with the Sales and Use Tax Department. In this particular case, the taxpayer operates a cell phone T-Mobile store. They were contacted for audit to look at their records. They had a lack of records. The most information at the time that they provided was a 2008 income tax return. That information was used in order to establish the liability. The taxable sales or gross receipts that were reported on the income tax return for 2008 was applied by a percentage, and that percentage was obtained from 7 similar businesses in the general area to come up with a taxable percentage that those taxpayers were reporting. The percentage was 69%. The 69% was applied to their gross receipts or total sales that were reported on the 2008 income tax return, and the taxable sales were arrived at. Now, those taxable sales were actually less than the cost of goods sold that was on the income tax return. Nevertheless, that was the liability that was established for 2008. A percentage of error was established for 2009 based on the 2008 percentage of error, and the amounts that were reported for 2009 were similar to 2008. In 2010, because the taxpayer was contacted in March of 2012 regarding this issue, they did report more sales for the year 2010. And so instead of applying the percentage of error, what we took was the average taxable sales, audited taxable sales for 2008 and 2009, and used those to establish the 2010 audited taxable sales, compared it to what was reported and came up with a difference. The taxpayer has provided additional information since then. They've provided some bank statements. There were 4 business bank statements. They provided, there's still outstanding business bank accounts statements that have not been provided. Subsequent to this hearing, they did provide some additional information, which was the personal bank accounts of the corporate officers. But as I mentioned, there's still outstanding bank accounts that have not been provided. They also provided amended income tax returns for 2008, 2009, and 2010, but those returns have not been filed, so those were not accepted. We have worked off and on with the taxpayer, especially at the direction of the board members in June of 2015 to try and get the information. The information that was stated that they had, which was the business bank accounts, they did not provide those. They also mentioned that they had the general ledger. When we went out, the 2010 general ledger had not been prepared and subsequently was prepared from the bank statements and appeared to be incomplete. It was missing some receipts. I do note that the taxpayer provided an exhibit today regarding a 2015 income statement. I would point out that that is unaudited. So I don't know There's several problems with it. One, it's unaudited. Two, it's hard to know if the business is the same as what it was back in 2008, 2009, and 2010. And then when I note on the cost of sales, I don't see the cost of the phones. I'm not sure exactly where that would be in the cost of sales. Regarding the penalty, a 10% negligence penalty was applied in this case. The taxpayer reported, at least for 2008, less than 10% of their cost of goods sold. Their taxable sales that were understated was $1.5 million. They had approximately a 400% of error. They did not provide any sales invoices, and the books and records, other than some external information, was very limited. And there hasn't been an explanation for why there was a failure to provide complete books and records. So with that, the department concurs with the Appeals Division decision and recommendation.
Thank you. On rebuttal, please.
Okay, and after the last meeting, and we did get a chance to talk with the auditor, and we believe we did provide all the bank statement the auditor request, the reason, and they mark on second bank statement is not provided. As far as the taxpayer told me, those banks is already closed out, and they don't have a bank statement at that time. And we believe we've been 100% provide and comply with the auditor, and they request the bank statement. We don't see any reason why an auditor indicate and we not provide all the bank statement.
Thank you very much, sir. The board discussion, members? Hearing none, is there a motion? Member Stowart moves to take the matter in submission, second by Member Maura. Without objection, members, such will be the order. Thank you very much for appearing before us today. The board will take your matter into consideration later on this evening and send your written report of our decision. Please be advised, I would direct the department to have a discussion with the taxpayer about offering compromise in the event that that's an option for the taxpayer. Members, before we recess, allow me to, with your indulgence, to recognize the former Assemblyman Steve Bradford, who's among us today. Welcome to the Board of Equalization, sir. We will recess and return at 1 o'clock, members. Members, before we return from recess, we have another distinguished, esteemed guest on our presence who is a pillar in her community and responsible for the development, cultivation, and raising of one of our esteemed board members, and that is in the presence of Mrs. White. Please stand so we can recognize you and acknowledge your presence. Glad to have you here. Members, let us reconvene the meeting of the Board of Equalization. Ms. Richmond, what is our first matter?
Our first matter for this afternoon is item C7, Allied Modular Building Systems Incorporated. Please come forward.
Welcome to the board. Before you begin, Mr. Njija, would you please introduce the issues in this case?
Good afternoon, Mr. Chairman and members. I'm Jeff Njija on behalf of the Appeals Division. The appeal before you presents two unresolved issues, which are whether adjustments are warranted to the disallowed amounts of non-taxable sales for resale or exempt sales to the U.S. government, and whether petitioner was negligent.
Thank you. Welcome to the Board of Equalization. It's good to have you back, at least to your representative. To the others, please be advised you will have 10 minutes to make your presentation, and we will return and allow you 5 minutes on rebuttal at your convenience.
Thank you. And well, I was hoping to say good morning, but good afternoon, Mr. Chairman, board members, and staff. I'm Jim Fire. I'm a partner with Downey Smith and Fire, and I'm representing the taxpayer. To my right is Mr. Kevin Pythman, who's chairman, and to his right is Ms. Frances Sullivan Lewis, who's the controller of the company. As was stated, there's two issues here. One is whether the taxpayer's installation of the materials that they sell constitutes either a construction contract or a sale of tangible property. Our position is that it's the sale of tangible property, and that based on the law that we're relying on for how we feel this should be treated, negligence penalty is not warranted in this case, and we think that should be removed. So to begin with, I'd like to have Mr. Pythman talk about the company and give a little demonstration of the product and how it's put together. I believe we had sent you a video clip showing how it's assembled, but again, just want to make sure we understand how this kind of works in more detail.
One second, please. Members, did you receive the clip?
I did, yes, I couldn't view that.
Okay, we've received it but have not been able to view it. My understanding is the department has also looked at it, and they believe it's consistent with the briefing and testimony of the appellant, so I think we're good to go. If you like, during the interim, we can figure out a way that we can actually view it. But thank you very much.
Okay. Well, just to kind of give you guys some background, we've been in business for about 27 years, and at first starting the business, was 25 and very naive, I can tell you that. But one of the things that I was really faced with no internet was really competing with partitions, right? So although to us it's more of an industrial partition, but in that space I'm dealing with against billion-dollar companies. There was no such thing back then as a modular building, a modular office, a portable building. There was none of those products even available on the market. So when we started calling it modular building system, it was a way for us to expand into several different segments of not just partitions, because we weren't going after the same market segment as the steel cases, the Hayworths, and the big players in that marketplace. We're really going after the industrial space. So it's more of an industrial type partition system. Our primary business, so of course, moving forward, there's a lot of other people hijacked the names we used, right? We were kind of first to the party, but not big enough to be able to battle that. Like a modular building used to be called a trailer, but for obvious reasons, synonymous with trailer, is they had to rebrand it to something else into a quote-unquote modular building, right? And then modular offices and so on. So when we first started the business name, none of those products were available. Prefabricated housings weren't really there. So it's really, the name has come really kind of convoluted. The good news is we're big enough right now to have our space in the market, so to speak. But when we started, the name really kind of fit with what we're doing. So everything that we do involves around exactly the same product. So it's basically a modular wall system, partition system, I guess you'd call it, for industrial use, which we use for lots of different applications. In other words, if we say it's a lunchroom or a conference room or a machine enclosure, the product is exactly the same. The only difference is we call it something different because a consumer can't really understand hey, how does a modular office work for me if I want to build a conference room? It doesn't work for me, or a lunchroom, or for that matter, a guardhouse, which I don't think is really at issue here, but it's the same product, right? So we have lots of sales that we sell directly to the consumer, which I'll probably let you, that we charge tax, collect tax, and pay tax. The issue that we have is as soon as that we add installation or put it together, now it becomes a construction contract, which to us it's not. It's the same thing, right? So it shouldn't be the issue of if we install it or not install it. It's still movable, changeable, and relocatable. That's the only purpose a company would actually buy the product. Otherwise, if they were making it permanent, they would just hire a contractor and make it permanent. In our instance, that's not why they buy our product. They buy it to move it, change it, alter it, whether it's for 1 year use, 6 months use, or to be able to change it. Companies like Coca-Cola say, hey, put this over here in the corner now. 2 years from now, it's take it out of that corner and now put it in that corner, right? As much as you'd like to think Coca-Cola bottling doesn't change, it changes all the time. So that's really, we change it from state to state, from location to location, from this side of the warehouse to that side of the warehouse. So really, the whole point of this product from a consumer standpoint is to make it movable. In a traditional construction or construction contract, if you were to tear that down, you throw it in the dump. Now, I found a report that's in the report that you guys might have in 2003 that 501 million tons of construction debris in a landfill. That's a lot of, our product doesn't go to the landfill, it gets reused. And at the end of its life, it usually gets donated to somebody and at absolute worst, recycled, right? So it's not your traditional construction product, otherwise the customer wouldn't pay more money for it, right? The whole point is for it to move. So we really have two customer types that we really sell to, and that's customers that are always going to alter, change, move, and change it, or they're customers, large businesses, Coca-Cola, Pepsi's, and Boeing's, that don't own their building. And they don't own their building, so their contract has to say, hey, when you move out of this building, give us the property back the way we leased it to you, which is pretty standard in any commercial lease agreement. So those are really our two customer types. Now, kind of to back up, when we first started the business, our core customer was racking and shelving companies who were going into racking and shelving businesses and say, I need a shipping and receiving office in the back of the warehouse. So they would sell our product, resell, we would resell it to them. They would, of course, charge tax on it and submit tax. Of course, over time, that business started really declining for us, and it's about going to find other places for us to market our product. But we realized there's two customer types, and those are the two that we focus on, right? That's why people use our product. And so really, it's just, I'm going to probably leave the section 179 stuff to you, but meanwhile, I'll continue to build this.
So I just want to make it clear that this is the basic way they install the rooms. And although the size can vary, the only difference is you'd have more panels if it was a larger room. So it's pretty much the track bolted down to the ground, and then the panels attached to it, all right? We've had several re-audits with this case, and just to give you a history of how this is developed, initially, I got involved with this towards the first audit had just been settled, or the prior audit, and they were just finishing up the field work here. We went back and forth about how is this a construction contract, and the final answer that I got, in essence, from staff was, well, it looks like realty. So it was submitted, we had a hearing, and then it was, the approach was, well, you have to look at case law, and what is the intent of a construction contract? What is an improvement to realty? And that's where they took into consideration the intent, how it's adapted to the environment, several other factors. Oh, sorry. Yeah. It's like Legos over here, okay? And then the board said, well, that's not the analysis we need to use. We need to look at 1521C3, Regulation 1521C3. This is a prefabricated building or modular building. Well, we said, well, wait a second, we're not a building. And then there was one final adjustment that said, well, I tell you what, if you just have partitions or walls, then we're going to say that's tangible property similar to modular furniture, let's say. But, yeah, that's my understanding. Once you put a ceiling on this, then it becomes a construction contract. Now it's an improvement to realty. So in other words, if we had a 2,000 square foot office or room that we put together, if there wasn't a ceiling, it would be considered a sale of tangible property. That's my understanding. Once you put the ceiling on it, then it's an improvement to realty. So that's how far we've come. Again, from just a common sense, high foot overview, that just didn't make any sense to us. So as part of the binder that we provided, the first section just talks about, as Kevin was mentioning, some of the history of the company and some of the different types of uses that the rooms can be used for. And the selling point is, in addition to being green, it's portable, it's versatile, it's not fixed, unlike a typical improvement to realty where it's meant to be permanent and stay in place. This is not meant to be permanent. You just attach it with several bolts, and then off you go. When you want to remove it, just undo the bolts, take the panels apart, take it, use it wherever you want it, reconfigure it. Very flexible. So one of the things we talked about was, you're saying that this is a building, but when I think of a building, I think of 5901 Green Valley Circle, the whole building here. We're in a room in the building. The taxpayer provides that room in the building, not the building. This isn't something you carry on a double wide trailer down the freeway. This is something that's just stacked on pallets. In some cases, they have moved the units as a whole when they were bigger than a guardhouse, let's say, or a toll booth. But for the most part, it's just these panels that are put together. If you look on Section 2, this isn't an issue in this audit, but one of the things right now is containers are being used in addition for shipment and storage. Well, taxpayer, Allied, will put their panels inside one of these containers, right? And if you go to the second page, I think this was used for holding some property, or there's a screen door on there for security purposes. But what's interesting is it's attached in the same method as if they just put it directly to the floor. But in carrying out what board's approach on this would be, well, we're putting a building inside of a container, which is inside of a building, which just doesn't make any sense to us, and that we're confused about. So if anything, rather than 1521C3, we're thinking this is more like 1583 in modular furniture. What's the difference? Is it just the ceiling? I mean, does that make any sense? That once I put a ceiling on the room, then it becomes a construction contract.
And I might want to add, the reason that we attach it to our product is so it doesn't really impact the building that we're sitting inside, right? So in other words, in traditional construction, you attach to, let's say, the roof of a warehouse to suspend a ceiling down. We don't do that because we don't want to have an impact on the facility that they're in, right? The whole point is that when it comes down and gets moved, it should look like it never happened, right? That's the whole point of the product, right? So it's supposed to come down, palletize, move to someplace else. It's not, we have to do drywall repair, we have to take a bunch of stuff to the dump. It's none of that, right? The whole point is to have no impact to the facility at all.
So I was going to say that we're unaware of any other tax, insurance, accounting, regulatory purposes that this is treated as real property, as realty. It seems like it's just the Board of Equalization in this situation is saying it's an improvement to realty. We informally spoke with the Orange County Assessor's Office, and our sources have to remain confidential. I promised I wouldn't reveal them, but just on initial look, their business personal property expert said, well, we look at, is it substantially affixed to the realty? And would there be significant or substantial damage to the realty upon removal? And in looking at the videos on the website, they didn't think that was the case with this type of property. Again, I know I'm just going based on a visual inspection and just a conversation, but again, just to give you some insight into how maybe another department would look at it.
So something else is if you look at tab number 3, this is actually one of the customers that most of the audit has, and it's Camp Pendleton in San Diego. And this is a letter from 2006. I think the guy, he still works there, doesn't he? It's crazy. It's been there forever. Is the whole point of him buying our product is so it can be movable, changeable, and things always change for him. So it's not, it doesn't even go under his normal budget, and that's kind of what he's referring to in the letter, is that it doesn't go under the construction budget because it's movable. So he'll make it into one thing, and all of a sudden we'll get contracted, which I believe is number 5. We put a bunch of invoices there that we actually go take the stuff down, move it to a new location, and put it back up at Camp Pendleton or out of Camp Pendleton into the Navy base in San Diego or wherever he tells us to take it down and move it to.
That was one of the questions, does anybody ever move these rooms? And they do. And that was just an example where it occurred. So the rest of the sections, just FYI 7 and 8, are just discussions from their CPA about how this could qualify for Section 179 expensing, considered tangible property for federal income tax purposes. And then the last section is sample advertisements from competitors talking about the Section 179 expensing opportunities with this type of property. So it's not just us saying that. I think that was it.
Thank you.
Thank you very much. Members will go to the department. The department has 10 minutes to make their presentation. We'd ask that you commence with your introduction for the record.
Good afternoon, Chairman Horton and members of the board. I'm Andrew Quee with the board's legal department, and with me today is Robert Tucker and Kevin Hanks, and we will be representing staff. Petitioner performed contracts to furnish, install, and physically attach the prefabricated buildings to realty. Further, petitioner failed to report or pay tax on its purchases of materials furnished and installed in constructing those buildings. Tax has not been paid to the state by any other person with respect to these disputed transactions. Petitioner performs such contracts for the United States government and for persons other than the United States government. For sales and use tax purposes, Regulation 1521 clearly sets forth how tax applies to construction contracts. A construction contractor is generally regarded as the consumer of materials which they furnish and install in the performance of a construction contract. However, a construction contractor who performs a construction contract for the United States government is regarded as the consumer of both materials and fixtures which they furnish and install in performing the United States government contract. Under either scenario, tax applies to the sale of the materials to the construction contractor for use in the performance of the construction contract. A construction contract means and includes a contract to construct, erect, alter, or repair any building or other structure or other improvement to realty. Further, Regulation 1521 specifically provides that a contract to furnish and install a prefabricated or modular building is a construction contract whether the building rests in place by its own weight or is attached to the realty. A contract to furnish and install a small prefabricated building, such as a shed or a kiosk, which is movable as a unit from its site of installation, is a construction contract. It is required to be physically attached to the realty by the seller. Now, this is the black letter law provided in 1521, and I just quoted it for you. For the disputed transactions, petitioner separately stated its charges for, quote, materials items and for, quote, installation items on its invoice. For example, in one of the disputed transactions, petitioner billed $133,000 for materials items and $45,000 for installation of those items. The materials charge included a 10-foot by 20-foot by 8-foot high modular building above the mezzanine, which petitioner installed for the $45,000. The department determined that petitioner physically attached and bolted the modular building to the realty. Petitioner also confirmed that it bolts the buildings at issue to the realty. Therefore, under 1521, Regulation 1521, these transactions are regarded as construction contracts because petitioner is required to physically attach these buildings to the realty. Petitioner did not pay, report, or collect tax on any of the disputed transactions. The department doesn't have any evidence that tax was paid to the state by any other persons for these transactions. Therefore, petitioner is liable for tax on its cost of the materials, which the audit determined to be 50% of petitioner's, quote, materials charge per the invoices. Therefore, no further adjustments are warranted. We concur with the Appeals Division's recommendation. Thank you.
Want to give us a copy of that, what you just read,
Oh.
so we can read it ourselves?
The script that I prepared?
Yeah, give us a copy. On rebuttal, please.
Well, my question is, we're using the term buildings. Where are buildings defined in the law or the reg?
He can't answer your question. You can.
All right, well, my question is, how do we determine that this is a building? This room is a building? How is that determined? How are we lumped into this category?
I'm sure that answer to that question will come out. The department did not include that in their testimony or in their script. So.
Well, then I'm saying that's the wrong term. We don't fit under that.
Okay.
It's not a building.
I'm going to make another comment. That whole thing made it seem like we didn't pay any tax at all, which sounds horrible. I think the ones that are at issue are sales to, we do normally collect sales tax from every customer that we sell to. Every customer we sell to, except in the case if we sold it to the government. That's the only time that, is that
Or for
not-
resale.
Or for resale. And in those cases, we either paid the tax or the person that was reselling it paid the tax. So I guess that made it sound a lot like we didn't charge any tax and nobody got any, the state didn't get any tax. The only ones that are really at issue here are the U.S. government sales, and how does that really apply? Is it a construction contract, or is it we sell parts? So we sell them just parts, then it's no tax, but if we install it, we pay the tax? So there's kind of that's really what the gist of the deal here. We're trying to figure out which way that actually goes. So if we sell it to a private consumer and don't install it, we charge tax. But if we install it, then we don't charge tax, which for us, it doesn't really make a lot of sense for us. It should be the same whether we install it or not install it. We should charge tax to the normal consumer. We should charge tax for the product. We don't say it's a construction contract. They buy one door, one window, one wall panel, one whatever, so it's basically they buy items from us and we install them, period. And we charge tax to consumers or take a resale certificate to anybody where we're selling it to. The major issues here are really the United States government on how we treat them.
Yeah, and I think just with regards to the penalty, the taxpayer has been substantially compliant. They're trying to do the right thing. It's just that what their understanding of what's being presented just doesn't make sense to them. And I think it's an open question at this point. Obviously, we feel we're correct in our interpretation of this, but I think this is an open issue that they just want to get clarification on that. Up to this point, I don't think it's been clarified. And the prior audit was just settled out of a matter of convenience. Taxpayer had a business to run, and that was their focus. And that wasn't really resolved until the end of this audit period. So we're here now. We're here to get clarification, and that's just their basis for how they've been reporting.
Thank you very much, members. Just for purpose of clarification, then we'll go to Mr. Runner. Can the department share with us in this particular transaction what were the parameters, conditions that existed that caused the department to conclude that they were a construction contractor, therefore responsible, and that these were not fixtures but materials? And can you give us some insight to this specific transaction? We understand the general law.
Yes. So we requested copies of invoices from the petitioner, and we examined those invoices. And the invoices were described essentially as buildings, and these were items which were physically bolted to the ground, and it's not disputed that these were bolted to the ground. There was walls. It was a fully enclosed structure, and the Regulation 1521 clearly provides that a contract to furnish and install a prefabricated building or a modular building is a construction contract when it's physically attached to the ground, and here it was physically attached to the realty. And a lot of these were substantial. But there was a range. There was transactions under $50,000, some were over $100,000, like the one that I described earlier for you. And that's why we determined that these were prefabricated buildings that fit within the definition of a construction contract in 1521 because they were physically attached to the grounds.
And if I might just add, a construction contract, just to go back to the most basic definition, is a contract to erect, construct, alter, or repair any building or other structure, project development, or other improvement on or to real property. And at its basis, that's what this is. They're building walls, bolting them to the real property, and that's why this is a construction contract.
Having a roof or not having a roof, does that change your interpretation?
Well, we had a re-audit, a third re-audit, and we deleted items which were just walls set up inside of a buildings because we do have an annotation which says that modular wall systems are tangible personal property. Now, the remaining transactions are not the wall systems. The remaining transactions are fully enclosed structures, whether they were inside or outside of another larger structure.
I'm sure Mr. Renner will address other questions. Mr. Renner?
Yeah, just again, I think what we're trying to do here is try to clarify a definition, and try to see what this is and how it fits together. Let me just ask, for instance, the idea of bolting. I'm trying to get around this idea of bolting to the ground. If a wall is bolted to the ground that doesn't have a roof, then we saw that as tangible personal property?
Well, we were looking at an annotation which provided that.
I guess it's just like yes or no.
That essentially, that yes, that walls, intermoldal wall systems which were intended to be removed and relocatable were regarded that as tangible personal property. Yes.
Right. Okay. Okay. So they could be bolted to the ground.
They were, I believe, they were screwed into tracks inside within other rooms.
Were those tracks bolted to the ground?
I believe so.
Okay. I got my answer. Okay. So the idea is that they're bolted to the ground. Doesn't make any difference as long as it's a wall. At least that's what I'm hearing. Maybe I misunderstated that. Maybe it's a little too simplistic, but at least that's what I'm hearing. And then what we're saying, but if you've got a roof over the top of that, for instance, I toured in a lot of what I did in the past in legislature is I did a lot of work with aerospace companies. They got huge hangars. So you go to this huge hangar and they need to put up a tool room. Or they need to put up a drafting room or something like that. And so they bring in these walls, and oftentimes there's a roof attached to it. Not to keep the rain out, but simply for sound purposes. It's a barrier, just like the wall is a barrier. The roof is a barrier for sound and things like that, not the purpose of rain or anything like that. And what I'm trying to get over the fact is I'm struggling with this idea that says because you've got walls and then you put a roof on that, and it's a sound barrier or whatever for that purpose, that all of a sudden now you've created a building. And that's what I'm struggling with. And let me just come, and I guess my question goes back to like the illustration that's here, because on section 2 here, the one that's illustrated, would these be some of the issues that would be of dispute?
Not in this.
Okay.
This is something
Okay,
something
that's
new.
fine. I don't need it.
Yeah.
That's fine. If it was of dispute, then I would deal with that one. But if that's not of dispute, it doesn't make any difference. So I guess that's what I'm trying to figure out is why that would do that. I'll give you an example. If I was, again, I know folks that go out and they buy a tough shed. And they buy a tough shed because of its storage capacity. And they put that tough shed inside a room for the same purposes. Is that and normally I would think that tough shed, because it's a sale, it's a personal tangible property, and it gets dropped off right there. Would we see that as personal tangible property?
Well, not unless it's required to be bolted to the ground, because Regulation 1521, and this is a direct quote, it just says that a small prefabricated building such as a shed or a kiosk, which is movable as a unit from its site of installation, is a construction contract only if the building is required to be physically attached, and that's what we have in the regulation.
Okay, I guess, boy, I'm trying to get around that kind of tight definition, because I'm thinking, I may want to bolt it to the ground only because I don't want a forklift to back into it and move it 3 feet. It has nothing to do with it has this exact same purpose. It just is. I just want to make sure it stays stationary. And so I'm struggling with this idea that says, if I take this tough shed and I drop it off there, it's personal tangible property. If I take this tough shed and I put some bolts into my flab, because I don't want my forklift to back into it accidentally and move it 3 feet, and then all of a sudden it's now a building. I guess do you see my confusion? Can you help me through there?
Right, and I think the regulation is trying to create like a more clear line and clear guidance for taxpayers, and it's giving this rule that when it's required to be physically attached to the realty, that's the line that we draw, and that's.
Is that a reason? I guess I hear that. My question is, I don't know if that's a reasonable line.
I understand.
Yeah, I mean, I think I hear. I guess that's. I don't know if that's too simplistic of a line, when in fact you're not. Again, in my prior life, I bought modular buildings. I installed modular buildings. I put foundations on modular buildings. They were attached to the ground. When I think of attached to the ground of a modular building, it's because the building code requires me to do it because of earthquake issues and things like that. I get that portion of attachment to the ground. If it's just attached to the ground so it doesn't get bumped, that to me doesn't all of a sudden make it a building. And that's where I think maybe our reg is focused more on this idea of this building that's attached to the ground because it's the requirement of building and safety because of the use of the building, as opposed to this idea that you just attach it to the ground because you don't want somebody to run into it or back into it, or it's just part of the process. So that's where I'm kind of trying to get myself through this, and whether or not we're just trying to define this a little too tightly in regards to what a building is. The roof issue is really interesting to me because, again, you can have a roof that has the same purpose as the wall. It's modular. It has the same purpose as the wall. It's to create a barrier, a sound barrier. And all of a sudden, the wall is okay, but the roof then makes it a building. I struggle with. Does that make sense?
Right. I see what you're saying, yes.
Okay.
And I was wondering if I might.
I shouldn't ask you to validate what I just said. It's okay.
It's okay, I'll ask.
Mr. Werner, just to think about it, maybe a different perspective.
Yeah.
And I know that's not what we're talking about today, but when these are regarded as construction contracts, it actually reduces the tax liability.
Well, except if you're selling to the government, right?
And I can,
right? I mean, I get that. I get that if you were just selling.
No, I'm just saying outside of this taxpayer, that in general, it reduces the tax liability.
Yeah, I get that, but again, we're dealing with this taxpayer.
Right.
And here's the question I have, and again, that's the issue. I actually want to touch on that for a moment, too, in regards to what tax are we talking about? Because the issue is, if we were just talking about straight tangible personal property, if he was selling to, like I said, Northrop would then, he would charge a tax, and Northrop would write the check, and he would remit it. If he was selling now to the government, and he was doing it as a personal tangible property, he wouldn't collect the tax. But if we look at him as a construction contractor, now he's responsible for the tax on the back end of buying the materials. And that's, to me, where we're trying to get through this issue. And so when we talk about the missing tax, we're not talking about the missing tax in the sense that there was personal tangible property that was sold and tax wasn't collected. It really comes down to the definition, it seems to me, as to whether or not this was a construction contract. And if there was a construction contract, then what we're saying is you owe tax even though these were government sales because these were on the materials, not on the sale itself. And that's the missing tax?
No, actually, there is a clarification I would like to make. In this case, we have two different types of transactions. On the one hand, we have government transactions. And if this were tangible personal property, then there would be no tax on those transactions. On the other hand, we have transactions with non-government, with persons other than the United States government. And in those cases, for those remaining transactions, a lot of them are scenarios, including the non-disputed transactions, where a petitioner did not obtain a resale certificate. So if we actually disallowed those transactions, the liability would go up for those transactions, down for the government transactions, because if this is tangible personal property, tax would be due on 100% of the invoice charge for the TPP plus the fabrication labor.
I get the idea that the material, if you're doing a materials, it's going to be less than the price if you sold the whole item as a whole.
Because we billed him only
So
for
what you're saying
50%.
is if we go ahead and identify these as personal tangible property, you lose the government side of it, but then you've got greater exposure on the other side of it, the personal tangible property, on the issues where there was not valid. Oh goodness, this is like resale certificate day, isn't it?
We were hoping to avoid. We were hoping to avoid that. but- no, and we
and so you'd say that we now have greater exposure on that side of it because we taxed you less because we saw it as a construction contract. Now, if you want to define it as a personal tangible property, you're going to owe more because you don't have a valid
That
resale
is precisely,
certificate.
yes.
Okay. Let me ask you about that portion of it.
No, we agree that some of the transactions that we're saying were sales of tangible property, we didn't have resale certificates for.
Are you liable for those?
Yes,
Okay.
we're fine. We agree with the portion of the audit. That portion we agree with.
You're willing to even pay the higher amount, even though, because
Yes.
you realize that that's a higher amount than if it was if it was a construction contract.
Well, yes, on the retail selling price of the materials. We haven't gone beyond any of the labor, whether it's fabrication or installation. We haven't gone there yet. We're just trying to figure out, is this a sale of tangible property or construction contract?
This might sound kind of weird, but I always ran my business because it's the right thing to do, you do it. So if it's really not clear, that's why we're here.
So you're not concerned about how we define an issue and
Well-
what its a tax effect is?
Well,
Well,
look-
excuse me, I should re-say that. You're more concerned about getting a definition of what your building is.
Yes, I think
Than what it is the actual tax specific.
It becomes very difficult for us, for our consumer, to say this. Okay, so if we just sell you the building and you install it, then it's personal property. But if we install it, it becomes real property. That just doesn't even make sense. You know what I mean?
Yeah.
So that doesn't make sense. So if I could just sell it to you and you pay the tax on it, we're great. But if we install it, then it becomes real property, and therefore.
So for your business model, you'd like to get clear definition.
Yeah. Yeah,
Well-
absolutely.
Okay.
Thank you, Mr. Renner. Those hypotheticals are not necessarily the case before us, and I'm only sharing this before. I would not want the taxpayer to concur with the department's position that the sale of tangible personal property that is presumed to non-government contractors, that is currently presumed to be a construction contract, therefore the liability falls on the cost, as opposed to the liability falling on the sales price, including installation and fabrication and all the taxable labor to concur to that. To get the clarification, maybe we can go to appeals, but I first want to go to the department and have the department speak to the incidental attachment, which is one of the hypotheticals I believe Mr. Runner was sharing, is that if it's incidentally attached for the purpose of a convenience of the buyer, such as cabinets and things of that nature that are incidentally attached, how would you treat those?
Well, I believe the incidental attachment is referred to in the definition of machinery and equipment can be incidentally attached if it doesn't lose its identity. But in this case, we have
About
a clear...
a cabinet?
Right.
Cabinets, prefabricated cabinets attached to the wall?
I don't believe we would regard those as incidental attachment. I believe.
How would you treat a prefabricated cabinet? Materials or what? Prefabricated and bought in and just attached to the wall?
Do you mean within, like, in excess of 90%? I mean,
Right. Yeah. It's kind of a leading question.
Well,
I don't
there's
wanna-
prefabricated and there's prefabricated. They're regarded as fixtures. When they're in excess of 90%, they're regarded as fixtures.
Fixtures and how they're treated as far
Right.
as tax.
Well, they can be whether the retailer, they can be sold for resale in the case of fixtures if there is a valid and timely resale certificate.
Okay. So there is a distinction in a fixation, you know, and I think Regulation 1521 clearly provides for that distinction, and it goes further to speak about one of the determining factors is when it's removed, does it actually cause any damage to the property, the realty itself, and is it affixed in such a way that it's so commingled with the realty that it is considered part of the realty as opposed to something that is just incidentally attached with a couple of glue and that kind of stuff. Well, even glue can do that. Anyway, so appeals. Can you just give us some insight into this whole notion of a fixation, 1521, and particularly to these transactions and what would happen if, for some reason, well, the taxpayers ask for clarity as to when, if they're installing it and they're affixing it to realty, how should it be treated? If they're not installing it and the situation where they're just dropping it and then just incidentally attaching it, and any other things that they need clarity to. Anything else you want?
Just if we sell material just by itself and drop it off and the customer's installing it. I mean,
That's not an issue, though. We understand that's an over-the-counter sale subject to tax.
Okay.
Mr. Guirguis said two reasons why tax was being assessed. It said buildings on the invoice, and they're bolted on. That's pretty clear. So how I describe the property on the invoice determines tax? That doesn't make any sense. Physically bolted, how many items I can think of that have special foundations, special plumbing, heating, ventilation hookups that are much more complicated that are still considered machinery and equipment and not construction contracts. I could go on and on. So I don't think that's the issue. So it's clear in our mind we're not performing a construction contract. I don't see, he just said that if it's just the wall and it's bolted in, that's tangible property. Okay, well, when I add a ceiling, I'm not changing the method of attachment. I'm adding panels on top, as Mr. Runner said, just for barrier purposes, for noise. Why does that change anything? That doesn't make any sense. So right now, the board's asserting that you bolt it in, it's a construction contract. I'm going to ignore the part about it says buildings on an invoice. I can call it whatever I want. I don't think that's determinative. It seems to be the focus is because it's bolted in. But again, we disagree with that because there's a lot of items that I bolt in that are not construction contracts.
Let's say that whether it's machinery, cabinets, anything over 5 feet in any earthquake zone has got to be bolted down. It's a requirement by every city in California. If it's over 5 feet, it's got to be affixed, period. It's just kind of the way it is. It doesn't matter if it's a bookshelf, desk unit, you name it. If it's over 5 feet, it's got to be affixed to the ground, period. There's no option to that. It's obviously, including a safety factor, should be bolted to the ground, right? Whether, again, if it's a big piece of machinery, it's bolted to the ground. If it's a 5'2" cabinet, it's got to be bolted down, right? So those are all really requirements that are put forward by the state. So again, bolting shouldn't really be the issue.
And getting back to your argument, Mr. Horton, about affixation, again, it's
I'm not arguing one way or the other, guys. I'm just trying to address the issue of clarity, and I think appeals may be helpful. I don't think the department, the department's statement about the cost of an invoice says building. That's not in and of itself sufficient, and I don't necessarily. They have not said the basis of their determination yet. They've said it in combination with a number of other different terms that seems to cause the confusion. I mean, you say, well, it's taxable because it said building on the invoice. Well, that's not the basis. 1521 does not say that. 1583 does not apply that. The law itself does not say that. The law deals with totally different, and I don't want to get into doing that, into defending this case for the department, but appeals. Can you give us some insight into when materials are assembled and installed and affixed in such a way that it would be deemed a construction contract, and same thing with machinery and equipment, and then the distinction of when it would be considered tangible personal property.
So that's a lot. That's a lot to chew on.
Yeah.
So I want to begin with and the department had read it from the regulation, we've got a contract to furnish and install property and make a tangible personal property and construct an improvement to realty. That's a construction contract.
That's the contract. That's the original.
Whether it's a building, I think, is a red herring. What we've got is a construction contract because we have someone who is furnishing and installing an improvement to realty.
Okay, everybody got
No.
that? Okay.
We
Wait,
provide a-
let him finish. Let him
And
finish.
the improvement is affixed to the realty. Their own video shows that with these tracks, and they demonstrated here, with these tracks, it is bolted to the ground. That makes it affixed to the land, or realty, makes this a construction contract. Whether or not it's a building, whether or not it's just a statue or anything else, it's affixed to the realty. We have a construction contract. We then resort to the regulation to make a determination whether something is materials or fixtures. The business with the roof doesn't make it, if there's missing a roof, it doesn't make it not a construction contract. What it does is, because of the annotation that says if there's no roof, it's just a movable wall, we make an exception, but it's still a construction contract. We just wouldn't tax it as a fixture because of the annotation. That doesn't change the application of the reg. Machinery and equipment is essentially treated as tangible personal property, but that's not present here, so I'll skip that unless you want me to go down that road.
Well, yes, please. There are times that machinery equipment is affixed to the realty. So
But the crucial, I'm sorry to interrupt, the crucial
It's a leading question, so you can interrupt anytime you want.
The crucial distinction with machinery and equipment, which we don't have at issue here, but it's generally a machinery or equipment that processes other tangible personal property. So the fact that it's affixed to the realty by electrical bolts or otherwise, it's not classified as a fixture because its primary intent is it's not an integral portion of the room, and its intent is to process something else, whether it's water or air or conveyor belt that moves property. I forget if that one's in the annotation or not. But the point is fixation there is irrelevant. The regulation treats machinery and equipment essentially as tangible personal property for tax purposes. It's a retail sale. We don't tax them on cost and get into the fixtures versus materials.
Is there a point in time where the installation of machinery, you're installing machinery, and then there's plumbing that actually goes into the building, that it becomes a portion of it becomes a construction contract?
The first instance, we have to classify it as a fixture or machinery and equipment. We don't let the manner of affixation drive that. The first question is it integral to the building or is it as an accessory to the building? And again, we're getting far afield from what we've got in front of us. The manner, if you were to conclude it was machinery and equipment, then regardless of how it was affixed, it would still be machinery and equipment.
Okay, take us back to the case in front of us.
So for the case in front of us, we have a construction contract to furnish and install these modular, I'm going to say buildings because everybody's fighting over that word as well, to furnish and install improvements to realty, which is this movable system. And it's a construction contract affixed to realty because it's bolted in. Their own evidence shows that. So then we treat it as either fixtures or materials, as the department has done, in accordance with Regulation 1521. It isn't just tangible personal property. Those that do qualify as tangible personal property have been removed from the measure. The ones that were small enough, the kiosks and sheds that were old enough, light enough, small enough to be moved as a unit, we treat that as tangible personal property. What we have left is not those.
One last example I'd like for you to share is what happens when it's not affixed, but it stands there on its own weight?
That's the one, assuming it's a fixture, and then you get into the question of is it affixed, and there's a three-part test in property tax law that I can't remember the case right now, but weight, if it's sufficiently large that it can't be moved, or if it's intended, I think that's the second factor, is if it's intended to remain in place, and there's a third one that I can't, damage that would be done in removing it. We don't need to go down that road here because we have the video and the model that shows that it was drilled into place. We have affixation. It didn't just rest by its own weight, in which case we might get into that issue. But we don't have those questions in front of us.
It's just for the taxpayer to make sure that they.
You want to take this
we
one?
all understand. Member
I just want to call
Harkey,
just
Mr. Runner?
Since appeals was to respond
Sure,
to that, let me just clarify. So I just, what I'm hearing then, I just want to clarify then, at least what I thought I heard was that, and maybe I heard you say that there was some clarity to the regulation, but I'm trying to get this idea that the wall, the temporary wall, I guess, can be personal tangible property.
As a result of that annotation, that's how the department's treating it. Under the regulation, it is still an improvement to realty and still a construction
Okay,
contract.
I just want to make that point. Under the annotation, and what is an annotation?
Rulings of council generally, that's one that the department's gone in favor of the taxpayer.
Okay.
And
So-
the facts which
so
we
my
don't
point
have
would
present
be,
here.
my point would be, this board, and again, we have the ability to create an annotation that would clarify this issue for this taxpayer. Because you're depending on an annotation in regards to the wall.
Yeah, allow me to make clear. If it wasn't for that annotation, that wall would also be taxable.
Right, that's what, I get it. Again, but the annotation is what clarifies it for the taxpayer
Yes.
on that issue. And all I'm saying is, hey, look, if this is unclear, there can be additional annotations that would try to clarify this particular application.
Yes.
Okay, thank you.
Chairman? Member Stowell.
I'm just curious. I'm curious about the annotation. Can you provide any background on that annotation? What was the facts?
And I don't know it offhand, except I heard
Department.
it today. So.
Yes, it's annotation 190-1785, described as interior wall panels.
Say it again, please. I didn't write that fast.
Oh, I'm sorry. It's 190-1785,
Uh-huh.
and the title is interior wall panels.
Can you? Is it just a one sentence,
It-
or do you have any more background on what led up to it? Was there a case? Was there?
I don't have background information, but then it's talking about walls which are reconfigurable, and it says that such modular wall systems are classified as tangible personal property if they're not permanently affixed to realty. And it's talking about how the customer can take down the walls and reconfigure their placement as needed. And that was what it was looking at and saying that just these walls by themselves are tangible personal property, as opposed to say a wall that was like permanently attached and affixed to the realty, like a wall that we would have around here.
Can I ask real quick? You just said permanently attached.
Member Stowell.
1 second,
Oh,
please.
sorry.
Just okay. Were you finished, sir?
Yes, thank you.
Okay. Petitioner, go ahead.
No, I was going to ask, what is permanently attached? What is that definition? When he said, well, if it's permanently attached, then it's not tangible property, if I heard you correctly.
I do believe he's talking about if it's affixed to realty.
Right, permanently. And I'm saying, yes, it's affixed, it's bolted in, but it's not, well, what's permanently?
I don't think that's part of the regulation. It just says physically attached to realty is the regulation.
Well, my point is, the whole point of this product is to be portable, movable, not meant to be permanent. Okay, so, but anyway.
Okay.
Contract?
Yeah, go ahead.
So one thing I want to take an issue with, and I guess it's defining what a
Member
contract
Stowell.
is.
One second.
Oh, I'm sorry. Apologize.
Go ahead, Petitioner. Go right ahead, sir.
Well, I guess defining a contract, they make it sound like there's a construction contract, which I'm very familiar with. It says it's between a contractor and somebody. In our case, we provide a quote to a customer, and that quote says 14 linear feet of wall, 1 door, 14 windows, whatever that might be, and then they either give us a purchase order or they sign the quote. So there isn't this, I guess, your typical construction subcontract that you would see in a construction project. Right? So we're talking about just a quote and a purchase order. Right? So unless that's defined as a construction contract happens as soon as I attach something to the ground, right? But I just want to make that just point of clarity that it's not necessarily a quote-unquote construction contract that we put in place for any of our customers.
I think our appeal said something about to furnish and install the modular system, structure, building. Don't know how you want to describe it.
We've been working on that for years, I can tell you.
Yeah. Okay, but thank you, sir. I appreciate it.
Thank you.
Sounds like you got it. As soon as you fix it. Construction contractor.
I spend most of my life trying to tell people what I do for a
As soon
living.
as that happens, just drop it, you're good. Further discussion, members? Member Harkey.
I just need some clarification on 1521. Is there any reference at all to movable as a unit versus having to be disassembled and
Yes, the Regulation 1521 does provide that a contract to furnish and install a small prefabricated building, such as a shed or kiosk, which is movable as a unit from the site of installation, is a construction contract, only if required to be physically attached to the realty by the seller. And I'd also note that some of these are really large buildings that were furnished and installed. They included hookups for outlets, power, outside water, power, and ventilation. Some of them were multiple stories. And like this was, a lot of these involve substantial construction contract endeavors as opposed to just simply a shed or a kiosk. And I just wanted to make that clarification.
Okay, for the petitioner, would it be possible for you to just sell your unit and then hire a contractor, or have somebody hire a contractor to assemble it? Is that a?
Yes.
So your price includes both, all? What?
Well, it depends. So the majority of our sales don't include installation. So the customer installs it themselves, and we collect tax and pay tax. So we're good with
Okay.
that, right? On other projects, if I do like a Boeing or a Lockheed Martin, and they're like, our staff isn't going to do it, let you guys do it, right? So we sell them the product, we charge them tax, we install it, we're done. I don't think any of that's at issue. The problem is, and now I sell it to the government, and I install this for the government. Now, what's the tax, right? So that's really kind of where our issue is.
Okay, it's strictly, that's where I was going, strictly with the government contracts. And is that what we're really strictly dealing with, just the government contracts at this point? Appeals? Or not appeals, but department?
We have two separate types of transactions remaining. One is government contracts, and two is the contracts other than government contracts. So if this were tangible personal property, the government contracts, the sales to the government would be non-taxable, but the liability associated with the non-government contracts would increase because a lot of these, the taxpayer did not obtain a resale certificate and XYZ
Right.
response. Okay.
Right, and on a ratio of what we're really looking at here, are we looking at, is it majority, though, government contracts? Are we looking at the majority of the?
Yes. The taxable measure from the summary states that the non-governmental contracts, non-taxable sales for resale is $274,000, roughly, if you don't mind.
Okay.
And for claimed U.S. sales to the government, it's $429,000. So.
And one quick clarification, there's also an additional $76,000 undisputed in non-government contracts.
Okay. Okay, this is problematic. I see what you're saying. The reg is not friendly to what you're saying.
Well, I would add, too, that I don't necessarily agree with Appeals' definition of machinery and equipment. I mean, there's multiple things in here I think that we could address, but we're trying to keep it simple at this point.
Right.
Taking
What
how
I'd
long,
I'd like to deal with is is the government contracts, because I know you did not collect tax on those any way, shape, or form. They were sold to the U.S. government, so quote unquote not taxable. We deal with that on Medicare. It's, that's the way that is. So how do you go about, when the government contracted you to do something, to put up something, do you have a general size? Is it inside a building, or is it separate outside and then bolted to the floor, or is it bolted inside the building?
It's always bolted inside the building.
So it's inside a building?
Yes.
It's not a separate modular unit that, like in the schools, they have those
No.
modular units where the kids actually attend?
No.
So this is a separate modular unit inside a facility?
Correct.
A room.
A room inside
Basically, a room
the
inside of a
facility.
building, yes.
So, and it creates what? It creates an office, or?
A variety of things, kind of what I explained kind of in the onset. It could be a temporary pharmacy. It could be a conference room. It could be an office. It could be an enclosure around a machine to keep people out of it or safe or locked up. So although the product is exactly the same, the uses are infinite. So a lot of times, even in our descriptions, it really depends on what the customer's asking for is the way we're going to describe the quote back to them, right? If they say, hey, I want a temporary pharmacy, I'm not going to say, hey, here's a modular building, right? I'd say, hey, I'm going to quote you a modular pharmacy, right? So the application changes basically in our verbiage, but the product remains the same. But they're always inside of a hangar of the PX, a facility. And then if they decide to say, hey, I want to take this conference room down now, let's take it down, palletize it. I want you to move it, across the base, add one more wall to it, and we're going to call it 2 offices for staff sergeant, whoever, and so for the next 2 years. And then we'll go, again, take that back down and move it someplace else.
Okay. Yes, you're one.
Just a quick clarification that we do have some photos provided by petitioner with outside structures too, just for quick clarification. Some of them are multiple stories. So I just want, I could pass it around if you want.
Are those at issue, or are those part of the?
These are just sample.
They're not part of this case.
Right, these are just sample products offered by petitioner.
Right,
yeah.
but for those, he probably charges or does it appropriately. So my big concern is these government contracts, because I know that operating in good faith did not collect tax and not going to get that. So I'm going to have to, I don't know, I understand the reg. I've got that totally down. I've read it, and the reg is, it may be that we need to revise the reg a little bit, but it seems to be pretty strongly in the department's favor. The only problem is that these are government. They're to the U.S. government. So that's where I'm having the problem. The rest of the case, I think that the department, because of the reg, is solidly there. And although I think these, if you're not building them outside, you're building them inside an already existing real property, I can't understand why it's not a room instead of a real property. I know it's attached, but it just seems to me that calling it is a little bit tough for me because of the because it goes into a huge hangar, it goes into a huge facility. Yeah, it gets bolted. Now, it's not, by the reg, it's not movable as a unit. It comes down and gets reassessed, or gets replaced or removed. So I have a problem, because I think the reg is pretty clear, but I do have a problem with the government contract issue, because I think it would be extra punitive at this point to go after that portion. Because I think in good faith, and I do think even with the understanding that the taxpayer was trying or was considered them, and this is a first audit, I'm assuming, or
a second audit.
Second audit, but this is part of the unresolved issues are from the first audit, as I read. Right.
Yes.
So these are still unresolved issues. So I'm going to be looking very carefully at the government portion of this, because I think the rest of it, the department has made a clear case. I'm just concerned with this government portion only because the tax was in fact not collected, and they're not attached to the ground. They're attached to inside a building, just like you would probably not want a table to move or not want anything else to move. So I'm just, it's although it's attached to a piece of real property, I'm not so sure that a room constitutes real property in of itself. So I guess that's where I'm going with this. Thank you.
Member Ma?
Okay, so I'm kind of going in between 1583 and 1521. And it seems that 1521 is really property that is attached, affixed to real property, where they lose their identity to become integral and inseparable part of the real property. That's in 1521 under materials, permanent improvements to realty where they cannot be easily removed, prefab buildings, mobile homes. And I kind of see in this case that it's more of module systems furniture under Regulation 1583 because they are movable, changeable, alterable, and as the federal government said, under the DoD regulations, they don't fall under the category of construction due to the fact that they are not considered to be permanent structures because they can be easily dismantled and reinstalled, which they've done a number of times. So I just, I'm trying to figure out, obviously, it's a fixation. Does that change it into a construction contract versus, these module movable furnitures? But I think in my mind, if you're putting them inside buildings, no matter what, whether they're panels or wall hangings or screens, they still have to be bolted and affixed. You just don't plop them down. So in my mind, these are modules that I would classify them under Regulation 1583 module systems furniture versus the 1521, which is the construction contract. But that's how I am interpreting this.
We're working on a floating model. We'll see if that ever works.
Okay. Maybe the department can speak to the concern of the member?
Sure. We don't regard these as furniture. Simply, the modular furniture refers to cubicles and was designed specifically with those in mind. And here we're simply looking at walls, that would be much like leasehold improvements, and that's why we regard these as construction contracts, as opposed to, for example, the regulation refers to the different components that make up a cubicle system. I'm trying to find them. Oh, here we go. Freestanding desks, credenzas, lateral files, bookcases, work tables, returns, convergence, corner units. Those are in the nature of furniture, and that's not what we see here today. Thank you.
And maybe appeals the question about a fixation. Does that change anything?
Yeah, fixation.
Yeah. How's it fixed?
In terms of the contrast or comparison between 1583 and 1521? Because 1583 says if it's modular furniture, affixation doesn't matter.
Yeah.
And I believe you'd have a judgment call as to whether this was, I heard what the department said, and we don't disagree, that there's a difference. Furniture, I'm sitting on furniture versus walls, roofs, and buildings. But your insight isn't off the mark in terms of it's movable, reconfigurable easily without any type of permanent damage. On the continuum, I don't think this is furniture, but the trend is still on one end this modular furniture, and on the other end we've got 1521 with fixtures. So.
All right. Thank you. For discussion, members?
Can I make one more comment?
Please. Member Maura.
Okay, I did have another question for the taxpayer. The assessor's office, right? They will assess differently whether it's realty or personal tangible property. And when you spoke to the Orange County assessor, can you clarify what they said?
My understanding is that the specialist said we look at, is it substantially affixed? Substantially, again, I didn't get into a definition of it, but to me it was more than just bolting something into the ground, but and whether it would cause substantial damage upon removal. That's kind of their factors that they look at to determine, is it on the real property roll or the business personal property roll, or business personal property list. So, but, yeah.
Well, look, every furniture partition company that's out there makes a very similar product to us. They do doors and windows and everything just like we do. They just serve a different market. They're in high-rise buildings, they're in those type of things, and they don't have the issue we have because we're in a warehouse, right? So they still make doors and windows and everything that we make as far as our wall system, and they do affix it to the ground. They go up to 16 feet tall, and they do that in an office environment. So, I mean, you look at a website from Hayward to Dirt to all of them make a similar product, but their customer segment's different.
So, and one last question. In your handout, you give two advantages of your competitors, talking about taking 179 deductions for modular offices, portable buildings, and mezzanines.
Right,
So these are two of your main competitors,
yes.
and they're also,
Everybody in our industry does the same thing, and only because there's been a lot of tax law for IRS code, that it's a depreciable, tangible property. Like I said, the only, we can't find anybody who treats it as real property except for the board. I mean, the state of, the state of California doesn't, the federal government doesn't, the United States government doesn't, the tax assessor's office doesn't. That's why we're here.
That's not uncommon, by the way. I mean, the
Unity.
The unique thing about the tax law is different than any other body of law. And its essence in which it was created is just totally different. Assessors, for example, in the Rob Lowe case we just had, the assessor said the property is worth $2 million. Clearly it's over $25 million. Their interpretation of tangible personal property is different, incorporates whether or not it's an inherent property, where it is, and so forth and so on. But, you know, I only put that out just to make sure that we're just stick to the law. Member, I think I think you're there. Sounds like, you know, but you may got this.
Move to take the matter under submission.
Member, I mean, not from my perspective, but from what I hear. Member Harkey moves to take the matter under submission, second by Member Ma. Without objection, members, such should be the case. Thank you very much.
Thank you very much.
Thank you for your time.
The board will take your matter under consideration later on this evening and send you a written report of our decision.
Your conscience be your guide.
Prefer the law.
Unfortunately, it's the facts.
Yeah.
Well, clarification, you don't ask for clarification at this board hearing. You ask for a decision. Sometimes beneficial.
Members, let's take a 5-minute recess. Let us reconvene the meeting of the Board of Equalization. Ms. Richmond, what's our next matter?
Our next matter is item C9A and C9B. Phillip, Andres,
Ms. Cummings, would you please introduce the...
Anacker, Maura, Stanley, Harrington, and Jake Anthony Whitley.
Thank you. Ms. Cummings, would you please introduce the issues in this case?
Good afternoon, Chairman Horton and members. Deborah Cummins for the Appeals Division. The issue in each of these related appeals is whether adjustments are warranted to the amount of unreported taxable sales.
Welcome to the Board of Equalization. You'll have 10 minutes to make your presentation. We'd ask that you commence with your introduction for the record. Good to see you again.
Good to see you, Chairman Horton. I want to thank you and the rest of the members for hearing this case. My name is Graham Hode. I'm president of Sales Tax Resource Group. My client on my left is Mr. Phillip Anacker. He is the founder and managing partner of Flying Goat Coffee. Flying Goat Coffee has two locations at issue. One is in Healdsburg, California, and the other is in Santa Rosa, California. The audit of these locations was conducted for the period of July 1st, 2007 to June 30th of 2010 and resulted in an underreported taxable sales of approximately $489,000. We've been working with the audit staff, with the appeals division, and with the settlement section, and we still have not been able to resolve many of the issues and the questions regarding why the department believes that the petitioner underreported taxable sales, and this is why we're here, and we're really hopeful that we can achieve a fair resolution of this matter through the board hearing process. First, it's important to note that Flying Goat Coffee staff at the coffee shop always asks and always has asked whether the beverage purchased is for here or to go, and they ring the beverage up accordingly. This fact has not been disputed by the department, and it impacts pretty heavily the way the department conducted this audit. So they always ask and they always have asked. Prior to this audit, the department audited Flying Goat Coffee for the period of fourth quarter 2003 to fourth quarter 2006. And in that prior audit, the department accepted reported taxable sales percentage for the period of a prior period even before that. They took the prior period taxable sales percentage for fourth quarter 2001 through third quarter 2002 based on observations of the business and applied that percentage to what is now the prior audit period. That taxable percentage was 11.51, and it was 11.51%, and that was reviewed and accepted by the department. The department now states in the DNR, in the decision and recommendation, that they expect a taxable sales ratio of 30 to 40% for this type of business, and they reject Flying Goat Coffee's reported taxable sales percentage of approximately 11%. So our first question is, why would the department accept a taxable sales ratio of approximately 11% in the prior audit, but expect a taxable sales ratio of 30 to 40% in the current audit? In other words, why would they deem 11% acceptable then, but not acceptable now? The DNR also states that the department observed Flying Goat Coffee staff erroneously ringing up sales of soda as non-taxable sales to go, as well as ringing up sales of coffee served in the customer's own cup as non-taxable sales to go. And great weight was given to these random observations, which led the department to believe that taxable sales were understated and to impeach Flying Goat Coffee's records, and to conduct the full-blown observation tests on the business. However, there's no mention in either the 414Z, which I'll note was 12 pages long, or the audit working papers, both of which had very detailed notes, that the auditor had observed sales of sodas prior to performing the observation test. The only mention in the 414Z of any random observations were that the auditor noted that there were tables and chairs outside the 419, which is a different location, and the Santa Rosa locations. As the DNR suggests, if the observations of the soda sales occurred before the observation tests, why were these random observations not documented in the 414Z or anywhere in the audit working papers? Also, during the 4 days of observation, the taxpayer only sold and erroneously rang up 1 can of soda. Other sales of carbonated beverages, although immaterial, were properly taxed. Regarding the sale of coffee in customers' own mugs, own travel mugs, which the department cites as evidence that taxable sales are underreported, even if a barista did not ask whether the sale was for here or to go. A reasonable person, we believe, would conclude that a customer purchasing coffee in their own travel mug was doing so for the purpose of consuming the beverage off-site. And this is not evidence of underreported taxable sales. And so the department places great weight on the random observations of soda and coffee consumed in the customer's own mugs in support of their position. And yet it appears that either these events never occurred or they're otherwise irrelevant. During the appeals conference, it came to light that the department did not perform the observation tests in accordance with board policy. Now, many years ago, the board grappled with the issue of whether an ice cream cone was consumed for here or to go in what we affectionately used to refer to, back when I was an auditor, as the lick and leave dilemma. That is, if a customer takes a lick of an ice cream cone before walking out the door, is that a taxable sale for here or an exempt sale to go? And the board correctly decided that the retailer should not be put in the position of being the tax police and be required to chase down the sales tax from any customer who took a lick before walking out the door. The department still applies that methodology today, and I'll explain a little bit later. In this case, the department conducted the observation tests by recording whether the customer sat down or whether they left. When it was argued that the observation test should have been conducted by recording whether the customer stated the order was for here or to go, rather than what they actually did, the department accepted the recorded amounts for the observation tests, which were based on what the customer said and not what the customer did. Now, prior to making this adjustment, their observation tests erroneously resulted in 30 to 40% taxable percentage. Now, there are two problems here. First, the department expected taxable sales to be 30 to 40% of total sales based on audits of similar establishments. However, this expectation was only documented after the observation tests had been performed. So it's coincidental at best that what they expected from the audits of similar establishments is exactly what they achieved in the observation tests. Second, when they claim that they expect a taxable percentage of 30 to 40% for this type of business, it's because they're recording what the taxpayer did, not what the customer said they were going to do. How does the department justify citing audits of similar establishments as evidence that Fly and Go Coffee underreported taxable sales when strong evidence suggests that they have not been conducting the audits properly for what they claim in the decision and recommendation is over a decade? The department conducted the two observation tests per location and performed a litmus test. They compared the results of those tests with 6 months of recorded sales. And for these 6 months, they computed the range of taxable percentage that was recorded in Fly and Go Coffee's point-of-sale system. One observation test in each location fell within the 6-month range, and one observation test fell within 2% of the upper limit of the 6-month range. So here's the 6-month range. One test fell right in the middle. One test fell right near the top. Rather than accepting the taxpayer's reported sales percentage of 11% because the taxpayer passed the litmus test, the department averaged the observation test results, resulting in 21% and 23% taxable, and applied those results to reported total sales for the entire audit period when they had absolutely no basis for doing so. The department keeps reminding us that they saw people sitting in the coffee shop at all hours of the day, and that's why they don't believe the taxpayer's records. Keep in mind that if 100 people walk into a coffee shop and those 100 people order their coffee to go, and those 100 people sit down in the coffee shop, those 100 orders are exempt. There's no nexus between the number of people sitting in the coffee shop and how people order their coffee. This is why it's so important to remember that Fly and Go Coffee always asks whether the coffee is for here or to go. Yet the department will tell you that it's improbable that on some days 98% of the customers stated the purchase of coffee was to go. They'll tell you that it is statistically impossible, particularly when they randomly passed by the shop and saw people sitting at tables at all hours of the day. But they also told us that they observed sodas being sold on a to-go basis, but there's no record of it. They also told us that they were doing the observation tests properly, but we know that they weren't. They told us that coffee served in travel mugs was taxable. We know that it's not. And they told us that they expect 30 to 40% taxable for this type of establishment. Yet, those tests were based on incorrect observations. Today, people are savvy and they want flexibility. They want to be able to decide later on whether to stay or to go, and most people order their coffee to go for that reason. The department has provided absolutely no evidence that the taxpayer did not ring up the order, as the customer indicated, nor that taxable sales was not properly reported in accordance with Regulation 1603, as well as board policy. Flying Goat Coffee is doing everything they can to comply with the sales tax laws, and yet the department continues to hold them responsible as the tax police. For these reasons, we respectfully request that the petition be granted in favor of Flying Goat Coffee. I just want to follow up. Do I have any time? Okay, sorry, but that took over 10 minutes. I apologize. I have a letter, and I provided this to the board staff. It's a letter from the auditor, Charlie Whitten, to Ramona Varega, who was the appeals officer at the time. And we talked about the lick and leave test, and we talked about that the tax is only due on orders where the customer states that the order is for here, not if they state it's to go, even if they sit down. In this letter, I'm going to quote it directly. The department has historically, presumably meaning the past decade that they refer to, the department has historically held that taxpayers are responsible for tax on all food products consumed on the premise, regardless of what the customer has indicated their intentions are. We have encouraged retailers to collect tax reimbursement from customers who indicate that they will consume the cold food products on the premise, but report on a percentage basis above the sales that they have collected tax on to capture the sales where customers have indicated the order is to go, but then have consumed the items on the premise. So this is what the auditor told to the hearing officer, that we are taxing we want the taxpayer to report tax if the taxpayer the customer indicates it's for here, but also report additional tax if the customer indicates it's to go but sits in the coffee shop. And this is why we think this audit has gone terribly sideways.
Thank you very much. Members, let us go to the department. The department has 10 minutes to make their presentation. We'd ask that you commence with your introduction for the record.
Good afternoon, Chairman Horton and members. My name is Scott Lambert, and I'll be representing the Sales and Use Tax Department today. To my right is Kevin Hanks, also with the Sales and Use Tax Department, and to Mr. Hanks' right is Robert Tucker with the Legal Department. Oh, I'm sorry.
Pardon, wrong.
That was Steve Smith. Yeah, I've done that before. But anyway, to start off, what I'll say is that whatever the auditor believed at the time of the audit, there are no sales where there was any indication that the tax or the customer could have left the premises and that item was included as taxable. So originally, when we conducted the audit, the auditor was inside the business. One was inside, one was outside, and what they saw was people getting coffee in ceramic or porcelain cups and sitting down, and they also saw customers getting paper cups and sitting down. And there was also customers with their own travel mugs, or and I don't know if they were travel mugs. What I'll say is it's referred to as cups. So the taxpayers' own cups, and they may have been travel mugs. But anytime those were considered taxable is when the customer sat down. So the fact that you had a travel mug in and of itself, we didn't say, oh, that's taxable, or you left with that. It was only the people that sat down. After the audit was conducted and it went to the supervisor and the DPA, they all concurred that the auditor did not hear what the customer said, did not hear what the employee asked, and all those sales that were in question were removed from the audit. So that is not at issue here. There was a prior audit, and approximately the taxable sales came out to about 11.5%. The current reporting taxable is about 11%. What I'll point out, in the prior audit, there were some recording errors based on the POS. Those were corrected. The taxpayer was instructed the proper way to report, and there was no observation test. So the auditor did not sit there and watch how many people were sitting down. The auditor states that there were options given to the taxpayer, and they declined to have an observation test. And that is what they recall from here. There is an entry on the 414Z which says the taxpayer was given options in the prior audit, and the auditor at the time says that was one of the options. They didn't want to do it. He didn't force them. Well, he can't force them, but he didn't pursue that, and he accepted what they had claimed, which was 11.5%. In this particular audit, when the auditor was in, they noticed a large number of people that were sitting down, and that is supported by the observation tests. If you look at the observation test for each one of them, and there's two different locations, Healdsburg and Santa Rosa. One is in the 30% range, 30 to 40%, and the other one was 30 and then a little over 40%. So there are a number of customers that are sitting down here. And just to point out again, we didn't include any where there's a possibility that they could have said to go and they sat down. Now, the department doesn't agree that whether the taxpayer always asked whether to go or not. We have no idea what was stated. What I'll point out is that the taxpayer does not charge tax on their coffee sales. So when somebody comes in and gets a coffee, they would get charged a price, and there's a key ring that's hit on the register, and that records whether the taxpayer is going to report that as taxable or not. So if they don't hit that key ring, it doesn't report as taxable. So when we look at the 6 months for that, the test, or not, I wouldn't say a test, I'd say we analyzed the data for 6 months at each one of the locations. The number of sales that were less than 10% at the Santa Rosa location is 58% of sales are less than 10% at Santa Rosa. For Healdsburg, it's 37%. So there's a number of days where there's a low percentage. We have no idea whether that register was hit the button for whether they were staying here or not. What I'll say is on these two tests, there were 2 days tested. We did not test for a complete day. We should have. We have offered to accept the taxpayer's recorded records for those 2 days, to use whatever that taxable sales were for the percentages for those 2 days. We're not opposed to that. As the representative said, that we did notice one error. Otherwise, we're accepting what they were recording for those particular days. We've also offered to conduct additional tests. We offered to conduct additional tests during the audit. The taxpayer declined for us to conduct additional tests, and I don't know if they decline now for us to go out there, but that's the offer, that we're not opposed to going back out and seeing or doing more testing for this. But in each one of these, there's 2 days tested for each location. The taxable sales on one of the tests is more on both locations than they had reported as taxable in the 6 month periods that we looked at. And the other one was at the upper end of those percentages. So the odds are that we're going to test 4 days, and there's going to be 2 days that just during our test that happen to be higher than any taxable percentage they have. Was right. Statistically, it's improbable that that is going to take place. The calculation is gonna be less than 1%, and in some cases in the 10th percent, that could happen at each individual location, let alone both locations together. What the taxpayer has reported at this particular time is basically 4 customers per hour sitting down at their location, and the department believes that that number is higher based on the observation tests that we conducted, and that's the net result from those. We have 81 at one of the locations for both days, and at the other one, we had 62 and 69% of or numbers of people that were sitting down. So there are a number of people as supported by the Yelp comments and just the knowledge of staff regarding that particular business in general. So accordingly, the department concurs with the Appeals Division decision and recommendation.
Thank you very much. Members will now provide an opportunity to rebut at your convenience.
Okay. The department just told you that there was a prior audit and no observation of the business was performed because the taxpayer declined to allow the observation. The 414 for the prior audit states that on 4/4/2007, the auditor observed the business activity. On 4/10/2007, he observed the business activity. On 4/11/2007, he observed the business activity. I don't see anything in here that states that they declined to allow the auditor to do an observation test. I don't see that there. I don't know why that statement is in the department's analysis. Second, he said that not all parties agree that the taxpayer asked that the customers asked the customers whether the orders were for here or to go. In the letter to Ramona Varega that I just quoted from, it states, quote, all parties agree that the taxpayer's employees have asked the customers whether the order is for here or to go. It doesn't get any clearer than that. Third, the department, in order to go to an indirect method when they do an audit, they have to first impeach the taxpayer's records in order to move to an indirect method such as an observation test. They use as, let me see, hold on just 1 second here. The reasons that they use to impeach the records are that let's see, they say that we find the department was justified in impeaching petitioner's records because the department observed several instances in which the petitioner's employees erroneously rang up taxable sales of soda to go as exempt, or taxable for here sales of coffee as exempt. Again, we go to this. Here's the 414 for the prior audit. This is the 414 for the current audit. It's 12 pages long. He's got incredible amounts of notes in here, but nothing about he went in before those observation tests and saw anything about a sale of a soda, that he saw sales of travel mugs. This was all brought up after the fact, and this letter from Charlie to Ramona is the first time in 2013 that statement was ever written. And so I don't think that they ever had any reason in the first place to impeach the records of the department. Fourth, viewing people sitting in a coffee shop does not a for here sale make. It all hinges on whether the customer walks into the coffee shop and states that the order is to go or for here. That's what determines the taxability. Nothing else. To say that, well, we still believe because we saw people sitting at the tables that the taxable sales was understated. There's no nexus to that. There's no connection between those two events. And finally, he says, well, the knowledge of the department staff is, such that we expect a 30 to 40%. I already pointed out that the staff is doing it wrong. They didn't know how to do it, so they were doing it wrong. So their knowledge was not there. It's interesting to note that when they did the original observation test, they expected 30 to 40%. And when they did their incorrect observation test, they got 30 to 40%. When they had to make the adjustment to accept the taxpayer's records, they got between 20 to 30%. And lo and behold, in the decision recommendation, the appeals officer writes, however, we would expect taxable sales of a ratio of 20 to 30% based on the coffee shop's substantial indoor and outdoor seating facility. Coincidental, I think. I don't know. I mean, it seems like they're just trying to justify whatever they found in the observation test, and I don't think it's fair, and I think they've been, like I said, I think they've been used as the tax police to try and get these they're trying to justify that the taxable sales are understated. I'm done.
Thank you very much. Discussion member Harkey.
I'll go first. For the department, Scott, I believe that you said that you would be willing, says the auditor, or I know the auditor is no longer with the board to confirm, but staff indicates the auditor believed that most coffee sales took place during the first part of the day. Do you concur with that?
Yes.
Okay. So when we did our audit, when we did our observation test, did we use a half a day in the morning?
We took the date. I'll get the exact. The one observation test was from 7 a.m. to 2. Well, let me get you. It's Santa Rosa, 7 a.m. to 2 p.m. The next day was 7 a.m. to 3 p.m. For the Healdsburg location, it was 7 a.m. to 4 p.m. and the next day was 7 a.m. to 3 p.m. So that's pretty much in the morning through most of the day. There's a couple hours left at the end of the day that we did not cover.
Okay, and what were, you said something about using the rate, the taxable sales rate for the 2 days, the on-site audit. What or the observation audit, what were the taxable sales ratios for those 2 days?
Well, for each one of the locations, first, the Santa Rosa, there was 2 days, August 31st of 2010. It was, and do you want rounded numbers or?
Yeah, that's right.
Okay, 24% for that day. For 3/3/11, it was 19%. The average was 21%. For the Healdsburg location, the first day was 10/05/10. It was 20%. The next day was March 2nd, 2011. It was 28%. And the average there was just a little over 23.5%.
Okay. Yeah, I see. Okay, I see where you're going with that. I don't know why that was brought up, because that looks like that's the number you're using. I thought maybe there was some wiggle room in that. Okay. I think you stated that prior to the observation audit that the auditors did not observe whether the sales were asked for, or whether the customers were asked for here to go.
That I don't know whether they were we don't dispute that. Our position is what the representative stated, that during all 4 of those test days, that the position is that each one of those customers was asked whether it was here to go. My statement was for the audit period, we have no idea if each one of the customers was asked whether it was here to go. But there's no question that the way the audit is conducted, that's how it was treated. The taxpayer said that, and only the customers that sat down with a returnable container were included as taxable.
Okay, with the exception of the one soda, did the department observe any key ring errors during the observation test at all?
Well, what I would say is the ultimate result is no. What I would point out, and is just the difference between the two, because originally we thought we had, because we saw the number of people that sat down was on, and this is for the Santa Rosa location. For the first day, we saw 108 sit down, but we ultimately only included 81 as taxable. On the second day, we saw 113 sit down. We only included 81 as taxable. And for the Healdsburg location, on the first day, we saw 93 sit down. We only included 62. The next day, we saw 105 sit down, and we only included 69.
And how was that arrived?
Well, because what happened is the auditor was not close enough to hear what the employee asked or what the customer responded, and that those people that sat down had paper cups, and so the assumption was made that those customers had said to go and then sat down. So your question is did we have any ring-up errors? The way the audit is done right now, I would say no, but I couldn't tell you whether there were ring-up errors or not, because we don't know if all those customers said to go or for here, and then it wasn't taxed because they got a paper cup. But really,
wouldn't
that's
that show up on the cash register? I mean,
they didn't record it up. They didn't record any of the customers that sat down with a paper cup as taxable.
And that was verified with the
by the
observation
auditor.
test?
Well, that's right.
On the days of the observation test,
Yes.
or no? Yeah,
On
okay.
the days of, so that's really not.
So these numbers, though, the 21 and the 23 and a half and averages are partial day.
They are for a partial day. They don't
Right.
include the last couple
7
hours.
to 3, right.
Right.
And
May I say something? They aren't for a partial day because they ended up using the taxpayers' records for those days. Unless I'm wrong, I believe
Well,
I believe that we use the taxpayers' records for those days. The observed were 37% and 33%, but we used the taxpayers' records to develop the taxable percentages of 23.5 and 21.3 for that entire day.
That's not correct.
That's not correct? Okay.
That's not correct.
Okay.
We use the
Sorry.
taxpayers.
Member
If I
Harkey?
could.
I'm
well, you can
sorry,
ask
go
me.
ahead, yes.
What it means by we use the taxpayers' records is that up through that time period, we
Okay.
used the records that they had through those hours. So we didn't
My mistake,
use the
excuse me.
last couple of hours for there.
Okay.
So we pretty much accepted how they rang up the sales for those days, except for the one carbonated beverage.
Okay, next question is, the prior audits assessed the tax at 11.5 and 11%. Why are you considering those ratios too low? Strictly on the observation, or?
That's right.
And the assumption that these were taxed, or you're saying that the observation, though, was checked back to the cash register tapes
For the prior audit?
for the taxable and non-taxable?
Well, in the prior audit, we pretty much accepted how they rang up the sales, and there was no observation test. So if I believe your question is like, why would we do that?
Okay.
I think there was, from the auditor standpoint, he was an experienced auditor, but my understanding is he wasn't experienced in that type of retail business, and he probably accepted that when he shouldn't have. And I think the other thing is that he advised them how to report correctly, and he thought that would take care of the issue, and then he didn't think there was a materiality issue with it, and that's why he ultimately accepted it, is my understanding.
Okay. I'm sorry. Inside joke. Okay, so for the taxpayer, is there any reason that observation tests conducted today, not that I wish to put you under that, would produce a different result than?
The only thing that I can think of is that they've added Wi-Fi to the business, and so, and maybe Phil can expand on this, but I understand that they've added Wi-Fi. So the people who sit down in the restaurant and stay there and order the coffee to go might have increased. And I understand, I haven't looked at the subsequent periods as far as what the percentage of taxable sales that were reported afterwards, but I understand based on my discussion with Maura Harrington, who's the co-partner, I understand that when they did add Wi-Fi, the taxable sales percentages did increase.
Okay, so you're,
yeah, I don't think you would be comparing apples to apples if we did an observation test today versus
versus what was before.
Yeah.
Okay, that was
5 years
kind of my understanding. For appeals, why didn't you question the department's failure to perform observation tests all day, entire days, as recommended by the audit manual?
At the time, it was recommended by the audit manual, but at the time that the DNR was issued, that was not an absolute requirement.
Okay.
And the DNR author understood that the petitioner was not open to longer testing, which I understand is not the case.
Do you know why? What changed since, well, I guess we've kind of answered this, but not really. Prior taxable sales were 11.5 and then 11%, and that's what the customer is, or the taxpayer is claiming is more in line with what they were doing at that time, although not now, because they have Wi-Fi and people are actually, plugging in and sitting around. Why didn't appeals ask the department what changed so that you would expect a taxable sales ratio of like 30%?
To our knowledge, nothing changed. It was simply the way the audit was done, and the prior audit was not raised and was apparently not looked at. Perhaps it should have been. However, the department isn't required to maintain the same. They're not required to say it was 11% here, so we're just going to accept 11%.
No, but I think that would raise an issue. You'd want to know if you got 11 to 5, then you're going to 30 to 40, and then adjusting down to 21, 23. What changed in that period? So I'm just questioning how, because we don't have the auditor anymore, and I think that the staff is doing its best, but it just seems like we're. What other options, excuse me, this is for the department, and I probably should know this, but I don't, so I'm going to ask it. What other options, other than having someone say, for here to go, does a coffee shop have?
As far as reporting?
As far as recording taxable versus non-taxable.
Well, that's pretty much it.
And
to
it
know
sounds
whether
like they
they're
did that, yeah.
Right. I mean, you could have, based on a cup, you would, if you weren't asking, it would, if somebody's getting a porcelain cup, it's probably for there, I would think. I guess you could have some people.
If it's provided by the facility, yeah.
Yeah, I guess you could
See,
have some
I bring my
walking
own
off.
porcelain cups too, because I don't like paper.
Right. Well, they have porcelain cup here because they're a green
So if they're selling with a
company.
porcelain cup, you kind of know that's here.
Well, you would
that's
think,
for here.
you would
Right.
think so, unless there are people walking off with them.
Right,
but,
because they're stealing your goods.
But you could
Okay,
have-
I'll just one more question for the taxpayer. When you rang up the porcelain cups, did you ring those up to go or to stay? Since that seems to be a.
Stay. Realize too that if we make a mistake, we have to make the drink again.
Okay.
So if we give someone who wanted it to go, if we give it to them in a porcelain cup, most of the time they're going to make us redo it, so we lose the product. So
Okay.
our staff has to be accurate every time, and they're well trained. This
Okay.
is.
I feel like the problem centers around what other options do you have other than to ask for here to go, and you have a cup, maybe a positioning of a cup, but just because people come in and sit down, you don't really have an option at that point to go back and say, hey, you're sitting. I want to tax you. I need to pay tax. So I'll just let it go. I'll let somebody else.
Member
Thank
Maura.
you.
Okay, thank you. I had a question about the soda. How many sodas did you observe?
There, I don't know off the top of my head the exact number. It was a handful, a couple handfuls, something to that, in that area.
Okay.
During the test.
Okay. Oh, and talking about the test, what is the usual procedure? I thought it was supposed to be 3 days for a site test.
Right. Well, it depends on what kind of test you're doing. The rules have become more defined now. They weren't as defined then. It recommended that you do a complete day, but that was not a complete requirement. It was said if you could do it, you should do a complete day. But in my opinion, we should have conducted the test for a complete day.
Just one complete day, two complete days?
I would say a
3
number
complete
of.
days?
I think when you take a look at that, at what happened in this test, in that there was, at the end of this, there was a dispute as to did you ask to go or whether it was for here, and ultimately we agreed with the taxpayer and took those out. We would want to test again because now we would actually want to hear what those people with the paper cups actually said. And because there might be the circumstance where someone wants to just drink a portion of their coffee and then leave with that paper cup. So for us, it would be to our best interest to further that test. And as I mentioned, the taxpayer declined for us to conduct further testing. So at that point, we really couldn't correct the partial days that we had initially observed.
So to the department, I want to verify if there is a large coffee chain in this industry that has a certain percentage taxable sales.
Right. Well, there's probably a couple of them.
And what is
I'm
the
familiar with some of them.
Okay. Well, what is the percentage that they are allowed to use?
I'm not allowed to use.
Or whatever they report, and then I guess the department verifies whether the percentage is higher or lower each year. But they, as I understand, they're allowed to use a certain percent.
Hanks.
They don't have to charge tax on everything or ask to go or to stay. They just pay it at the end of the year. Is that true or not?
I would just add that I'm not familiar with the arrangement that you're talking about, but what that taxable reporting ratio is would probably be confidential information, so we probably couldn't discuss that here. But I would think that it varies. It probably varies. Well, absolutely, it varies by location. So depending on the size of the establishment, just the number of people that might take their beverages to go, whether or not they serve food there. I mean, some of these places that we're thinking of are smaller.
I'm not asking about that. I'm just asking because I think a lot of the smaller coffee shops that are similar to these large chains, are facing higher percentage taxable sales than these other large chains, which have an agreement with the BOE that they can report. They don't have to collect, but they just pay it at the end of the year at a certain percentage. And that's what I'm trying to figure out because, as you can see, I mean, it's very confusing having an auditor sit inside, outside, trying to figure out, to-go cup, styrofoam cup, porcelain cup. Yet, why aren't they able to use, have that same sort of, methodology that some of these larger chains?
Right.
Why can't they just pay at the end of the year a certain percentage, and then you guys can come and audit and verify versus, this 2-day tests, 1-day tests, and then just trying to, say it's 40% taxable sales.
Right. Ms. Ma, what you're saying would be workable if the taxpayer were to elect to do something like that, and there were There were observation tests that they had conducted to determine what that percentage was, and we could verify those amounts. I don't think that we'd be in disagreement with looking at that information. I think in this case, the auditor, the audit staff that looked at the assignment thought that just based on their knowledge of that business, that the 10% or 11% reported taxable sales looked low for that establishment and based on their own personal knowledge of that business.
Okay, but you're open to allowing smaller mom-and-pop coffee shops to work on a prospective level in terms of the taxable sales or the sales tax that they want or will report to collect, and then you would audit to verify, similar to these large retail establishments.
See, I'm not familiar with the arrangement that we have with the larger retail establishments, so I couldn't speak to that. I could just speak to whether or not the taxpayer put together a test of their own. If those amounts could be traced and verified by the audit staff, and it looked reasonable based on their knowledge of that business, then yes, I think that would be agreeable with the audit staff.
That's all the questions I have for now.
Thank you, Member Mao. Member Rutner?
Yeah, let me just. A couple of things. I'm also aware of arrangements that we've made with larger coffee folks, and I guess I'm kind of stunned that some of the staff executive staff at that point are not aware of it. I guess that's a little stunning to me, but that's another issue. And I'm just wondering why, in that sense, in a situation like that, that whatever that amount is, that isn't then at least some kind of a standard that could be applied when there's dispute. And so that's my observation there. But I'll tell you, the question I actually want to talk a little bit about is in the letter. Help me understand the letter of December 23rd that was read. And again, I'm just wanting to get some context to this because I'm afraid I'm trying to figure out if this is flavoring the attitude of the auditor, where it says the department has historically held that taxpayers are responsible for tax on all food products consumed on the premises, regardless of what the consumer has indicated their intentions are. Is that?
What's the year on the? I'm unfamiliar with
2013.
2013. I would say at that particular point that was not the department's policy.
And then it goes on to say, we have encouraged retailers to collect tax reimbursements from customers who indicate that they will consume the food product on the premises. That's not the policy.
That is not the policy. The policy is if someone says it's to go, that it's not included as taxable in the in the audit, or nor is the taxpayer responsible for reporting that tax.
But to report on the percentage basis above that sales that have been collected on tax to capture the sales where customers have indicated the order is to go, but then consume the items on the premises. So that would be all incorrect.
Incorrect. That's correct.
Is this letter from the auditor?
To the appeals officer.
Is there any history of correction on this? The two appeals?
I have, that's the first I've heard of that letter, but I know there, in the olden days, we did do it that way.
Okay, let me ask, where did this, I'm not sure where this letter came from. Was it in the file? Was it? I mean, I got a copy of it, so I assume it was in the file.
Yeah, this letter is in response to our letter to the appeals officer, our brief that was given to the appeals officer at the appeals conference, and they responded to our brief. And this letter.
This letter can be found in the file?
Yes.
So
this is where I
have you not found this letter in the file?
I have not read that specific
And you have not found this letter in the file?
I don't recall reading it. It may be in the file. Would you
like to see the letter? Have you seen the letter?
If I read it, I might recall seeing it.
Maybe I think you've got a copy of it. Maybe we can give that to both appeals and
give it to
they'll make a copy of it.
What I would say is that the conference holder did not follow that in any way.
Yeah, I tell you, I get that, and I understand that, but what I'm trying to get through is I think this tells me of a bias. This would indicate a bias to me of the auditor in regards to how they did their work. And I guess it was really concerning to me if this is a letter that was done and then to the appeals office and there's no correction in it. That sounds like there's no reason to assume that this isn't current policy then.
Right.
And I, for one, would be appalled if our current policies or the intentions of policies out there by auditors is the fact that we would be asking them to ring up on taxpayers taxable sales when the taxpayer said, the taxpayer being the consumer, the consumer said to them, I'm going to eat this. This is to go. I mean, that to me is almost fraudulent on the part of, we're asking them to overtax somebody. So I don't know. I'm a bit concerned. Like I said, I'm more concerned about what this tells me about the attitude of the auditor in this setting. I'm sorry, was Appeals going to say something?
I was just going to say, I think that has to do with the lick and leave. The department did a long time ago do it the way that says, but it's been changed for several years.
Yeah. Okay. Let me ask you again. Let me see about the business a little bit. Coffee business. You sell other kinds of things there. What kind of things do you sell besides your coffee?
Teas, some pastries, very little soda to go. It's really mostly about coffee.
Very similar to what I would find at one of those big retail chain coffee shops.
Close, yeah. But the coffee's better.
Huh?
But the coffee's better.
I'm sorry,
the coffee's better at our place.
Well, I just, of course. Of course, it's too.
Thank you.
Of course. Yeah, for people getting this, the statement is in the middle of the second paragraph is where the statement is. Okay, so very similar to those larger chain issues. Your seating, how many seats do you have?
In one store, I would say it's probably about 35 seats.
Okay.
And then in the other one, it's probably half that. The Santa
Okay.
Rosa store, it's about half that.
Okay, thank you.
Just from an administrative perspective, I just thank you, Mr. Renner, for providing letters of advice that go out from the Board of Equalization and incorporates the names of the members should go out on the letterhead that does not have the members' names on it. So if you guys can correct that in the future so that the member's name is not on these letters of advice, that'd be much appreciated.
Yeah, especially when the advice is bad.
To the department, can you give us the results of the observation test, the numbers that you observed and the numbers that you actually allowed?
Okay, I'm sorry. The two sets of, for each location?
For each location, you had indicated that you observed 116 set down. I just didn't write the numbers down.
Oh, okay.
And then you allowed.
Right. Okay, so for the Santa Rosa location, the auditor on August 31st of 2010, the auditor observed 108 taxable transactions.
Taxable meaning?
They sat down or they bought something that was taxable.
Okay.
And then what was allowed or what was used in the audit was 81 transactions.
And why did you use 81 instead of the 108 that was observed?
Because the auditor did not hear the conversation between the customer and the employee as to whether it was for here or to go. And all of the 27 that were allowed were either paper cups or the customer's own container.
Okay.
All right. And so for March 3rd, 2011.
So in other words, you really didn't follow the lick and go
We did not.
policy? Okay.
Well, we originally did, and the results that stand today, no. It's not included in there. It's only the customers that had returnable containers, a porcelain cup, or a taxable product such as a carbonated beverage.
Okay.
Chairman Horton,
I'll come back. I've conducted audits on some of the larger chains, and what we may be thinking of is the managed audit concept, where you have all of these different chain operations, and they do different things. They're in different locations, and so we kind of average it all and come up with an average. Allow the taxpayer to go in and do their computation. It's kind of like the managed audit concept. Are you familiar with that? And how does that work in these situations when you have multiple chains and they allow them to do a managed audit?
So a managed audit would work very much like you're describing, where there's an area of the audit that the auditor wishes to verify, but for the sake of saving time on the taxpayer's part as well as the department staff, we allow the taxpayer to conduct that review and that analysis of that area of the audit. Generally, it's an area that both parties agree that should be examined. We enter into a little contract with the taxpayer, just identifying what those expectations are, what areas are going to be examined, the time frame in which that is conducted. So perhaps that's what Ms. Ma was speaking about.
I think Ms. Ma has a legitimate point, though, and maybe we ought to take that up in the Business Tax Committee. When we have that data, we should at least provide, and we don't have sufficient data. It's always best to look at the audit on an actual basis whenever you can, and certainly not use additional data out there, but providing the taxpayer the option of having that same convenience might eliminate some of the heartburn that we experience in these cases. So I would suggest that we consider that in the Business Tax Committee and seeing if we can come up with a safe harbor rule. If appropriate for the industry. The challenge with what we do here, it's always a double-edged sword. We do one thing, it affects another 100 people, differently, which is the inherent nature of taxation in and of itself. All right.
I just have one quick question.
Ms. Member Stowar.
Okay, just real quick. So you were giving Chairman the count of 108 taxable transactions, but you only used 81, and basically saying you didn't apply that lick and leave policy, and acknowledging that the auditor couldn't hear what the customer was saying. Why is that? Was the auditor near the cash register? Was the auditor?
I'm not sure. The auditor was far enough away, but inside the establishment, where they could see the transaction, but they couldn't hear the conversation. There was also an auditor that was located outside that was also observing.
Is that normal policy where you could only see but not hear?
It shouldn't be. You really need to hear the conversation, because you need to know what the customer's saying, because that's how you're going to find the errors and you don't usually find, out of 108 to 81, you usually don't find that many customers that say to go and then sit down. This, whether people do it on purpose or not, in this particular case, it might be the situation where maybe they thought they were going to leave, and then, so they really intended to leave, and then they sat down, or it could, like I said, they could just have they want a paper cup of coffee because they're going to leave with it after they drink half of it and leave. So you usually don't see that high of a percentage of people that say to go and then sit down, but it's not an issue at this time.
Okay, thank you.
I think in doing the observation test, just to clarify, the reason they didn't listen to what the customer said was because they didn't think it was important. They didn't care what the customer said. All they cared about was whether the customer sat down, and that's based on their understanding of how the board policy should have been implemented, and it's simply not. It's simply not true. The second thing I wanted to mention was that, they performed the litmus test. They took the 4 observation test results, and they compared them with 6 months of sales and saw where the observation test fell within the range of sales for those 6 months. It's interesting to note that not one of those 4 observation tests fell within the 6 months that they used for the litmus test. So, for instance, they tested, one of the days was August 2010. Well, that wasn't in the 6 months. March of 2011 wasn't in the 6 months. October 2010 wasn't in the 6 months. And March of 2011 also was not in the 6 months. So they're using the 6-month recorded taxable sales range as the litmus test. And they say, well, that range was from 2% approximately to 27%. And one of the observation tests fell within that range, but then the other test fell at the upper end of that range. And I'm just pointing out that the observation tests weren't even for the same months that 6-month test. So are we really comparing apples to apples again? And then if we did expand it, would the range be, if both of the observation tests fell within that range, would we then just accept the taxpayer's recorded percentage, or would we still be averaging the 2 observation tests and applying those to total sales? And if so, what's the rationale?
Question Department, when was the audit concluded?
Concluded as, what was the,
Finalized the audit, you sent the letter?
I have to.
2013.
And while he's researching the question of the appellate, did the appellant perform a test of their own? And that you have a test that you've conducted that you'd like to recommend? The reported amount, as I understand it, is 10%. The sales are taxable. Not to dispute whether that's true or not, but
we believe we're doing it right. I mean, we're asking the customers whether it's for here or to go, and we're ringing the coffee up. And there's no incentive for the barista to incorrectly hit the wrong key, especially considering if they do hit the wrong key, it's going to make the coffee incorrectly, and they're going to have to remake it. So there's more incentive for them to hit the right key and to make the coffee the way they want, the way the customer wants it, which is for here or to go. And we have done that. I mean, the test is the recorded, what we've keyed into the register, because based on the customer's desire and wishes and statements. Which is kind of goes to why we didn't want another observation test, because we believe we're doing it correctly to begin with.
Late 2011 is when the audit was completed.
Okay. In reference to the tablecloth test, how many chairs and all that stuff. What cost you to go in and do an observation test?
What caused us to do that?
Department, my apologies.
The auditor?
Yeah.
The auditor, the number of people that were sitting down. When you go in there, if you go online and look at Yelp, it'll say that it's a very busy, the one in Healdsburg is very busy. It's a lot of people that don't need to get to work, or people that are on vacation. It's an area that it was more than 11% that they're in their estimation.
And let me encourage the department, when the department comes before the board and provides us with data where they're basically saying that it was 108 transactions in this case that were taxable, you only picked up 81. The same way you have to justify when you pick up more, when you actually don't adjust and you give the benefit of the doubt from your perspective, you have to justify that, because the determination of whether you gave the benefit of the doubt can't be entered into this as something to consider in the determination. I mean, in this case, I get it that there was an observation test. 108 people were observed to have sat down. You only disallowed 81, allowing 20 plus. even though they sat down for whatever reason. You shouldn't do that unless you're prepared to come in and say you gave the taxpayer the benefit of the doubt for a specific reason. Otherwise, your test should reflect what actually happened. But just an encouragement, you guys continue. I mean, I'm with giving the taxpayer the benefit of the doubt. When I was an auditor or supervisor, one of the things I used to tell my team members is that these are all estimates. And I liken it to baseball. And I said, listen, our goal is not to hit a home run. Our goal at best is to get the first base. We don't need to get the second, third, and knock a home run. These are just estimates. The objective here is to assist the taxpayer in complying subsequently, prospectively, once we've gone in. It's somewhat of an education, which ends up with a tax liability, because even first base, as it appears to be in this case, maybe somewhere between first and second, is still a liability. Anyway, further discussion, members?
Move to take it under submission.
Member Harkey moves to take it under submission, second by Member Stowell. Without objection, members, such will be the order.
Thank you.
Thank you very much for appearing before us. The board will take your matter under consideration and send you a written report of our decision. Members, I wanted to earlier to welcome Gloria to the board. This is her first time coming before the board, and I just want to make sure, ask her if she could read back the last statements. Just kidding. What is our next item?
Our next item is Robert Ramos.
Speaking of Gloria.
Yes.
Ms. Cummings, please introduce the issues in this case.
Good afternoon, Chairman Horton and members. The issue in this appeal is whether adjustments are warranted to the disallowed claimed exempt sales of food.
Thank you. Welcome to the Board of Equalization. You will have 10 minutes to make your presentation. We will return and allow you 5 minutes on rebuttal. We would ask that you introduce yourself for the record. Before we start, we just received, I guess it's an exhibit?
Yep. Taxpayer
All
exhibit.
parties have it? Yes. Okay, so stipulated. At your convenience.
Mr. Chairman, members, my name is Joseph Swift Jr.
Robert Ramos.
Robert Ramos.
Mr. Ramos, if you like any one of those, you can pull close, and there you go.
What is at issue is that Mr. Ramos operates two basically fast food restaurants. One is 100% taxable. We don't have any qualms with that. The second one is kind of a mini mart with prepared foods to go, hot, cold, coffees, all that stuff that you guys just covered. What we went through is the auditors came in. We tried to present to them all the data that they requested. The one item that we didn't have were the sales tax Z-tapes. The reason that we didn't have them is that they were being put on the floor into a box and they were kind of growing. So they were of no use to us. The documents that I provided to you are basically what I believe that the BOE is relying on to come up with their answer to that solution. They're basically coming in and saying that they're coming up with a 41% non-taxable ratio. We came in, we showed other documents, they said that's not good enough. We showed more documents, they said that wasn't good enough. So the documents that you have in your hand are what I took from the audit report. That's why you see all the columns on there. And what I did is I took them and I compared them to, and these are for quarter 1 of 2011 and quarter 2 of 2011. I broke them down then and compared them to the reported quarterly forms for the businesses. And that's where the basically page 4 comes into play, showing what the ratios are. And, you know, that's our contention. We keep coming in and we keep going back and forth with the number. They're saying it's this, we're saying it's that. They keep moving the goalpost on us. They keep telling us, no, that's not right. You can't have this, you can't have that. One of the matters that was opened up at the appeals process that I think is applicable would be Chapter 8 of the Bars and Restaurants Manual, where they haven't even allowed us spoilage. It was brought up with Mr. Okahara. It's not in any of the reports that we have. It has been broached repeatedly with them. That's basically our pleading. We believe that our pleading should be upwards of 46 to 50%, and they're saying it should be at 41 and 44%. So we're splitting the baby.
Am I correct in understanding that you're requesting an adjustment for spoilage?
I would request that it would be included in any adjustment since we were not given any to begin with.
And how much do you believe the spoilage should be?
1 to 2% to come into it.
And to the department, did you adjust for spoilage?
We did not.
Did you adjust for self-consumption?
We did not.
Okay, so I
Well,
guess
yeah.
we should hear from you as to why not.
Sure.
Members, let us go to the department. The department has 10 minutes to make their presentation. We'd ask that they introduce themselves for the record.
My name is Scott Lambert. To my right is Kevin Hanks, and to Mr. Hanks' right is Stephen Smith, all representing staff. I'll start off with the spoilage. The reason why we didn't allow spoilage is because we use the taxpayers' sales figures. They're not going to sell something that's spoiled. So, well, I'll retract. That's not where I was going. We only concentrated on the sales. So if they didn't sell it, it wouldn't have been included in our audit. As far as the self-consumption is concerned, if they self-consumed it, they wouldn't have sold it. So the self-consumption would only be to the taxpayer's detriment. But what I would point out is a large percentage of this is hot food, and if they were the consumer of that, they wouldn't owe any tax on it anyway because it's food. So there is no adjustment. There would not be an adjustment for spoilage or for food, or I'm sorry, spoilage or self-consumption for those reasons. I'll step back for a second. In this audit, there were 2 locations. There was one restaurant, and there was another location that had a restaurant and it was a grocery store that had a restaurant inside of it. The location that was a restaurant, we accepted those sales as reported. So the only issue was the non-taxable sales that the taxpayer had claimed on their returns. We accepted the total sales that were made from the, and I'll call it, I don't know if I'm pronouncing it right, but La Tendita. From that location, we accepted the recorded sales that they had. So the only thing at issue is the amount of either taxable sales or inversely the non-taxable sales. So what the department did was the taxpayer only had cash register tapes starting at February 17th of 2011, which was outside the audit period. The department used the cash register tapes from February 17th, 2011 through June 30th of 2011 to come up with a non-taxable percentage, which was basically 41%. And from the schedule that you have, what the taxpayer wants us to do is take their sales journal from January 1st of 2011 through February 16th of 2011 and use the figures from there. And our problem with that is that we don't have any support for those non-taxable sales. If you do the calculation, it comes out to 65% non-taxable for that period. So if you take a look at the periods in February of 2011, each individual day, what you'll see is the non-taxable percentage is probably 20%. And their explanation for, well, let me just step one back. They had originally given us records from, or cash register tapes from February 17th of 2011 through April 30th of 2011. The taxpayer argued that when the weather is colder, that their taxable percentage is higher. So they wanted us to extend the test through June 30th, which we did, and it lowered the percentage. But their argument is basically against using this. If their taxable percentage increases when it gets cold, it doesn't make sense that January and half of February, the actual taxable percentage drops down to 35%. It is not supported by cash register tapes, and it is inconsistent with the records that remain for February of 2011 with the taxable percentage that's shown on these cash register tapes for those days. And for that reason, the department concurs with the Appeals Division decision and recommendation.
Thank you very much. On rebuttal, quick question, just in your rebuttal, just do you allow your employees to eat?
Yes, I do.
Do you ring it up when they eat?
No, I do not.
All right. On rebuttal, please.
Well, they consistently say with no support, but when going through the Appeals Division board hearing summary and some of the quotations in it, you know, if we can't rely on the data, how can they rely on the data? If they're saying that their argument is true, then ours would have to be considered true also. They're also stating in here when they're page 3, line 20, I have searched and searched for representation of these numbers through every piece of document that I have, and I can find no such numbers being reported or discussed with anybody. You know, they also have in the report as a point of contention, you know, that they're saying that we have acquiesced to a number, and we have never acquiesced to a number. The numbers that we discussed with Mr. Okahara were open for presentation, and for presentation purposes to define where is this number, where it lies. In applying his math in the packet that I gave you, I showed that, you know, the second quarter of 11 has no relationship to anything that he talks about on our form. The numbers are totally different, and that's where I keep going back to. I feel like Charlie Brown, where they keep moving the football, you know, and every time I get to a number and we start discussing it and we start going through it, they come back and say, oh, no, it's not another number. You know, they talked about a $385,000 number, and that was never discussed. But then magically the number, after talking with Lisa Renati, appeared to come down to 277. And I asked for explanation of why they were coming with this $80,000 difference, and it's never been explained to me. You know, and I don't want to beat a horse, but Mr. Runner kind of hit on an issue with the prior appellant in regards to, you know, there seems to be a number that some of these auditors have in their head before they even walk in our doors. And I can say, because I told it to my client, I was flabbergasted. The auditor came into me and said, in discussion purposes, and I don't think she realized she said it, oh yeah, you know, the Irvine district, we come in about 10 to 12%. That's usually where our audits end up. Lo and behold, my audit number's just about in that range. So anything that I have presented, they just wash over it. They glance over it. We are currently in audit for the next 3 years. We have changed our practices. We have every single Z tape. We have every bank statement. We have every credit card statement. But yet in their compilations, they say we haven't provided them anything. We haven't given them anything. And they have denied everything across the board every time. As I said, we're here just for the definition of what is the number so that we can proceed and go from there. We've already tried settlement and they don't want to settle. So we need something from the board to define it so we can progress.
Do you feel your current numbers support or dispute the audit?
They dispute it. They're a little higher. What has happened with the La Tiendita market is in 2010, right around there used to be an open lot around him, so he had visible street access. That's not there anymore. The business is suffering substantially. If it wasn't for Cafe del Sol, we probably would have closed the La Tiendita location.
Circumstances have changed. Discussion, members? Hearing none.
Yeah.
Or Member Harkey?
Yeah, we don't want to close this out yet. So how did the, this is for the department, how did you get these numbers?
And the numbers after, from reference 1 down?
Yeah,
Yeah.
this sheet, where does all this come from?
This came, the numbers that are on top that are from 1/1 to 2/16, the petitioner has added those. But
Okay.
other than that, this is a schedule from the auditor that they prepared it, and they got it from the cash register tapes.
Okay, and for the appellant, where did you get your 1/1 to 2/16 numbers from if you didn't have Z-tapes?
I took the first quarter sales tax report and did the simple math, the addition and deduction. Because I had journals that showed what were the sales from Cafe del Sol and La Tiendita.
Okay, now show me, because I'm looking at these numbers, and when I look at, you said to look at page 4, which I believe is this page. And when I look at page 4, I'm seeing same numbers, so I'm trying to, where are you coming up with your differences here? You see 46.94 versus, no, that's still the same thing.
Right, those are my numbers. Their numbers, if you were to take out the line 1
Okay,
and add up only their lines 2 through 133, I believe it is,
right.
that would come to their 41.44%.
Okay, so we're quibbling over 5 cents. Or 5%, okay. Okay. Is there, for the department, this audit's gone on for a long time. It started in 2008. Audit period 2008 to 10, so that's the audit period. That's not when the audit was completed. But your problem with those numbers from 1/1 to 2/16, you said that if it was cold outside, that there should be less taxable, if I understood, right? Because there'd be hot food sales?
There'd be more taxable.
There'd be more taxable. Is hot food taxable?
Hot food's
Hot food's taxable, okay, I'm sorry. I'm getting tired. Okay, so, and why don't we have anything from the department for that first month?
They didn't have any cash register tapes.
And could we have used anything else?
We did. We used the cash register tapes that we had, which started February 17th of 2011. We used the information that was available to us at the time, the source data. Recorded.
Okay. do you want to add anything to the conversation here?
Yeah, Ms. Harkey, they didn't use that because I presented them with the original sheets that my client gives to me to prepare the returns, and they said that they would not accept them.
What receipts were those?
They are manual journals that he keeps where he writes down every day what he has.
And you were not happy, the department was not happy with those or didn't accept those?
We did not accept them. The numbers are inconsistent with what we would expect, and they're unsupported by any type of information. So if you go to, if you do the calculation for that first period, you take the 35,000 over 54,000, you come up with 65%, which is 65% non-taxable.
Right.
If you do that for the other periods where there are cash register tapes, you just go down each one of them, what you're going to find is that the taxable percentage is in the 70 to 80% range. The non-taxable is in the 25 to 20%, and it's inconsistent with what the taxpayer told us in regards to their business, as that when the weather's colder, they have more taxable sales.
Yeah, I think they probably were just throwing that out. I don't want to, because when I go through the last pages, I find days that are higher, days that are lower. It just seems, and I know you're working on an average here, but there's some extremely low taxable amounts in the final page, I'm
Right.
noticing.
And that's when it gets into the warm weather.
Warmer
And they
weather.
don't have as much. And so
Don't
the
have as
point
much.
that we're.
Okay,
that-
but that's
yeah.
the point you're making.
Right.
Okay, thank you.
Further discussion, members? I just wanted to clarify that the legislature and the Board of Equalization removed all incentive from the promotional process or any other process relative to the auditors to actually go out and assess tax at any level. So there is no incentive for them to assess tax at any higher level than what the documents from their perspective, their objective professional analysis determines. And at the end of the day, win or lose, they still go home with the same benefits
paycheck.
they would have had that they came with. So, and that's been my experience in working with most of the folks at the Board of Equalization and the auditors, that they genuinely care and want to do what they can to educate, see their objective as education. 97, 98% of the tax administered by the Board of Equalization is actually self-reported. The items that come before us is a very, very small percentage. And so that in and of itself takes away that motivation. I just would share, and that would be helpful. Sir?
Well, in these two recent audits that I've had, I've experienced totally the opposite of what you're saying. I've experienced a great deal of hardship. Your auditors come in, they say one thing, and then they print something out on paper as opposed to saying it. You know, we gave them an extension on time because they said, you know what, if we don't give you the extension of time, we won't be able to, their time, that limitation of time had expired, and they needed to do some more paper to eventually get to where they got. They said, oh, in order to give you a fair shake, we got to do this. And then when we gave it to them, they went totally opposite of what they told us they were going to do. And then in the second audit, you know, as to oppose, you know, one of my shops is a coffee shop. And I have a register that's on NEC 4000. And you can't ring out a sale if you don't put for here, to go, or drive through. You know, and we sell coffee. And we're not even claiming any of the coffee exemptions on that. But one of the problems that we did have is that the auditor went there and said, because, you know, for example, if you order a coffee and you change your mind, you want a latte, The way the procedure works is that you have to go and you void out that whatever you put in there, and it takes it off, and then you ring it back up. It doesn't close the transaction, it just erases what you put before there. If you put something on there, it doesn't have this or that, you can go in there and erase it, which is voided, and then at the end of the day, you have your sales receipt and it has voids on it. Well, the auditor was saying that those were sales. And if we didn't accept those sales, that he was going to give us a lot more difficulties. And that's what he's done.
We should have let you testify earlier. That
So,
testimony
yeah.
is helpful. Let me see if the department has dealt with that. But
So when
let
you're telling me
let
that-
me also share that. That's not to say that in any organization you don't have a few John Waynes. Don't get me wrong. But the process itself is such that only as, when he's acted the rough parts. I love John Wayne. Don't
I
get
would
me wrong.
concur with you, Chairman. 98% of you are great.
So when that does happen, let me just encourage you to reach up to the supervisor, not resolved there. There are several different levels internally. If that's not resolved, the Board of Equalization has established what I think is an excellent process with the Assistant Chief of Staff and so forth who are now available. This board is very, very sensitive to when that stuff happens and very, very responsive, at least in all the engagements that I've seen with this particular board and previous boards as well. But let me see if, let me put your testimony on record again that you indicated that there were voids, right?
Yeah, correct. On your sales receipt.
And why would those voids exist?
The voids exist, for example, you go in there and you order a coffee, you change your mind, you want a latte. And throughout the days, or one of my employees or myself, instead of pressing the right key, we press the wrong key. And then you have to go in there and correct it. Because
And when would you go in and correct it?
while the transaction is going on, you can't close the transaction out. You can't cash it out until you put in the product.
And would that be reflected in your Z-tape,
Yes, it would
the
be.
adjustments?
Right.
Oh, okay. And to the department, which number did you use?
We used the sales off the Z-tape for.
All right.
And you didn't include any voids?
No, you wouldn't.
It wouldn't automatically exclude them. All right. I thought we had something. Tried. Thank you. Further discussion, members? Member Amon moves to take the matter under submission, second by Member Runner. Without objection, members, such will be the order. Thank you. Ms. Richmond?
Our next matter is item C11, Elton, Justin, Hoiles. Please come forward.
Ms. Sanjija, as the taxpayer comes forward, would you please introduce the issues in this case?
Mr. Chairman and members, the appeal before you presents one unresolved issue, which is whether adjustments are warranted to the disallowed claimed exempt sales.
Thank you very much. Sir, as you settle in, thank you very much for your patience. Noticed you've been in the back very, very patiently waiting on your opportunity to present. So I just wanted to extend our appreciation for that. And welcome to the board. You have 10 minutes to make your presentation, and we will return and allow you 5 minutes on rebuttal if necessary. We'd ask that you commence with your presentation, with your introduction for the record.
Yes, my name is Michael Hoiles, and I was the owner of Mick's Cafe, and I am Mick. The papers they gave me when I first came in was more of the products that they taken view of at the cafe off of Yelp, which what we done, we was a cafe, we opened up, and our building size is 368 square feet, and our permit originally was to go only, and it was a coffee shop, and the outside place, which the photographs are taken of, was belonged to the company next door, an antique place. She done landscape gardening, designs, and all things like that. And everything, all the products, all the chandeliers and the mirrors and all that was hers. But this walkway through, because it was like originally it was where we transferred our place over, made it out of, was a garage at the back of a building. And you'd have to, originally was the driveway. So that was free access for us to get to the back. And we got very friendly, obviously, with the girl next door. And she let us start using her tables and chairs because she had lots of them. These iron, this is one of the things she specialised in, was these wrought iron, antique, shabby chic type setups. And she designed the garden originally, and for her customers to see. Now, on this here, as you can see, and also the type of cooking that we had, facilities we had. We wasn't originally, I mean, say on some of the paperwork you got here, we wasn't allowed to cook. But what they regard as not allowed to cook means you can have a microwave, you can have a panini, and you can have a 9-inch heating plate. And that was our total cooking facilities for heating anything up. We specialised in, originally for organic coffee, and specialty coffees, and we've done sandwiches, organic, and salads. And because we originally, when we first opened, we weren't allowed to serve out, we initially started doing business by taking sandwiches and things round to the shops. But we found out it was better for us to take the orders first in the morning when we was quiet and deliver them later. We'd probably do 8 to 10 a day of that type of business. But the to-go food was always cold for the simple reason we made it. We used to send one of the girls round because we had basically the same people. Sometimes it was like doctor's offices, the banks and all those sort of things. These are regular customers. Then we had like boutiques who had like 8, 9 girls in it and big boutiques there. And these were our regular customers. Not every day, but when you shared it out amongst the top, we'd probably average about 10 a day. Now, we tried a couple of things to make the business work really good. Because we couldn't cook initially, I bought in food from a commercial kitchen to try and do an evening meal. And we'd done a fixed meal initially. This is how we first done it. It was a fixed meal, 1 meal only. That's all they had. Because I could buy it from her, I bought like 20 meals from her. Then it wasn't really working. So we thought we'd do it just for a couple of weeks. So after a while, we decided not to do that. When we closed again in the evenings, we didn't do it anymore. And plus, we finding a lot of the customers felt it was uncomfortable. It's cold at night because we're near the beach, and it gets cold at night. So we found that people weren't too happy with that. Then we had another go later. We thought, we do easy stuff. People love pastas. So with pastas, what we would do is we would have one plate, we'd boil up loads and loads and loads of pasta throughout the day and put it in small bags. So then cool it and put it in the refrigerator. And we'd make the sauce, and that's how we was going to do the pasta thing. Same with the soup. We'd make it one bowl of soup, we'd have it in a pot, let it get cold, and we'd put it in the microwave to heat it up. That's how we served it. That's how we would serve. This is all the food to go. From the very beginning, we was doing about 30%. We was charging tax on of our total sales, but about 30% of over 30% of our sales are coffee as well, which most of the people would to go. When we started selling in-house, when we was allowed to use more of the seats, we would know who was to go and who was to sit, because we'd give a china cup to the people, because the girls would say, is this to go or is this for here? And they go for here, so they give them a china cup. To go, they get a paper cup. And then we had, later on this week on, we never opened again in the evenings ever again after that, because it was absolute disaster. We kept losing money. We tried different promotionals, 2 for 1, to sending it out to older people. We had a few old people come in, getting the 2 for 1 meals, promotion, and that was it. So we decided we're not going to be doing these evening things any again. Then we had a company come into us called Grubhub, and they said, and they looked fantastic. Said, what do you do? This girl comes and done such a sales pitch. Said, oh, we do this, we do that. We get all customers coming. What do you think you're getting? Oh, you'll get maybe 10, 15 customers a day. Oh, brilliant. But what's your menu? You tell me what you want to do as a menu. Well, okay. So we put a menu together, and we've done things that could be cooked up early. Like all the things that we do on there are stuff, and they gave me this here, this today, this here, what we read. We've done this after we've done Grubhub menu, this mixed cafe thing. This is what, and it reads, as you can see, organic coffees, blah, blah, blah. It comes down special events, located, because we'd rent the place out to anyone wanted to do a birthday party because it was pretty and that type of thing, and we'd serve them a meal, whatever they wanted to do. But we done, in the time we was open, I think we done like 10. So it wasn't a great business thing. And this thing here, this letter was initially when we very first opened, and I sent this back to her, and and the way this is like being cherry picked, it's almost like saying, oh yeah, look at this, to compare to this to this, is like almost like lying. Well, that's crap, because the simple reason, this is when I first opened, and this is when I tried to do the Grubhub. I did not get one single order from Grubhub, not one. And even though I'd done some canvassing with a guy who used to go menus for about 6 other shops, restaurants in the town, he went and canvassed for us. It wasn't that great. Wasn't that great at all. So anyway, we packed up doing that. And then after that, we was 4 o'clock close every day. And when they get done this, they looked at our menu and types of things that we've done. I mean, to say the salads and that type of stuff, it was easy to do for us. And sandwiches were easy for us to do. It's quick. I mean, to say, to be able to do all this hot food, the way they're talking about the amount of quantity of what's name, it's totally impossible in our environment. Because if someone could tell me how you could do 50 or 60 meals a day, hot meals, with that type of things, please tell me how to do it, because I can be a billionaire too. That it's just not possible with a 9-inch heater plate, a panini, and a microwave. You have to have certain foods all ready to go. Or the easy things for us was our specialty salads, because we'd have the big boxes of mixed organic salad, and you put it in them. We put our own house dressing, and then we do all from there. We do like a mixed house salad, which was the #1 seller, and about 10 other salads we do, and all this stuff was. And also the people, how we know the people who was in and used to go, is because the people would take it on a plate, order it on a plate and sit in the inside. So. We're saying that what we took taxes on was like about 30% of the sales. Well, the department says, we give you 25% of your things. Well, it didn't take into account of the coffee, which is most of the coffee people come in the morning, because the Starbucks is almost opposite, and we done organic coffee, Starbucks never done, so we got all their overflow. For some reason, I do not know why people go to Starbucks. It's absolute crap coffee. I do not know, and I don't know how we didn't get great more business. We did, but I think it's because where we was an 8-foot wide place up the side of our place, and we was right in the back, and we was the last business at the edge of the town before the school. So it was hard for us, So we had to create our own business, and we're creating our own business was going around. Now, also, they said, when I sent the paperwork into there's about 2 flyers. They go, we didn't see any of these flyers on it. And I go, what do you mean there's no sales of the flyers? Well, then I thought about it. One of them was a children's one, was the children's flyer. It was to a company called Fancy Feet. And what they used to do is they had children who used to go dancing every day there. And people, after they go from school, their parents want them to have a meal, you know, a snack. You know, like we do healthy snacks like yogurts, we do certain salads and certain little things like that we do for them. And it would be $5. And what happens, the parents would do it month in advance. This is the only way we could do it, because we couldn't run round there at 3 o'clock if we was busy in the cafe and take staff off. Otherwise, I'd need more staff. So what they would do is they mark it up. So every day we give them a list of 5 things they can pick from. Like Mondays. Say one girl was in there on Monday and Wednesday, it'd be her name, and then on these other days it'd be different girls. So like we do like about between 8 and 10 of those every single day until like we was into it for about 3 years. Then after that they started doing a bit of the stuff themselves, Fancy Feet. Then because they was doing some of the stuff themselves, it wasn't really worth it us doing it. So we packed up doing that. But we've done it for about 3 years. And so that wouldn't be on the daily tally thing, but it'd be in my takings. And as far as like this business, I mean, they got this all down to my son. Well, my son only opened the business. He got in touch with the department, which is on your thing here, where in April of 2009, he said, please take me off the thing. And they said, oh, you got to close down and open a renewal one. Oh, rules are, obviously you all know what the rules are, you've got to be up to date. We had this maniac kid come into our business. It's my friend's kid who had a problem. And I was like, he's been a good boy now, can you employ him? Sure, I employ him, you know, because he was my best friend when I first came to the States 36 years ago. And I employed his son. He was on Oxycontin. I went, oh my God, what are you doing to me? The guy was stoned coming to work. You know, I said, no, you can't do this to me, Lynn. This is ridiculous what you're doing. I can't have him. So this kid, about 2 weeks after I fired him, smashed through my back door window and took the we just had a regular cash register, but it had the information on it. So he took that because he knew it had money in it, because we used to leave about between $150 to $200, all different types of change, and he used to know that. So he smashed through the back window, took that away. So I got behind with my paperwork to close it out. And then we started to get ourselves straight, one thing and another. And I'm still trying to run a business, make it go hard. I mean, to say, I'm there every day, in the morning, the night time, whatever. You know, for 4 years I was there 7 days a week. And so that was one situation. Then, about 3 months after that, he does it again. But this time, we put bars up and we put an alarm in. But he smashed through the front through the door in the place from the patio, and the alarm didn't go off because the alarm setting we had put in, it wasn't set high enough. So he managed to take the till again. So the third time he tried to do it, he couldn't get through. He tried to smash the door, the alarm went off, and he ran away. Well, he got caught by bragging at school. And this was like a screw up with one thing, but anyway, he got convicted, he got probation for whatever thing. Unfortunately, not for my fault, my friend, his son, he's ended up ODing and he's actually dead now. And it's just one of those things. But these are the sort of people I had around me. It was like ridiculous, it was driving me mad. And then, so we got a POS system. And we was doing everything all right with the POS system, doing all our books and all that. And most of the stuff we kept we had this little office, which was like 7 foot by 6 foot. We kept most of our stuff in there. So some of the stuff I stored in my place at home. We had a fire, but not all the stuff got destroyed. I had all my bank statements, all the receipts, everything, things. There was no PO things, but I didn't care because everything was in the POS. You know what I mean? I knew how everything worked. So the fire destroyed some of the stuff that I couldn't give to the auditor. But the auditor did have all the bank statements, every purchase, every credit card, all the information. And the auditor come up and he said, yep, the sort of credit cards for this type of business to the amount of cash that you put in is correct. So they know we wasn't up to skullduggery, is like almost like suggestions in these sort of things. It's like slants. I mean, see, even that I almost take as a slant. It's like, oh, you gave us that back in the beginning of your business. Oh, but look what you did. We're really doing. It's not the case. Believe me. So anyway, the other thing I'm going to ask you is, please, if you can, take it out of my son's name and just leave it to me. I'll sort out anything you do. I'll pay or whatever you want me to pay. You can do what you like with me. Just don't do it to my son. He asked for it to be out. I put my name on every single return as owner. And I have very good reasons for you to take it out of his name.
Thank you very much. Ms. Richmond, how's our time clock doing?
We gave him a few extra minutes.
Okay. All right. Thank you very much, sir. To the department, you have 10 minutes to make your presentation. We'd ask that you introduce yourself for the record and commence at your convenience. In the process of making your presentation, I'd ask that you address the argument of inconsistency and inconsistency in the activities. There seems to be various different activities taking place at different times, and if your test period doesn't reflect that, I understand you use recorded amounts. I get it, but please address it.
Okay. My name is Scott Lambert. To my right is Kevin Hanks, and to Mr. Hanks' right is Stephen Smith, all representing staff. In this particular case, the taxpayer operates a cafe. The taxpayer's records were not available. The information to work with was very limited. There were no cash register tapes. The department ultimately ended up accepting the total sales that the taxpayer reported. So the only thing that is at issue is the claimed non-taxable sales. There's only 3 cash register tapes that support any type of non-taxable sales. There is no other information to support it. The 3 copies of the cash register tapes were included in the decision and recommendation. It'll be at the back of that. If you take a look at it, there appears to be inconsistencies, irregularities in the cash register tape. If you look at the first day, which is March 8th, 2012, they sign in at 9 a.m. The first sale doesn't take place until 11:48. There's only 4 sales before 6:53. There's large gaps between times, starting at 6:53. Then there's a sale at 6:54, 6:57, 6:59, 7 o'clock. It appears to be inconsistent. The taxpayer's testimony was also that he started closing at 4 p.m. I'll point out that the cash register tape indicates 7:12 p.m. The next register tape shows 7:33 p.m. The next register tape is at 6:31 p.m. This is all in March of 2012. The other cash register tapes for the other 2 days are also have the same inconsistencies. The taxpayer claimed on their returns, on average, that 71% of their sales were non-taxable. This is consistent throughout the start of this business. The taxpayer started June 2008. The audit takes place, the first period is July 2009. So basically the taxpayer was in business a year before the start of their audit period. But what I say is that the returns filed for the first 4 quarters of the audit period are consistent with the returns filed subsequent that what's in the audit period. So there is no major fluctuations in non-taxable sales that are being claimed throughout the audit period. It's relatively consistent, which seems to indicate that there would seem to indicate that there wasn't a change in business, but we have to go by the information that's available to us currently. When the taxpayer was sent a letter dated October 22nd, 2010 from our return analysis, and they were questioning the amount of claimed sales, non-taxable sales. Taxpayer indicated he had no seating, that they had a limited hot food or facilities for hot food. If you take a look at the department's exhibit number 2, indicates the taxpayer has an outdoor grill barbecue, which is consistent with the department's exhibit 3, pages 1 through 3, that indicate the types of food that is being sold by the taxpayer. There is ravioli, spaghetti and meatballs, shepherd's pie, chicken marsala, chicken curry. There's a number of taxable items, bowls of soup. The breakfasts are omelets, panini, muffin, scrambled eggs, quesadilla. There's a number of taxable items here. If you take a look at the department's exhibit 5, page 2 of 2, it's a Yelp comment. It's the taxpayer, Elton, responding to a complaint about the business closing when it rains. This is a quote, "Again, we are an open-air cafe, so when the weatherman says it's going to rain that night, we will close, mainly because our customers don't want to get wet while we are eating." If the taxpayer was mainly selling to go, it would seem unusual that the taxpayer would close their business if a major portion of it was not for consumption at the facility. If you take a look at Exhibit 6, it shows the dining area, which is tables covered in white linen. There's also Department's Exhibit 6, page 2, page 3. They also show the taxpayer's facilities, which is, and we have to go by this too because there's just a lack of record, is the Yelp comments. And the Yelp comments indicate that taxpayers are making comments about them eating at the location and that they like the cafe setting, like an English tea garden, and that's part of the draw. So the department, based on the experience and the information that we have available to us, gave the taxpayer the benefit of the doubt and estimated that 25% of their sales were non-taxable, and we allowed that and disallowed the remainder. In regards to the son, who is the taxpayer, Elton Justin Hoiles, he is the one that took out the permit, signed the return. He also indicates on the ACMS that he electronically files the returns. The bank account was in the son's name. There was a note in our ACMS comments early on when they took out a permit which said that the son was not the owner. They were advised to close out the permit and change the ownership. They were advised twice of that. They never closed out the permit, and it remained in the son's name. So accordingly, the department concurs with the Appeals Division decision and recommendation.
On rebuttal, please.
Okay. On these Z-tapes, the only reason these Z-tapes are here is because there were things that was wrong with them. If you look at the top of it, Edwin, salesperson, short, $47 again. This is for my youngest son, Leon, to check out. Then I've got minus $30. What's this? Right? This is what I've got. On this here, other ones here. There's another one with a girl missing. Christine, salesperson, did not close out. 9 sales. I had to close them out myself. Why? Talk to Christine tomorrow, ask her why. I want them closed out at sale. Well, what they would do, the things, it's like they're saying like they're not open at the time. It's when they closed it. They go in and they close these things. That's the time it goes in. Not when they print it out to the customer. They do it out. They do the thing out to the customer. They would close when they actually go in and close it, and they usually close it when they punch in for their tips. So I could use the credit card, or they know how to do it. They would get their tip added to the credit card. That's the ones in the side, and that's why they're saying. And the ones at the end of the day, it's like ones that are closed out. It's ones that are not closed out. I closed them out. I used to sit in the cafe after we close out, maybe 4:30 after guys are cleaned up, and I would sit there and I'd look through things and I'd read stuff, whatever it is in the office, because like it's just one of those things I'd done. I'd play around on the internet, surf the net. Then I'd go out and I'd do the till, take the money out, and do the things. That's why these things there's different times, the sales and that. And as far as I didn't give them much to do, I got a guy to put all the things together. This is for their auditor guy. Who I got someone to put them all together. Every single receipt that I bought stuff for, all the reports from the credit card companies, all my banking, the checkbooks. I gave them everything. I gave them everything I could give them. And what was the other thing I didn't like? I was saying you said about the the things on the table. Yeah, we would try and do parties and try and sell. I was doing everything I could to try and get business. You think you had things on tablecloths when you got a coffee shop? No, it was like for an event. We would take pictures of events. And a lot of the things, those eating things, we had friends who'd come in and they would say, oh, sorry, I should be talking to you. Yeah. Sorry. Friends that come in, I'd say, you like to pay, do us a favour, do us a good Yelp, yeah? Or customers come in and they go, oh, really like your place. You like it? Just do us a Yelp. But the point is, there's 47 Yelps or something in there. And of the 47, that's over 4 years. That's one a month. It's not like a million people coming in and eating. You know, people take a coffee to go. Don't Yelp, yeah. And you can't ask me. Oh, you're going to go? Please give me a Yelp. And what's the other thing? In the things that they've done, they listed every single thing. But this is the woman come in. This is her, the mother of the guy who owns Yelp, and she said, "Oh, I'll go there." And apparently she has thousands of Yelps. She goes around, and this is what she said about the thing wasn't about all the stuff, all the tables. Mixed Cafe describes itself as an English garden, and that it was. Yesterday was foggy with thick marine layer that lingered all day. I can imagine how spectacular this pretty cafe would look with filtered sunlight hitting the mirrors and chandeliers, with this space so generously adorned. See photos. Then she's got all of these beautiful functional art creations are for sale via the adjacent space called Care Design. Then she's got my next review. You know, it's like, I don't care what you do to me. I'm just so sick of it up to here now. Just let me pay whatever you're going to do to me, do it today. I need to get on with my life, and I'll pay the interest on it until I've got enough money to pay whatever you want to do to me. Just don't do it to my son.
Thank you.
He's not to blame for this mix-up. And I put everything in every penny I took, I banked. And was it a crime to try and make because I couldn't work. I thought I'd start a little business, a little coffee shop, and do things. It's not fair. Life's not fair. I'm sorry. But you've got to make the decision. Please give me a decision. Let me know what I'm doing with my life.
Thank you very much for your rebuttal. Members, I'm going to ask Chief Counsel to come forward, if you will. I just want to explore the request of the taxpayer to assume the liability or hold his son harmless of the liability with I would guess there would need to be relative to the protection of the fiduciary responsibility to the state that somehow protect on the liability actually being paid. Any thoughts on that? And an answer of no thoughts at this time is good. We can figure it out later if you like. No, I'm talking to General Counsel.
I guess
Please introduce yourself.
Randy Ferris, Chief Counsel. I guess appeals, do you believe the period is still open because of the petition being filed, or?
I have some thoughts if you guys.
No, just is the audit period still open for a dual to ownership?
No, questionable ownership will have passed. Statute of limitations to go.
That's what I'm asking. Is it open?
My
It is not
apologies, gentlemen. I would ask that you speak into the mic so we can get this conversation on the record.
Statute of limitations for issuing a new notice of determination under a theory of a dual, like a questionable ownership, that will have passed. And a 6829 wouldn't be an option yet because the business hasn't closed.
Not the sole proprietor.
So
The business is still operating?
No, it closed in 2012.
It's a sole proprietor, 6829 can't apply.
Oh, sole proprietor.
All right. So, I mean, the practical solution would be for the father to pay whatever liability on behalf of his son, so that no collection activity would be taken against the son, if that's the father's intent.
But I would like to get some sort of reduction on things because
Okay.
those numbers are so towards.
Sir,
Sorry.
thank you very much. Thank you, Mr. Ferris. Appreciate it. They said there's a, as I understand the testimony of General Counsel, is there's a way to avoid any collection activities against the son, given the assumption of the liability from the father and the payment of the liability. Discussion, members? Member Runner.
Let me just, I've got a couple quick questions. The seating that's engaged here. Where is the seating? The seating's not on the taxpayer's property or where the restaurant is. Is that correct?
I'm not exactly clear
Okay, let
as
me go ahead and ask the taxpayer there. Tell me about this. Tell me about the seating, because I've got pictures of seating here.
Okay.
And tell me about the seating.
Use the
Okay,
microphone,
seating?
sir.
Oh, sorry.
That's okay.
Yeah, that's good.
Yeah, that's good.
Mhm.
Yeah.
No, it's not working, is it?
Yeah, yeah, it's working. You're on.
Yeah. The seating was Care Design's seating.
And who is that?
Care Design is the antique shop next door.
Okay.
And she rented that space from the shop at the front, up the side. But when she got the thing was that they still had access to the office at the back, which was an office before I converted it to a cafe. And I got very friendly with Care Designs while I was thing, and she let us use the tables and chairs that
Did
she
she
had
have
there.
tables? Who put the tables in there?
She did.
Who owned the tables?
Care Design.
So she owned the tables. She put them there. Did you have any kind of contract with her in regards to the use of those tables?
No, just for.
Could she remove those tables
Yeah,
the
when
next day?
she used to when she sold, and she used to sell them, and she had lots of different things. She would do.
So she would put these tables out on display.
Yeah, this is how it was. It was like a whole English garden, the whole thing, because that's how I started.
So
it.
so
She
this
said
was
like
this was a display that was next to your
Yeah.
restaurant.
Yes.
And people could then buy from you.
No, not from me. No, from
No. Buy the food from you.
Sure, yes.
Could take their food and take it to her seating.
Yes.
And her seating was for sale seating. It was part of her display.
Yes. And the mirrors and the chandeliers, all the pots, all the things, antique pots, shabby chic pots, and all that stuff. She had the things with the.
Okay, I get that. So, and you had no agreement with her. She could decide one day to take all those chairs out.
If she wanted to, but the point is, I think it was almost like.
But she wouldn't because she was selling them. Is that
Yeah,
what-
because,
no.
and not only that,
Yeah.
with the cafe, she loved it because like people were coming through
Right.
now,
Right.
coming through.
So she saw it as to her advantage to
Of
have
course
these
it was,
chairs there.
It was to her advantage because her sales went up quite a lot after the Care Design. But Care Design actually moved out about a year before we did.
Mm-hmm.
But she left loads of her stuff there, loads of it, all the chandeliers, all the pots, and that, because they had hanging tags to show where a new place was. And we would say people, give them the cards.
Okay. So she had.
But we did buy some chairs. But we bought like two big tables after when she moved because she
during this audit period.
What do you mean? No.
Was it during this audit period that you bought those chairs?
But they ordered this for 1 year. Is that what you're talking about? No.
Okay. So during this audit period, she owned the chairs.
Yes.
She owned the tables.
Yes.
It was in her space.
Yes.
She was paying the rent for that space.
Yes.
You were not.
No.
She had control of that space.
Yes.
Let me just ask, department, does that make any difference?
I don't believe so. I think.
And why would that not make a difference?
And I think that the reason would be is the taxpayers' employees had the customers and were serving food to the customers at those facilities, and so they were the ones that would bring the food out.
You were serving those tables.
Yes. I girls who we used to do. They used to do
Okay,
this.
just hang on. Just,
lunchtime.
so you were serving those tables. It wasn't somebody was coming to your counter, ordering your food, getting their food, and walking and taking their food to those tables. You actually had people.
Yes.
Serving those tables.
Yes.
Okay, thank you.
Member Harrington.
Can I make one comment about?
Member Runner?
Excuse me.
Yeah, if you want to clarify, go ahead.
Yeah, there was one other thing said about a barbecue. Where the health department said I could have a barbecue grill, and we had that in the car park. And we tried that but it just didn't work. Because going out there and trying to do it, we tried to do hamburgers, and we would do like a smoked salmon, grilled salmon. That's what we tried to do.
So you used it barbecue for a short time.
Less than a month.
Okay, thanks.
Okay, I had to step out for a minute, and I apologize, but did this menu issue ever get settled, or all of these menu items?
What was that?
It's just tons of menu items for salads and off the grill and soup of the day and desserts and coffees.
Yeah, that was things we offered. We offered all the time different things. You know, we with the internet also with Yelp and that makes you look something you're not. Makes you look like you're a big beautiful place. Though the garden was a lovely garden, we weren't. It wasn't that sort of business. Believe me.
It wasn't a part of your business. So I could go in there and order 4 cheese ravioli. You would have that.
So, if it was the period when we was open in the night time, we closed. Remember, we only had it was open 3 periods night times. 3 periods we opened at night times, and it didn't do that much goodness business for it. I just thought, well, if we can put our takings up this much money, my expenses are all the same basically, except for the staff who would work it. You know,
I don't want to get too much into. I'm just trying to find some questions.
Oh, yeah.
So you offered all of these items at different periods of time. How large was your facility? How many square feet did you rent?
386 square feet.
Okay, so that's basically the size of a
Small double,
real small
wide double
bedroom,
garage.
maybe a large bathroom. It's not a very, very large spot.
No.
And you had what kind of equipment to cook with?
A microwave, a panini grill. It's like a
Right,
one of those
I know what a panini grill is.
panini grill, and
9-inch server plate.
oh, and a 90 plate. That was the
Okay,
maximum you were allowed
so,
to do.
and you were
I had
able
to
to
think
make,
myself, I'm
you
all
were
right
able to
with that.
make all of these various entrees because the tuna salad bowl was cold. These things were cold. Okay, I understand it. And although you periodically served food outside, primarily those chairs outside and
Yes.
whatnot were owned by the lady. How frequently? Because
We use them every day.
Okay, you use them every day.
Yeah,
You're not
we-
helping yourself here.
No, I'm just telling the truth. you
I know. This is just very, very difficult. So you think that like 71% of your sales are exempt as cold
Yeah,
food
for
go?
the
How
simple
do you
reason,
justify
30%
that?
of it was coffee, most of it in the morning. We're busy coffee in the morning because all the mums going to school in the morning, they would stop in, and after school they would stop in as well for coffee. But mostly in the morning. Starbucks, because in the morning Starbucks in the Palisades is slammed, and people they didn't have to wait at our place, you know. And plus they got better coffee.
Okay, so you mostly did coffee and cold food. You had this.
So
and
if
you-
they take the cold food, they giving you 25% of that, and with the coffee, which was like about at least 25% of our stuff would go, because people when they eat, they don't always have coffee with dinner, or you know with their lunch. You know, they have like a iced tea or ice drinks or something like that, or juice. Or some people just come in and have a smoothie, you know, and that was it.
Okay. This is really hard. The department, you've been here, you've sat here with us, and you've heard the story. And you understand what some of the issues are here. Is there any, can you see in your review of the file where there's any wiggle room for you whatsoever? And that may be an unusual question, but I want you to think about it because you're more familiar with the file than I am.
Right. I guess I would have to go back to the Yelp reviews, and I mean, basically, that's what we have is the information from the internet and the taxpayers' testimony. People enjoyed sitting there, so if you came and got coffee and you sat down, it's going to be a taxable transaction for, if you're not asking for here to go and they're sitting down, that's taxable. And
Yeah, I know, we've heard that all day long. So I just want to know, I mean, this is really got, there's a lot of exceptions, I think, in this particular case, and the fact that the menu is changing. The Yelp reviews, truly, there weren't that many of them, and the one lady said that it's like an English garden back there, and then we find out that the English garden is actually not owned by him or occupied by him, but he does periodically serve out there. So, there are, the department is probably correct on saying, yeah, he did serve, and yeah, he didn't ask to go or whatever. But I'm just thinking that the amount of to go versus eat in, I'm just wondering if we've got any flexibility there at all. Okay, thank you.
Yeah.
Ms. Harkey?
Yes.
We're just considering it here, and in our experience, we've seen some other similarly established businesses with as high as a 40% exempt non-taxable ratio. That's higher than what we've considered to date, but it wouldn't be out of the realm of normal to see something like that, 60% taxable and 40% exempt.
And what are we assessing now?
75 taxable, 25 exempt.
So 60/40
Correct.
would not be out of the range.
Correct.
Okay, you all heard that. Okay, thank you.
Mr. Hoiles, your testimony is that this additional table space was owned by someone else? And you did not have a contractual agreement with her, verbal or otherwise?
Eventually, when she did leave, so no one else didn't come in there, I rented the space off the woman who had the front shop.
And when did that occur?
About a year before we actually closed.
And how does that relate to the audit period?
It wasn't nothing to do.
Wasn't in the audit
No.
period? And so it's my understanding you did not have a verbal agreement with them to use that space. And
All I had was access through it, walkway, they're allowed through it.
okay,
Access.
I understand that you
Sorry.
did serve the area. I get that, but department, did you have any evidence that there was a contractual relationship that?
We
he-
don't.
Nothing?
Well,
just-
no.
You don't? Okay.
We do not. What we didn't have much records is, because of the fire and the theft. So we used what we had, and, from the pictures and the comments that are made by the customers, those those directly indicate that the taxpayers' employees were servicing those tables by bringing the food out and also by coming by, checking on the customers, and also cleaning the tables after the customers were done.
Yeah,
So-
I get the,
and the-
it's kind of like a catering use of someone else's facilities, and you're actually catering the product. What I'm going at is were there any situations similar to when you're in a mall and, where you're in an area where there's common area that you're not contributing to the cost of that common area, and the sale takes place inside your facility, and it's eventually, then it's taken out to the non-common area by the customer?
Yeah.
And it's, let me add one more variable here, and it's cold.
Right. Well, what you're referring to is at a mall, if you have a common
No,
area.
not a mall. I changed that.
You changed it.
I understand. It's not a mall.
All right, not a mall.
This is just an area
Yeah.
where, similar to the area that the taxpayer has,
Okay.
There's a common area that's shared by, anybody wants to walk through there, evidently
Right.
can walk through and sit down, or I don't see any, I didn't hear that there was restrictions. And are there any situations where there's cold food that is sold and they take it, go over there and sit down and have a bite to eat?
Yeah, I don't think that's the situation. I think that would be a taxable situation. It was a benefit to the person that owned the art shop, because what you do is you get those customers in there and they're taking a look at
By
your...
virtue of that benefit, you think that's compensation? There's a
Well, there
mutual
was
agreement?
I think that was the reason why it was beneficial for both parties to
Well,
do
it's
that.
still not a
And,
contract. Yeah.
and I
Benefit's
don't...
not sufficient to
I don't-
establish a
Right.
change of give and take.
Obviously, I don't know if there was a contract or not. The person had left beforehand. We did go through, we audited through the closeout date of the business, so if there's any tables and chairs bought before that, it would be included in our audit period. But there is a new owner that has taken over, and they have a similar establishment that they're with new tables and chairs, but I don't know what the I don't know what the arrangement is with that.
All right, thank you. Further discussion, members?
Just real
Member
quick,
Runner.
just on those tables, could anybody sit in those tables? Like, if somebody wanted to go there and sit in that table, and just sit there?
They could do, but we discouraged it, to be perfectly honest. I know you're saying you're not helping yourself, but I'm just telling you the
Yeah.
truth.
You discouraged by telling them to get up and move?
No, I just say, don't touch those salt and peppers or something like that.
Gotcha. They
Because
were
we
preset
had
with those things. Okay.
we had a problem with a couple
I got
of
it.
bums.
I'm good.
coming
Thanks.
there, you know?
Okay, members, I'm going to do something unusual. I just asked the chairman, I'd just like to make a motion now so that this gentleman could know what we've done. I would like to move to use a non-taxable ratio of 40% based on the department's testimony that could be acceptable, and to also ensure that collection efforts are transferred to Mr. Hoiles.
So moved. Second by Member Stowart.
Offering
Michael
compromise
Hoiles.
as well.
Noting to notify the taxpayer of offering compromise. Discussion, members, without objection, such will be the order. Sir, the Board of Equalization has moved to make an adjustment in your favor of the taxable liability. We have also asked that the department meet with you to discuss how to relieve your son of any collection activity, and they will have that discussion with you and do their best to accommodate your requests and your assumption of the liability.
Can I just pay the interest for a little while until I get myself straight?
We'll have to work that out with them.
Oh, sorry. I didn't.
You're closed out, right?
Yeah, business is closed, yeah.
So I would encourage the department to discuss the offer in compromise so that we can finalize the whatever, not, I don't want to say liability, but whatever amount is determined by the department to be due as a result of the evaluation of the offer in compromise. And then at that point, the shifting of the liability if possible. Okay?
Yeah,
All right.
they'll explain to you what the offer and compromise options are.
Okay.
It's-
Thank you very much.
Thank you very much. Good luck to you.
Thank you.
Thank you for waiting.
Ms. Richmond, what is our next case?
Our next case is item D, Special Taxes Appeals Hearing. Item D1, Kerolos H. Guirguis. Please come forward.
Mr. Bachas, would you please introduce the issues in this case, please?
Mr. Chairman and members, Chad Backus with the Appeals Division. The appeal before you presents one unresolved issue, which is whether the seized tobacco products should be forfeited.
Thank you. Welcome to the Board of Equalization. Sir, if you would pull your mic close in the event that you decide to testify. Please be advised you have 10 minutes to make your presentation. We would ask that you commence with your introduction for the record.
She's my fiancée and she's the manager, so can she do it?
Yes, I will speak on behalf of Kerolos. So real quick, let me just do a quick introduction. First of all, thank you very much for giving us the opportunity to come and speak before you today. Bear with me, we're a little nervous, and I know that you guys are very tired. So last case, so we'll make this quick and easy. Again, my name is Elizabeth Guirguis. I am the manager. I kind of help my fiance Kerolos, who Kerolos Guirguis is the owner of Orange Hill Smoke Shop in Orange, California. And so I just kind of help him do all of the administrative kind of work such as this. So before we begin, I just really want to quickly point out a couple of things. Obviously, this is our first store. This is our first case with the BOE. We don't have any attorneys or accountants, no offense to anybody, but we're here literally to represent ourselves. We're here to do the right thing and just kind of find a resolution. So as we go through this case, this will be kind of a deja vu to your kind selves, as this is exactly more or less the same case that you heard on November 18th with Mr. Sharif El-Fayek, who is a friend and who owns several smoke shops and cigar shops down in the San Diego area. So, I'm very aware that this case is really for the release of the cigars, questioning the release of the cigars. And, to be truthfully honest, I know very well that that's more or less impossible. However, it was really important for us to come here and speak before you today just to really get a point across, tell our story, mainly because, unfortunately, we were frauded. At the end of the day, we were duped by the cigar company that sold us these cigars. And so I provided a packet. I apologize in advance that you guys did not receive this packet, a couple weeks ago. Was out of town for work. So when you open up these attachments, in order you will find the first invoice and the only invoice that we have for Sublime Cigars based out of Florida. Also correspondence between us and the owner of Sublime Cigars, which is Mr. Thomas Jarmirski. And then a couple emails that were sent by other store owners at the same time as we were hit, they were hit as well. So they had correspondence with Mr. Thomas. A couple of sworn statements, one by Mr. Basharoun, who is the owner of Tony's Fine Cigars, and also Mr. Sharif El-Fayek, who was the owner of Almond Smoke Shop, who was here on November 18th. The last two pieces, just to have for your reference, is we have the first page of the file of class action lawsuit by our lawyers. We have raised a case against them, and we are in the process of it. We'll go through that real quick, and then the last thing is, when the investigators came in, we were very emotional, as we've only been in business at that point 4 months, and so we found out that our names were on Sublime's website, and that's kind of probably how this all came about. Not that this has very much relevance to you, however, it just kind of shows that he put, for California, 15, 20 stores on his website, and today there's only 2, because it's obvious that everybody else has a problem as well. So I just wanted you guys to all have that. So as I mentioned a few minutes ago, the most important thing is we want to get our story across. We want to explain to you why we're here and what we're hoping the outcome will be. Quick background, we opened our store on October 15th of 2014 in Orange, California. 4 months later, on February 25th, 2015, 2 BOA investigators came into our store, which we were under the impression would be a very clean inspection. We had all of our paperwork in order and ready to go. We had a feeling that it was going to happen, and it ended up quite different. Coming up, just, this is our first store, so we had to kind of ask for guidance from other store owners and friends to understand exactly what is it that we should purchase and who to purchase it from. After we obtained our licenses, our tobacco license and our retailer's permit. In regards to cigars specifically, at the time we had reached out to 3 companies, Phillips & King, Xander & Gregg, and Sublime Cigars. In each situation, we would begin the conversation with the companies providing licenses and permits that were required to set up an account and then kind of go through the whole order process. So in the case of Sublime Cigars specifically, it was the first week right before we opened up, and we had the store ready to go. It was probably about October 2nd or 3rd. And it was our first order and, again, our last order. And the person that introduced us to Sublime Cigars is also a friend and store owner, Mr. Nabil Basharoun, who started the communication for us on our behalf. Kerolos was there at the time. Spoke to Mr. Thomas with Mr. Nabil and notified him that we are opening up and we would like to buy some cigars. Long story short, we provided him our retailer's licenses and our tobacco licenses. He set us up and he provided us an order. And the order was, the invoice was on October 9th of 2014. We specifically asked him, 2 questions. Can you sell in California? Can we buy from you? And are taxes included or taken care of? And his response was, yes, California taxes he said specifically taxes are included in the price of the cigars. And then this is where we got really confused on the actual invoice. At the top, right below the total due, it says tax exempt, yes. We didn't really understand what that meant. We assumed that meant that taxes were included, based on also the verbal communication between us and Mr. Thomas. So after everything was set up, I guess at the end of the day, he knew, Mr. Thomas knew that he was not supposed to sell to reseller, to an owner of a business that holds only a reseller's permit, and that he should only sell in California to a distributor permit. And at the time, we were just opening up. We didn't even know what a distributor's license was. He honestly maliciously sold to us and to all of these other stores. As a side note, the BOE investigators were really sympathetic to the situation that we had just opened, and they could tell that we were trying to do the right thing, and that it was a simple and honest mistake that we simply did not know. And asked and kind of gave us some pointers on what would be going on next, and that basically we found out from that point that all these people the BOE must have been notified something about Sublimes, and that's how we were kind of targeted. So I actually took it upon myself to call every single person that was on this list. And I notified them that, hey, there's a problem going on. BOE is going around, not trying to tip anything off, but we were under the impression that that he was paying taxes, and it turns out that he was not paying taxes and that he was frauding all of these stores. So, at the end of the day, today we're kind of here just trying to we're really trying to recover from this, because this is our store, this is our baby. We put in all this blood, sweat, tears. We put off our wedding for 2 years, really for this store. Every penny went into this store. And at the end, we lost $1,500 or $463 worth of cigars, of which, when the BOE investigators came in, they found majority of the cigars in there, and to be truthfully honest, whatever was taken, a huge chunk of them was, we were buying them for our customers, trying to kind of bring in business, like, hey, thank you very much for coming in. Here's a cigar on us, you know, all of that. So, what we're trying to do is, you know, first and foremost, you know, we are definitely learning more about the process, understanding what we can and can't do, understanding that if there is a distributor license. We are looking into purchasing or applying for the $1,000 distributor license. We're making sure that on every single one of our receipts at the bottom, it says that CA tobacco taxes are paid or are being forwarded, because that's something we did not know, and it wasn't until the BOE investigators pointed that out to us that we were able to understand that process. Just to let you know what we are suing Mr. We're almost there? Okay. We're suing Mr. Thomas for fraud and breach of contract. Right now, we have a default proof of package in place. You know, again, I apologize for taking too much of your time. We just want you guys to understand that, you know, this was an unfortunate misunderstanding. Had we known the rules and regulations a little bit closer, I do realize that, you know, it is our responsibility, but maybe if we had a class or something that would have helped us to kind of understand what was allowed. And, you know, again, when you have the time, you can go through and see the correspondence that he sent to us. And one thing that stands out is he says, we're not responsible for your ignorance. So it's just blatantly an attack that he knew and didn't care about our store or the other stores' well-beings. So that's basically it. Do you have anything quickly to say? Okay. So sorry for that, and thank you for taking the time to listen.
Thank you. Members, let us go to the department. The department has 10 minutes to make their presentation. When asked to commence with your introduction for the record. It doesn't appear, correct me if I'm wrong, but it doesn't appear that the appellant is requesting the merchandise be returned. Is that your request?
Ultimately, yes, since this is the hearing for the return, we are requesting that that the merchandise be returned. However, on a larger scale of the issue, our concern is, and this is not for this hearing, but we'd like to, you know, make this as on the record. We received a 20-day closure notice, and the bigger picture is, as a brand new store, we can't afford 20-day closure notice or 20-day closure. And once this is resolved, we'll go to the next point. But yes, we know that we're not going to get it back, but we are requesting it.
Okay, so.
Is that the best way to say it?
Yeah.
We got it.
Okay, so the department should speak to the request in addition to the request as far as the 20-day closure and where we are in that regard. At your convenience.
Sure. Thank you, Mr. Chairman, members of the board. I'm Pamela Mash from the board's legal department, along with Jake Heflu and Steve Smith representing staff. The tobacco products in custody cannot be returned because tax hasn't been paid on these products. As you're aware, under the Cigarette and Tobacco Products Licensing Act law, when the board discovers that a retailer possesses tobacco products in which tax is due but hasn't been paid, the board is authorized to seize that product. And it's presumed under the Licensing Act that tax hasn't been paid unless the retailer in possession of the product provides a purchase invoice showing that it purchased tax-included product from a licensed distributor or wholesaler. Specifically, the Licensing Act requires that the invoice include the license numbers of both the seller and the purchaser, as well as the amount of tax due or a statement that California excise tax has been included in the total amount of the purchase. In this case, all of the seized product was purchased from a Florida company that is not licensed in California, and the invoice provided doesn't show that, doesn't support the release of any of the product that we have in custody. Neither the distributors nor the retailer's license numbers are on the invoice. There's no statement that tax was included in the purchase price. There's also no amount of tax due shown, and in fact, it shows that tax was exempt, which is incorrect. I understand the petitioner contends that he thought that the purchase price included tax, but the fact remains that the invoice doesn't show that tax was included, and petitioner hasn't provided any other evidence to show that it paid the tax. And this distributor isn't licensed in California, so it could never have collected and remitted the tax to the board anyway. As far as the 20-day closure notice, there actually wasn't a 20-day closure notice. What it is a notice that there's a potential for 20-day suspension in the event that after the citation hearing, not this hearing, if there are findings in the citation hearing that a 20-day suspension is warranted, it could be up to 20 days, but there's no notice that anything's going to be shut down. It's just a potential that could be. And again, as you know, that's for the citation hearing, not the seizure hearing today. Ultimately, the board may release the seized product only if it determines that they were illegally or erroneously seized. And in this case, they were clearly properly seized. They're untaxed. Petitioner cannot legally possess them. They cannot be returned to petitioner. Thank you.
During the citation hearing, will the triers of fact take in consideration the history of this particular vendor as it relates to the advertising that they've been putting out? Okay.
Yeah, sure. By regulation, we have mitigating circumstances that they
And under those circumstances, I know you can't predict, but your thoughts as it relate to the 20-day suspension?
I honestly can't say, but I mean, there's mitigating circumstances. 20 days is the max for this. It could be reduced to 5. It could be reduced to nothing. It could be reduced to a warning. There are multiple mitigating circumstances, including that they'd only been in business for 4 months. This is their first violation. They've taken, steps to remedy the situation and are potentially considering getting a distributor's license. So those things will all be taken into consideration.
And they filed a lawsuit.
Mm-hmm.
Yeah, I can't really speak about the lawsuit.
Yeah.
I think it's
All I
speaks
have
to
is a
them, too.
cover page that doesn't really say a lot, so I don't know.
They give you, I'm sure they'll give you a copy. On rebuttal, please.
Sorry, sir.
Yep, on rebuttal, you have a copy of the lawsuit?
Sure, yes, I actually do. It's right here. I apologize. I could have, I should have.
Can you give us a copy? Us, including
I do
the
have just
department.
a quick question, if I may. And I may misunderstand, I apologize. It says, the citation and violation noted above, you are subject means maybe? I thought subject meant you are subject to the following penalties. 20-day license suspension, the date of your license will be eligible for suspension on 8/24/2015. That was obviously based on us not doing these appeals. So does that mean that, I'm a little confused.
Members, does that, we'll ask the question.
Okay,
Kind
sorry.
of get it out there for you, but does that conclude your rebuttal? Yes.
Oh, I apologize. Sorry. I just have a couple of quick comments to make. That, again, Mr. Thomas only requested at the time the retailer's license and tobacco license. And so, again, we were under the assumption that he could sell in the state of California. And later we realized that he's not only not allowed to sell in California, if he were to sell in California, he has to sell to a distributor that would eventually sell to us. So that's something we didn't know and we found out. And then the only other 2 people that are left, like I said, on that list is from that. The other thing is that I was under the impression that when we buy cigars, since it was our first order, just as when we were opening our store, we went to buy cigarettes, that the taxes were already paid. That's what we thought, but we didn't understand the rules and regulations. And then the other, and I mentioned that before, that this specific order was on October 9th, which was the first cigar order. The last comment I'd like to, quickly make, which is, we do have a lawsuit against them, and it's unfortunate that the Board of Equalization of California are so restricted to not being able to, go out and pursue these companies that are eventually affecting us as California businesses who ultimately pay taxes to California and help our cities and our counties. For us, we feel like you guys should actually sue him. But I know that it's not possible, so that's why we're taking that action. And then the second thing is that, if you look at our the first was $1,463. What would have been taxes on that? $200-$300? For us, it wasn't worth it. And that just goes to show you we weren't maliciously trying to do anything wrong. And then, it's unfortunate because if we know that Mr. Sharif El-Fayed, for example, was investigated by the BOE a week before, and it would have been. I think it would have been helpful if we were warned, maybe, if we kind of all look out for each other, and said, you know, if you are carrying these, you should definitely pay the taxes. Get right, like something. Don't buy from this distributor. Basically, he's a crook at the end of the day. So, sorry about that. I just wanted to throw a couple more things out.
All right, thank you. I mean, as the author of the legislation, I can assure you that they are doing their due diligence as it relates to this individual. They simply can't disclose it to you.
Absolutely. Thank you.
Member Harkey?
I just wanted to ask the department, I'm very concerned with the potential closure for their shop, and I know that's not subject to this hearing, but are you going to be at the next hearing?
No, I won't be at that hearing.
Okay, if you could,
But
you will be?
Jay Kefley will be at that hearing.
I mean, we've heard this story before from the same distributor. This is deja vu all over again. And I would just hope that these individuals that are innocent here and have really been scammed and defrauded would not have to pay a price for closing a shop. So, you know, that's a lot out of their life. And also wouldn't want their reputation tarnished, because I think they're on the right footing of trying to, you know, be sure they're doing things correctly. And, you know, if you need to stop by a BOE office and get any kind of instruction, please do so.
Absolutely.
We're in Irvine, okay?
Okay, great. Thank you.
Thank you.
Member Stower?
Just real quickly, to the petitioner, did you say you guys had just opened your store?
Yes.
You've been open for 4 months?
October 15th, 2014, open date. February 25th, 2015 was the date of the investigation.
To the department, do you know the process when someone obtains their tobacco license? When do they receive informational bulletins on the rules and regulations?
I believe they receive it with the license. With the license. They get all kinds of publications and letters and information. They're not always read, we understand, but they are sent out to the...
It's with the license. I was
Yes,
trying
with
to
the
find a way,
license.
so it's with their important papers, I used to say.
Yeah. And the license was issued in August.
Okay. I'm very sympathetic. I was looking to see if there was any relief through the Victims' Compensation Board to the petitioner, but unfortunately, it doesn't come under that umbrella.
It does not.
Yeah. And I agree with Ms. Harkey as far as the violation. I know that we did change the statute on that to allow less time and even down to 0 days.
The regulation,
The
that's
regulation.
correct.
So
We-
hopefully that's taken into consideration so that this particular business doesn't have to close for any days.
Those are all circumstances that the citation officer would hear, absolutely.
Okay, thank you.
Further discussion, Member Runner?
Yeah, can you read that notice again to me that you received that made you feel like you had a 20-day suspension?
Sure.
Subject to.
It says for this is notice of violation. Cigarette and Tobacco Products Licensing Act of 2003 goes on, says Business and Professions Code violations. The description, sales, or possession of untaxed tobacco for which tax is due. And at the bottom, it says, for the citation and violation noted above, you are subject to the following penalties: 20-day license suspension. The date of your license will be eligible for suspension on August 24th, 2015.
Okay, now, as a reasonable reader of something, why would I not think that I'm just going to have my license suspended for 20 days?
Yeah, I hadn't seen that letter. What I have is a notice in our system that shows a potential suspension for 20 days.
What notice is
and
that?
The notice that she
That
has?
that she has?
Can I look at it? Of course. It's the notice of the violation, so when she...
And who is that from?
That should be from our special taxes and fees.
So we send that notice out?
The Board of Equalization sends that notice out, yeah.
Yeah, I think we need to take a look at that notice.
I think what happens, and I could be 100% wrong, I don't know, but I think what happens is you can dispute this. So what happens is you get this notice, and then you appeal the notice, which is what everybody does. But you're right, the way it says
Again,
it is that it says subject.
If I was a business owner and I got that, I would
Sure.
assume that I'm going to now be
Sure.
closed for 20 days.
Sure.
I don't know if we help them understand that it could, because in reality, I mean, we know how some of these go.
Sure.
It could, if indeed it's reasonable, they've done everything they could be, I would understand that they could probably just get a warning.
Sure.
And so, to me, if I was a business owner, man, there is a big difference between a warning and me closing for 20 days.
Sure.
And so I think we need to review that to see if we, like, throw in an array of items that could happen to you. Something to help at least ease that a little bit. Because I can appreciate, again, a panic of a new business owner saying, man, I just got defrauded and now you're going to close me down for 20 days. That would be a concern. So I'd like us to maybe review that and get back to the board in regards to how it is that we're going to kind of make that a little more clear in that regard. Let me ask you this too. In regards to when somebody gets a license, when they go through that process and we give them all that paperwork, do we give them a list of folks they should be careful of that we know are actively out there?
No.
Hold on, I mean, they can answer. That they know that we know that they are actively out there defrauding folks.
Right. We don't do that, but we do what we
Could we do that?
I don't know that we could because there are lots of people doing all kinds of things that we don't necessarily know about. But we do.
No, I'm talking about the
provide-
ones we know about. Clearly, we can't do anything on the ones we don't know about.
Maybe
But if we,
Chief Counsel can.
well, again, she's a lawyer. She can help me, and if we have a question, we can call Chief Counsel up. The ones we do know.
Sure.
I mean, we do know that there's a history of issue. Are we not able to let them know that these are individuals who are selling that who may be misrepresenting themselves? Do we have a liability at that point, maybe?
I don't know because at the end of the day, we have a list of who the distributors are who can
Right.
sell and wholesalers are who can sell to our retailers.
We have a good
We
list.
have that list, and we
Is
tell
that a long
our-
list? I don't know.
It's
idea.
not very long.
That's not a long
It's
list?
a couple of hundred distributors.
So
And we give that information of where you can find that information to our retailers. It's in the publications, it's on the website, you can look it up, you can call us.
So
It's
we
not
could say
difficult
to them
find.
something like, somebody getting licenses, you should only be buying from these people.
I think we pretty much do say that.
Do we? Do you
You
remember
should
getting
only
something
be
like, do you
buying-
remember getting a list of?
I apologize. I actually would like to just, build on that. Forgive me. I apologize. To be honest, opening a new store, everything's crazy. Paperwork is everywhere.
right, I get that.
However, we know when the investigators came, they gave us these 3 pamphlets that we never got, which is sales of cigarette and tobacco products in California, tobacco control laws, and cigarette and tobacco product inspections.
So
as
when you
well
went in
as
to get your seller's permit,
our tobacco.
your tobacco,
permit. Right.
excuse me, tobacco, you never received those.
We didn't get these. We didn't get this, which is very important to have on our window. And we didn't get the 18 under 18, that yellow sticker that says 18 or under cannot come in, blah. They provided all of that for us. And very good point is it would have been extremely helpful if we had a list of distributors, especially as a new store that doesn't have another store, where we can and can't buy from. That would have helped.
At least where you should buy from.
Or at least
I
where we
get the
should,
idea, if we open a
exactly.
door telling you may not want to buy from these people, that could create some
Understood.
liability. But we could direct you to who is licensed.
Exactly, and actually that'll help us because we were struggling to figure out where to buy products from, and that's why we ended up going to friends and friends who have stores, and let's be honest, at the end of the day, the ones that know the most, or the ones that have the correct information are the authorities, the BOE.
Okay.
So-
I think what I'd like to do, I think we need to do more. And I think right now, I think what I'd like to do, and we'll take this on as a customer service efficiency issue, because I think it fits in that role, to review what kind of publications and when it is that they're distributed to sellers. Because here's what I think is going to be your challenge. I mean, again, you're going to go to hearing, they're going to tell you what's going to happen to you. I think obviously you've got a very good story, and so we'll see. Again, we'll see how that works out. The problem is going to be, we cannot erase your first violation. So as a result of that, the problem is going to be, again, if you accidentally or something gets screwed up again, you no longer are in a first violation issue. Now you have a second violation, and then the penalties become much stricter, and we have far less ability. It becomes more conscriptive from our part as to what happens to you. So in one sense, we can kind of ease out what may happen to you in a first one, but boy, if something else happens on a second one, because you've already had the first one, no matter how light the first penalty was, you are really kind of like at risk. So anyhow, I think we'll go ahead and put that on and to see if we can try to clarify that, because I would hope that in this kind of business especially, we give them a whole packet. It includes lots of different things. And again, they've got to get the license from us. It should be really easy for us to identify who to get it to. So we'll follow up on that. Thank you.
Thank you very much.
All right. I do want General Counsel to speak to the board's ability to say any of that. And the, I mean, quite frankly, I'm very sympathetic, and I echo, and I would hope that, and certainly would encourage the department not to assess the penalty. I mean, not to take your license away for any time whatsoever. You have seemed to have corrected the issue, take affirmative action to do the right thing, and I think that should be taken in consideration, particularly with the first time around. The second time around, basically, the legislature sort of looks at that as, you know, shame on me for the first time, shame on you for the second time, and that's consistent throughout the law. But, you know, I just want to make sure that we don't start identifying. Anyway.
Randy Ferris, Chief Counsel. The board is taking the proper approach by instructing the licensees to only buy from licensed distributors and listing who those authorized.
Or not licensed.
That's the correct approach for something like this. Even if you tried to say it in a fairly neutral way, of here's a list of people that aren't licensed that you shouldn't buy from. Until such time as they get licensed, that can be so fluid that it would create burdens administratively to make sure it's always current in every moment.
Yep, I agree.
Okay, thank you.
Thank you. What's our choice here?
Further discussion, members? Hearing none, Member Ma moves to take the matter in submission. Second by Member Harkey. Without objection, the board will. Such will be the order. Thank you very much for appearing before us. Congratulations on your marriage.
Thank you.
To be.
We'll
Look
see
forward
how
to
that
it. We would be hopeful that the Board of Equalization wouldn't be an impediment to that process.
Absolutely.
As you see, she's the boss. So.
Now you're starting out right.
Wise.
Yeah. Wise guy.
Members, let's take a 5-minute recess. Members, let us reconvene the meeting of the Board of Equalization. We will take up the items for final action to resolve those issues for the taxpayer. Ms. Richmond, what would be our first item?
Our first item would be item C2, Jantex Inc. and Beyond Inc.
I
Discussion.
move to grant the petition.
Member Harkey moves to grant the petition.
Second.
Second by Member Runner. Objection. Ms. Richmond, please call the roll.
Mr. Horton?
No.
Ms. Harkey?
Aye.
Mr. Runner?
Aye.
Ms. Ma? Ms. Dowers?
No.
Motion carries.
Next item.
Our next item is C4, Brian Scott Gerstein.
I'd like to make a motion to allow the 4 transactions for the $100 and $150, and to have the drop shipment be handled separately as taxable separate item, and then sustain the rest of the staff recommendation for the remaining amounts.
Can we talk about that for a minute? Because
Sure.
I have a question in regards to the, actually the NASCAR watch.
Why
need a second?
why don't we just open up for discussion, and then we'll
You gonna
take a
second
motion.
it and- Oh, you want to open up for
The
discussion
challenge with the
first?
second
Okay.
is that you
And that'll
have
be-
to speak to the motion.
And that'll be what we'll be voting on.
Oh,
Just
okay.
Have the broader
We'll get
discussion,
there.
see if maybe
Okay,
there's a-
withdraw.
if
We'll
there's
get
a
there.
common motion or something.
Not second.
We'll get there. Member Runner.
My question is in regards to, I mean, I think there's some valid issues on those too, but to me, the NASCAR watch, it was also an item to which there was clear communication on the part of the taxpayer trying to clarify. Now, did he indeed, in that correspondence was the phrase, I'll find it here, where's my phrase? Did it say for resale, quotes, as the regulation says, or did he actually intend mean resale by the nature of the conversations? And I'm trying to let me find the reg here real quick, because I do have a question in regards to that. Yeah. Yeah, right. And the reg says it has to have the phrase for resale. And again, I just think the nature of all of his questions and whatnot indicated that was its intent. I don't know what to do. And the idea that the XYZ letter, the guy said, no, I was going to use it. But again, I'm not sure how else the guy answers the question, because if he says, if I answer it wrong, then I'm going to owe the tax. So I think he's not taking, that the XYZ letter, I don't know how useful that is, because it's kind of self-incriminating for him to answer that. So I don't know. I have a question about that one too. So I just wanted to kind of throw that out before we actually started the discussion, or in the discussion.
Chairman?
Member Stowar.
Actually, I see it different for that watch. Wasn't that email after the fact, so that he didn't take any type of resale certificate or attempt to take a resale certificate at the time of the sale, so we can say he took it in good faith?
Was it? I don't know. Was that after the? I thought it was during the negotiation of the sale.
I think you might be right.
The email correspondence where taxpayer asked the customer if he had a resale number was on March 20th or March 30th, 2011. He responded the same day. And then the transaction.
Yeah, because he's saying, please email me back the serial number and model number so I can make a payment. So, right, I mean, this was all during the negotiation of the sale, it seems to me.
Right. The negotiation earlier, the email correspondence that we have starts on March 29th, so it was in that same,
right,
within a few
Excuse me,
days.
it was during the sale transaction?
According to the email correspondence, they were negotiating price on March 29th.
Do we have the invoice?
We
No?
should somewhere, because the invoice needs to include, I think there was actually phrasing on the invoice that somebody talked about, so I assume we've got an invoice somewhere on it.
Okay. And then my other item is on the drop shipment. You know, at first I was thinking that, okay, this is a different transaction, it's non-recurring, and it should be moved out and just taxed separately. But their own testimony was that, one, they did drop shipment on a regular basis in-state and out-of-state, and they weren't going to do any more California drop shipment because now they see that they're going to be responsible for the tax. And then when I go to the audit manual with respect to non-recurring events, or non-recurring items, it doesn't fall into that category. That it was something that they sold on a regular basis, a watch, and the amount was within the same amount that they normally sell. So I don't see how we could pull that out based on the audit manual. I think it was rightfully included in the sample. As far as the other items, there's just not enough evidence for me to agree that it was not a sale. The letter that he did get from one client was just not enough for me.
Okay, so you don't like the motion?
I was being polite.
Any part of it, I believe.
Don't like any part of that one.
Members, my concern with the NASCAR watch is that no resale certificate exists. Unfortunately, the intent of the party, no matter how it's consummated or conveyed, unless their intent is that if they specifically said that this modifies any previous documents or so forth, the mere discussion of what you intend to do is tantamount to the discussion that takes place with the auditor and so forth, and the reverse wouldn't hold true. And looking at taxation, one of the days I try to look at it as a double-edged sword, that if that was the case when they had a valid resale card and someone said, well, we're going to use this, well, that resale card would actually relieve them of the liability regardless of what they intended or regardless of what email they sent, so forth. And so I'd have some issues with that. The reoccurring nature, we tried to get there on the reoccurring nature, but the taxpayer testified themselves. And quite frankly, I wanted to interrupt, but I couldn't. And he said it a couple of times that it's not reoccurring, it's something that is consistent, and its business is directly related to a sale that we do all the time. And so to pull that out as a non-recurring area, there would be an inherent challenge. The items, we certainly wanted to be able to sort of stratify this, and however the small amount items, the testimony is that they are reflective of the audit period and what happens throughout the audit period. Pulling those out too would be somewhat complicated from my perspective, but anyway.
I would just like to clarify on that. I think the items, the 100 to the 150, those 4 items, what occurred is that the department pulled out one document that showed a $6,000 watch with a $500 insurance, which we got explained really should have been $5,000. And if you shipped anything that's worth $6,000 and you've only insured it for $500, you're really in trouble. So I do believe that was an honest mistake. So I think that these other transactions, for which there were no invoices because they were truly just for shipment of, like he said, a watch. He seemed very credible and believable to me. I didn't feel like he was lying to us about those items. And he also had two responses on 2 of the items. The other 2 items didn't have responses on, but he did show the receipts for those, for the shipments. So I think he was very credible on those 4 transactions. As for the watch, I empathize, but I think we've had a lot of discussion on the proper form for sales, the proper form for resale. But I do think that transaction, I did ask him specifically, so the only transaction that was, of these being questioned, that is non-recurring is the drop ship, and he did confirm yes. So maybe something else was that I didn't clue in, but I did listen to the questioning there. So we could bifurcate this, I mean.
Just go, I'm fine if you want to restate the motion.
Okay. I mean, I could do any or all, but I'd move to allow the 4 transactions for $100 to $150, and to account for the drop shipment handled separately as an aberrant item or a non-recurring item, and sustain the staff recommendation for the remaining accounts.
There's a motion as so stated, second by Member Harkey, second by Member Runner. Members, I would have to share just to the issue of credibility, not to question the taxpayers' credibility, but the department is equally credible in their review and analysis of that it was a service in connection with the sale of tangible personal property. And so and these are verbal statements that we have the actual documents before us, the analysis made by the department, which disputes that verbal statement despite their appearance of credibility. So I'd have to object to that. Further discussion, members? Hearing none, Ms. Richmond, please call the roll.
Mr. Harton?
No.
Ms. Harkey?
Aye.
Mr. Runner?
Aye.
Ms. Ma?
No.
Ms. Dowers?
No.
Motion fails.
Subsequent motion, members.
I'd like to move to allow the 4 transactions for 100 through 150 and sustain the staff recommendation for the projection of the remaining accounts.
Also get it. That's the same motion.
No, it's not. No, it's not. It
What'd you
doesn't.
take out?
It does not. I did not take out the drop ship.
Yeah.
And that's a big item.
Let me hear it again, member.
Okay, there were 4 transactions for 100, 3 at 100 and 1 at 150 that had shipping labels, no receipts or no invoices, as I understand it. And they were verified and explained to me in full detail by the appellant. And the department didn't really, I'm not distrusting what the department said, but the department basically said there were no invoices, so we're just assuming that they were at a certain level. And the problem with that assumption is you don't insure something of a large value for $100. So I think he was very right and accurate in saying that the minimum is $100. He had to pay for $100. It didn't cost him anything, and he did it. So I want to move to allow those 4 transactions for 100 and 100, 100, 100, and then 1 for 150, and then sustain the staff recommendation for the projection of the remaining accounts.
I still would object. That's the logic seems to be a little counterintuitive, and that if it was insurance, I would agree that you just don't insure something for $100. Therefore, the conclusion made by the department there was service in connection with the sale of tangible personal property, I think is a reasonable conclusion on their part. But there's a motion, second. Ms. Richmond, please call the roll.
Mr. Harton?
No.
Ms. Harkey?
Aye.
Mr. Runner?
Aye.
Ms. Ma?
No.
Ms. Dowers?
No.
Motion fails.
Somebody else better make.
I give up.
Move to adopt staff recommendation to deny the petition.
Somebody else's turn.
Mr. Stowell moves staff recommendation. Second by Member Ma. Objection noted. Ms. Richard, please call the roll.
Mr. Harton?
Aye.
Ms. Harkey?
No.
Mr. Runner?
No.
Ms. Ma?
Aye.
Ms. Dowers?
Aye.
Motion carries. Our next matter is C5, PCS Wireless, Inc.
I'll move that the petition be denied and be referred to offers and compromise.
Second.
There's a motion to deny the petition and find the petition negligent. Second by Member Runner. Without objection, members, such will be the order.
Our next item is C7, Allied Modular Building Systems, Inc.
Ms. Ma?
Members, just, if I may, I just want to make sure, I just want to see if I can get the appeals department to clear up. There were a number of hypotheticals that were posed, and my review of the situation is that those hypotheticals simply didn't fit the situation in place. Although they did exist in the audit period, some of those hypotheticals where you have not a nominal transaction, walls and so forth, but the department excluded all of those. They didn't pick up the tax on that. The only thing that they picked up was when you had those major buildings with major drill downs and installation taking place and so forth. But I don't want to, I'd like to have the department speak to that as to what which is always the inherent challenge when we get into discussing hypotheticals. Generally, I think the hypotheticals are good because they serve to educate us in a what-if situation, but we also have to be able to get back to what is and the reality of where we are in these transactions. So, appeals, can you please speak to the transactions that are being disallowed?
And the way you phrased it, we would agree with. The department specifically went back to pull out the transactions that were the types of units that can be moved easily, that were the small ones, the ones that didn't have a roof on it. The ones that remain are, for lack of a better term, the big ones. Their own pictures show some of these that are 2 stories, they're full-size rooms.
No, those, but hang on. That was clear, that was not part of that was not part of what they were appealing, though, those particular ones. The ones they were dealing with were not the ones that are 2-story.
I'm just explaining what's left in
Okay.
the measure is the big, what got taken out were the ones that would qualify as modular furniture or that were consistent with that annotation that said if it's just walls of this type of nature that's the exception to calling it a construction contract. Those got taken out. All that remains are the ones that are the heavy items that can't be moved as a unit, that are affixed to the realty, that do have a roof.
Right. And your comment was 2-story. That's what I wanted to clarify.
I'm just trying to speak to the nature of how big what's left is and the small stuff that
There was not a 2-story item that they were appealing, was there?
I know the testimony was that they didn't have it. I'm just explaining.
Okay, I just want to clarify.
He's got it in the exhibit, so I was trying to use that as an illustration. We don't have the small stuff that could be otherwise modular.
Okay, members, we can agree to disagree. In the event that the board concludes that this is not a construction contract, therefore they're not the consumer but the retailer, and therefore a retail sale to the U.S. government, my concern is that there are hundreds of contractors out there that are treating it properly, and in such case, this exact same transaction, when another contractor's already paid the tax as the consumer, would alter those transactions. So in the event that that's the interpretation of the board, what would be the impact to other contractors?
Before I reach that question, it would delete the U.S. government sales for this taxpayer, and as they agreed, it would increase the measure of the remaining sales, which are the sales for sales to non-U.S. government customers. For anybody else who reported on cost and they don't have the U.S. government sales, if it's treated as tangible personal property, the measure would be the full retail price instead of their cost. And so to the other similarly situated taxpayers, non-U.S. government construction contracts, it would increase their exposure potentially.
Mm-hmm. They acknowledge that.
These taxpayers did, obviously. Today's taxpayers did, but Mr. Horton's question was to the other similarly situated contractors out there.
I'm not so sure that their representative wanted to agree with that, so I'll just throw that out there.
When you say it would increase these taxpayers' exposure?
Their net would come down. The audit item for the U.S. government sales would go away.
Okay.
The remaining measure, which is
$274,419.
That's cost. That would get basically would be taxing the markup. So that would increase. Their net liability, I believe, still goes down. Mr. Horton's question is for anybody else who has sales of a non-U.S. government construction contract nature who reported on cost. Technically, today's decision would mean that those would have to be taxed on the markup as well, and they're currently not.
Got it.
Well,
Sorry. Just real briefly, I think there was a brief discussion about Regulation 1583 and modular system furniture. Do we define furniture, or is it just, look up at Webster Law Dictionary, and to me, furniture would be a desk, a chair, modular furniture that we see often in offices like ours? Does that just apply the normal definition?
I'm reading real quickly, hold on.
Okay.
If I'm reading this right, the definition in the regulation is desks, credenzas, lateral files, bookcases, work tables. I don't know what a convergent is. Corner unit, storage towers, chairs. Basically, the common perception of what furniture is what 1583 is referring to.
Okay, so there's, in my view, there's no way we can get the structures that they were assembling to be under the definition of modular systems furniture.
Yes.
Based on the records, these are 200 to 2,000 square foot units. It's not, it's not a desk where someone goes and sits for a minute or two, But I can't remember the annotation that deals with this more or less, but the building within the building, 598, something like that.
190.0598.
Yeah. Can you share this with us so that we have as much of the information as possible in making our decision?
I won't take the time to reread it, but I did read that while the case was going on, and they actually put in dimensions and describe. 200 square feet. Some were more than that. It was 20 or 40 feet long, and so your understanding of that annotation is correct. Building within a building, but it's a very large building that you couldn't move as a unit by itself.
Okay. All right. Further discussion, members?
Yeah.
Member Ma.
So I think, this is obviously probably one of the tougher cases because it's the new type of construction or furniture or whatever they want to call it that people are using. I think we need to talk about, you put a roof on it, then it's not movable, but you don't put a roof on it, it is movable. Because I think that's what the taxpayers wanted. They wanted some clarification in terms of moving on, like how are they supposed to treat it? So, I'd just like to hear how the board wants to treat all of these, because there's other players in the market that are going to be impacted either way. So what does that mean? Does that mean our auditors are now going to go back, depending on how we vote today, to go back to all of these similar type of companies and audit and open it up? I want to have a conversation about this,
I think, and we've been pretty creative over the, here lately, in being able to protect the board from exposing itself to situations where our decisions that may be inconsistent with the law is not presidential and doesn't apply. And my personal opinion is that I don't think we're successful at the end of the day if we're ever challenged on that, but we've certainly been able to get there. But in this case, the evidence is such that these are not small units. These are large units in and of themselves. Once they're assembled, you can't get them out of the building without disassembling them, and then it's going to cause irrevocable harm to the building, which is one of the conditions of determining whether or not this is realty and it's a construction contract. The contract itself with the parties involved, that if my understanding is correct, is that they themselves, prior to adjudication, entered into a construction contract by the nature of their contract. You got materials, you got installations, you got ethics section. All of those are charges that they're charging, in the contract. So the contract itself becomes a construction contract based on their action subsequent to the hearing. And then the evidence provided in the video, it demonstrates how it's done, and that in and of itself demonstrates that it's affixed to the realty, and the inherent nature of the product itself is not similar to that of modular furniture, and more in lines with 1900598. And I think this is one of those areas that either the customer service department, committee, or business
business
tax
taxes needs to
committee
look
can
at
kind of take it up so that they can have a discussion as to where the interested parties are in this. But I think what we'll find is just diverse. Those who don't do business with the government would want to be consumers historically. Those who do business with the government would want to be retailers, because it's not a decision based on facts or based on law. It's a decision based on how much tax you want to pay. And so, unfortunately, I don't. And I think that might be helpful. I just don't know how to get there within the existing law.
So is it small? Is it big? Is it you can get it out? You can't get it out? I think we need to clarify this. Either it's all or nothing, or we're setting parameters, because I do think there are other, players in this industry, and they're going to be confused too.
Well, I don't think the other players in the industry are confused. I think there are a lot of them that understand this and they report it properly. It's just if they're subject to an audit, it's when the opinions begin to shift. And so, the Regulation 1521 is extensive. I think we've held a number of interested informational discussions on Regulation 1521. The contractors get it. The contractors really like it. They like to be treated as the consumer because it reduces their tax liability. So generally, their intent is to shift it to the other way. And we've dealt with this over the last 50 years. And the whole notion on the issue with the cabinets, and which was just a major issue for the Board of Equalization, they came up with this rule, this 90% rule, primarily to favor the contractors to be treated as the contractor instead of the retailer, or, vice versa, depending on the situation. The determination is, as it relates to size, is just an indication that it takes more than pushing it in, sitting it down, and then making sure it doesn't move in order to make it happen. So it's just an indication that kind of goes into the professional judgment. Then the affixation, how it's actually affixed, whether it has if it has a roof on it or not, there is an annotation that deals with this notion of the roof, which is an isolated annotation to a specific issue. But the way it's affixed, then is the next determination whether it's going to be damaging to realty. And at the end of the day, you have this thing that they refer to as a site test. You walk in and you look at it and say, oh, that's part of the building. And if someone was to purchase it, they say, well, that doesn't include all the fixtures and all the tangible personal property. But when they buy it, they're going to buy it as it is with this 2,000 or 200 to 2,000 square foot property in it. It has value to the realty by virtue that it's there from a selling perspective, whereas a chair in a building adds no value to the building whatsoever. Modular furniture, unless there's an agreement that you're going to leave that modular furniture, adds no real value to the building or the sale of the building. may add value in the escrow by virtue that you transfer it or you give it, maybe it's consideration. All those professional judgment is they take all of that in consideration. But for the most part, the industry is pretty astute. The government's astute too. I mean, the government, they don't want they don't want to pay the tax, and so they will usually issue a blanket certificate saying that they're not subject to the tax. Try to get out of it, but.
Couple
Mr. Renner?
Yeah, a couple comments. First of all, I don't know if anybody ever said that there was damage to the realty when these were taken out. I don't think that was ever talked about. I think quite the opposite was said, that these are movable, that you put them up and you can move them around. So I don't think there was any testimony at all that I heard.
But I think my point is that doesn't really matter. They have prefabricated houses that you can put
Well,
up
I
the
just-
whole house, and you can actually take the whole house down and move it anywhere you want.
Well, again, I only say that because your point, at least I heard, was removing them created, one of the reasons for justification was it created damage to the real estate.
The question
I
was
think
relative
that's
to
in real estate.
to
The other
regulation.
issue, it seems to me, is that the fact that it has value because you sell it, I mean, within a building, that's fine, but you're not selling it, you're not getting value because it's part of the real estate. You're getting value of it because it's part of it's there at the real estate site. Just like you can sell a building with furniture in it or not. You can buy a house with furniture or not. It doesn't make the real estate any more valuable. You're just buying it because it's furnished. And so the fact that it's a value at its time of a sale, it doesn't make it, adds value, doesn't make it any more of a permitted issue. The issue that I thought was interesting was the annotation. And that is clearly, in the past, I don't know when, there was clarifying annotation dealing with this issue of modular walls. Because in the beginning, this issue was applied to modular walls, that these were construction contracts. But yet there was a change and an annotation then made to exclude these modular walls. So my thought is, hey, look, if we could, I just struggle with this idea that says you can have a modular wall and you can use it for then an area that you're fencing off fencing off. And like I said, I've been plenty of hangars that should do exactly this for a tool shed or for a tool crib. And then you want to go ahead and put a roof on it that, again, isn't weatherproof. It's just in order to keep the sound down and all those issues. All of a sudden, it becomes a construction contract simply because it has all the elements are exactly the same. It just has a roof on it, and it's inside of a building. I think, to me, I don't have any problem trying to figure out how to extend the annotation to include that very narrow kind of application. And I think that's kind of where I come from on this issue. I think it's interesting. We talk about chairs and what's furniture, but the fact is we actually have. You can go to a furniture store, furniture catalog, and you can find whole pieces of modular furniture that include doors, windows that are 15 feet tall, that are and they sometimes they attach to the floor. Sometimes they're put in by pressure from ceiling to floor in order so they don't move, so they don't meet earthquake requirements. So it's more than just chairs and desks. It can be whole kinds of modular kind of walls that end up being there. And to me, this is more like a modular wall that happens to maybe have a roof on it for different purposes. And that's why I'm fine to, at this point, have we had a motion yet?
Yeah, but let me be clear. I truly appreciate your opinion, Mr. Runner, but I wasn't stating my opinion. I was stating the law. So, relative to my opinion, I mean, I'd love to see.
Again, Mr. Chair, I appreciate that. But the reality, hang on just a minute, because I think I have a right to deal with something here, because you basically said, I have an opinion, and you are quoting the law. What I'm saying is, we have a chance to adjust it with a new annotation, which becomes law. Or changes the law. Or
Can I interject here?
Madam Harkey, wait a second. I agree that we can change the annotation. We probably can change the regulation, and I think it's appropriate, if that's your desire, for the board to take that matter up and decide as to whether or not and how that affects. And I believe it's appropriate that we take that up in the Business Tax Committee. Unfortunately, that's not the issue before us, and the department took all of those items into consideration and they excluded them. They didn't pick those items up. They excluded them. The only items before us is the ones that are more akin to the construction contractor.
Let me
But
ask you,
anyway,
for process, is there a way for us to actually hold this pending a process within the Business Taxes Committee?
sure.
And that way we can actually try to see if we can try to identify what the unique issues of this are through a proper regulatory process?
Okay, I just would like to opine that I think that's going to take quite a while. I'm not sure what these taxpayers are looking for right now. This is not going to be a quick decision. We have currently, the regulation that we would be looking at is Regulation 1521, C3, which specifically states attached to real property, also says prefabricated buildings that are not movable as a unit are always considered construction contracts, whether they are attached or not to the real property, which I think is a problem for what we're trying to do here. I very much want to give these guys a break, but I'm just afraid that we're going to get this issue really confused. But Fiona, or Ms. Ma did bring up good points that the Department of Defense Regulation 1583 says it's not a permanent structure. The interior wall panels, 1901785, and to modular systems. So I think we've got a lot of conflicts here between what the Fed's willing to do, what the FTB does, and what the BOE does. And so I do think we need to review it. But, so I will be happy to take this as a business tax issue. I'm more than happy to do that, but I think we're going to have a lot of back and forth on it, and I think we need to probably have a decision this evening for this taxpayer and let them, as they said, to just kind of get on. There is a negligence penalty here that I don't think is appropriate. I'll just say that, and if anybody wants to try to abate for anything else, I would entertain that.
Okay. I'm sorry, I didn't mean to cut you off, Ms. Harkey.
Member Stowa.
Are we done with discussion?
Member Runner?
I would, again, I think that, again, I don't have any issue with the fact that we would try to create and understand the regulatory process to clarify this issue. The taxpayer's already paid $66,000 of his liability. He's only got $33,000 left, so he's already paid the vast majority of it. In reality, if we go ahead and, I assume what we would be doing is continuing this hearing. If the taxpayer then all of a sudden said, no, I want it decided, he could let us know and we could go ahead and decide it in the next month or two. If he was not open to a longer process, which indeed it would be. I mean, clearly you're talking about,
Talking about a
numbers of
real long
months.
process.
But again, it seems to me it would be in the taxpayer's hands, because if he chose not to do that, he could just say, hey, no, I'd rather have it on your next agenda. You guys just decide it. So it seems to me he still is in control at that point, so.
Well, I mean, for me, I'm clear. I mean, I get the regulation. I also get the law. And quite frankly, I think you have to change the law in order to change the regulation. Regulation is simply an interpretation of the law. What we end up with at the end of the day is clarifying law, not necessarily clarifying.
What law do you believe we'd have to change?
Legislation.
What's the legislation say?
But
see, I don't think so. I think it's all regulatory.
Okay.
That we have within the realm of being able to do it, just like the annotation does now. Just for the heck of it, I'll go ahead and move to grant for the taxpayer.
Okay.
Go from there.
Mr. Runner moves to grant in favor of the taxpayer, presuming a second. Member Harkey? Oh.
That would need to be a re-audit if you're finding that it's TPP.
Because the rest of the deal would
The markup higher on the.
I don't think it's going to happen, but sure, that's fine.
Let me make.
Do we have a second?
You okay with the re-audit?
Well, I think it has to be, because the clarity with the re-audit is because we're having to redefine what it was that his other sales were, as being tangible personal property, of which he said he was okay with.
And there's a markup.
Yeah, I know the answer. I just don't see the wisdom in it. There's a motion, second, it dies for the lack of a second. Subsequent motion.
I move to cancel the negligence penalty, otherwise deny the petition.
Member Stowell moves to cancel the negligence penalty, otherwise adopt staff recommendation and determine liability according to the department's second re-audit. Second by Member Harkey. Without objection, members, such will be the order. Ms. Richmond?
Our next matter is C9A and C9B, Phillip Andrews Anacker, Maura Stanley Harrington, and Jake Anthony Whitley.
I move to grant the petition.
I'll second.
Member Harkey moves to grant the petition. Member Runner seconds the grant.
I mean, just in discussion.
Discussion. Member
Yeah,
Runner.
the reason why I'm okay with that is because at least I am familiar with what it is that we give to some of those chain type in terms of what we assume on the sales. His numbers are much closer to that number that we give to some of those managed audits or whatever we want to call them. And so his numbers are closer to that than what the departments were, and so that's why I'm comfortable dealing with his numbers.
Yes, they were.
This,
Thank you for clarifying that.
this is another one of those ballpark things.
That's the flying goat.
You know?
These are flying goats.
Yeah. I mean, I wouldn't grant in its entirety, but probably reduce the ratio down to 12.5, which is, gives some consideration to,
What, 12.5?
As opposed to the.
As opposed to the
To the 11,
11.5 that he has.
right.
yeah, 12.5.
What did the department come up with? 20%?
Help me out here, Bills.
The department came up with a 23 and a 21.
Yeah, they
Okay,
did,
so it's-
23, 21.
I mean, for a variety of reasons that I could state if the night wasn't so late. But,
It is.
all right, there's a motion and a second on the floor to deny the petition, to grant the petition by Member Harkey, Member Runner. Ms. Richmond, please call the roll.
Mr. Horton?
No.
Ms. Harkey?
Aye.
Mr. Runner?
Aye.
Ms. Ma?
Aye.
Ms. Stowers?
No.
Motion carries. Our next matter is C10, Robert Ramos.
Oh,
Spoilage.
this one's a tough one.
Oh, this is real hard for me. I don't know about anybody else, but once Mr. Ramos started to speak, he seemed to be able to explain his case very clearly, and I thought he was very acceptable. I would, the non-taxable from the department was 4144. The non-taxable that they were originally requesting, the appellant was originally requesting was quite a bit larger, but then it came down to 4694. And I would like to move to accept the non-taxable to 4694, reduce the non-taxable from 4694.
To what?
Or to 4694 from 4144.
Okay.
And accept the rest of the audit, I guess.
I'll second.
Raise the non-taxable.
Non-taxable, yeah, non-taxable. That's right?
Just for clarification, Member Harkey moves to raise non-taxable up to 46.94. 94, second by Member Runner. Objection, Ms. Richmond. Discussion, members? Member Stowell.
Give me a second, please. Again, what did the department come up with?
4144 of non-taxable.
And you're saying 46?
Right.
Difference of 5%.
Appeals, if you want to bring some clarity to these numbers as to what we're,
That makes them a little more.
Taxpayer had originally thought 51.57, and I think he made a comment that he was going to split the baby, so he wanted to go between what his numbers said and what the department came up with. The department was looking at cash registered tapes for the period mid-February till the end of June. Taxpayer provided, extended the period to 6 months using sales journals for the first 6 weeks of the year. So departments was based on cash register tapes, taxpayers was based on sales journals. Is that what you're?
For 1 month.
yeah. The department indicated that the numbers in the sales journal were inconsistent and unreliable.
Correct.
And therefore.
Only 1 month. It's only 1 month. The rest of it they got.
Okay.
I don't know. I'm just thinking,
Is it-
he's going out of business in one location and.
All right, there's a motion and a second to adjust the non-taxable and somewhere in the middle. Second by Member Runner. Ms. Richmond, call the roll.
Mr. Horton?
Aye.
Ms. Harkey?
Aye.
Mr. Runner?
Aye.
Ms. Mogg?
No.
Ms. Dowers? Aye. Motion carried.
Wait a minute here.
That was a protest vote. It's okay. It's just fun up here.
All right.
Never want to assume on anybody.
Okay, that's right.
That was a protest vote.
Ms. Richmond.
Our next matter is D1, Kerolos H. Guirguis.
The department threw out a number, didn't they?
Which one is that now?
The cigar.
This one's the.
Cigars.
Oh, cigars. Okay.
Oh, no, I'm sorry.
no.
I've got a Hoyle. We already did
We
that
did,
one.
we
I'm
did
sorry.
Hoiles.
We did that one.
We did Hoiles.
I'm sorry.
So, just move the petition be denied, is that the proper?
Member
way?
Harkin moves to deny the petition, second by
Second.
Member Stovall. Without objection, members,
I wasn't gonna make all these motions.
such would be the order.
And we'll continue to work on the language of those notices and
I
whatnot.
can't
make
wait
the
for
motions.
everybody. I don't want to make these, I know you do. You get me in the ditch. We can all- I like to know I have some company up here when I throw something out.
Our next matter is item O, adoption of the board committee reports and approval of committee actions. We have the legislative committee from February 23rd, 2016.
Adopt. Motion to
Which one is
adopt.
it? The committee report, your next committee report. We just got it.
Oh, 1 second, I just need to catch up.
Right here. Oh, is it? Here, that's you.
Member Harkin moves to adopt, second by Member Runner. Without objection, members, such will be the order. Ms. Richmond?
Our next item is the organization of the board.
Members, I would make a motion to appoint Diane Harkey as chair of the board.
I will second.
I would do a substitute
Discussion,
motion.
members?
Substitute motion.
Members, I suggest we take up the motion as give every member an opportunity to vote on the motion.
Well, I'm going to make a substitute motion. Substitute motion will be that the board move to a rotation for the chair.
The item of rotation is up. Maybe we dispense with this, and then we're able to move forward and finalize it. So subsequent motions on the table. Without a second, it dies. Motion on the table. Mr. Richmond, please call the roll.
Then I have another substitute motion.
I've requested that we call the roll, so we'd have to withdraw that. I don't plan on doing that. Ms. Richmond, please call the roll.
Mr. Harton?
Aye.
Ms. Harkey?
Aye.
Mr. Renner?
No.
Ms. Ma?
No.
Ms. Dowers?
No.
Motion fails.
My motion fails.
Chairman,
Member
I would
Ma.
like to nominate Ms. Ma as chair. I believe her experience as a CPA will be great at this time while we're looking at the SEO audit findings.
I believe there's a second to that, Member Runner?
Second.
Member Runner seconds.
No, they should not.
There's a motion and a second to nominate Ms. Ma as chair. Ms. Richmond, please call the roll.
Mr. Harton?
No.
Ms. Harkey?
No.
Mr. Renner?
Aye.
Ms. Ma?
Aye.
Ms. Dowers?
Aye.
Motion carries.
Congratulations to Ms. Ma. I'm sure she'll do an
Congratulations.
awesome job. And to the other items on
One
the.
quick comment before we move on to the next
sure.
item. I want to say thank you to you. You've been an excellent chair. It's 5 years. You've had some hard times dealing with some of the issues facing the
It's been
department.
fabulous.
I'd like to commend you on the outreach you did with VITA and other, poverty reducing issues, TRACE, the Tobacco License Act, and just your overall knowledge of the department and how you seem to bring us all back together when we're out there sometimes. So thank you very much.
Thank you very much. Very confident that Member Ma will continue in that line. She certainly demonstrated that in the legislature.
I would like to say a word too. I want to thank you very much for your 5 years of service, and especially this first year being on the board. It was absolutely fabulous. You were very, very helpful in keeping this board together. There was a lot of contention, primarily over the reorg. And I would just like to say that the contention over the reorg has really created a bit of a fracture up here. I would not have even bothered to assert myself had it not been so contentious. And one of the items of contention is the most recent bill that just got put forward that quite honestly puts everybody up here in the ditch. It's AB 1828 that Ms. Ma has sponsored. And I would hope that now that she is board chair, that she would somehow see that this is, this is not in the best interest of the board. It's not in the best interest of future communication. I think we all worked together really well for the first 6 months, and I would like to see that return. So that was my reason for not supporting at this time, but that doesn't mean we won't be cooperative going forward. I appreciate everything that she has done with the legislative agenda, even though some of the bills I didn't appreciate. And I'm hoping that we can finally get this board rowing together and not picking things apart. That's what I'd really like to see. I think we had a good 6 months, and I'd like to see it continue.
Thank you, Member Runner.
I'm sure we're going to take time at the next meeting where there'll be some specific issues, talking about the chair and long service. And, I think whenever you get into, obviously, these public roles, sometimes public roles are easy and sometimes they're hard. And, the public roles sometimes mean that you end up with disagreements. But at the end of the day, I think we have all been around long enough to know that we all have a job to do. And we appreciate the hard work that each person and member does. And I think that we certainly need to make sure that as we come together next time, that a part of our agenda includes then a thanking of the chair for leadership in this process.
Thank you, Mr. Runner. Much appreciated. Members, it's been a long time. It's been 5 years serving as chair of the board, and quite frankly, it is time, as we begin the transition, I believe every member should have an opportunity to serve as chair of the board. It's a unique experience, even though the responsibilities are rather limited. But it is a position that allows you to provide some guidance and some leadership on a number of different issues. And it's been an extraordinary pleasure. With over 35 years of public service, I've often told people that this is one of the only positions that I'm actually overqualified for. You know what I mean? And so under Member Ma's leadership, I think we have some issues to deal with over the next year and a half. I'm very confident in her ability to do that. And Member Ma?
Yeah, thank you. I appreciate serving with everyone here because I think we all bring different perspectives to the board. And one thing I try not to do in the legislature is try to take things personally because we all represent our constituents. We all get elected by the people we represent. We may not necessarily agree with each other, but I hope that we can agree to disagree and not take it personally. So I look forward to working with all of you. I do especially look to the chair on many of the BOE appeal cases because I think based on your experience, like you said, you have been around and you've been doing these audits and you've seen these cases, and so I appreciate, and I do change my mind, like the case today, listening to your arguments, and so I think it's been very helpful to have a healthy debate for each of these cases. I appreciate the dialogue. I think the taxpayers appreciate the dialogue as well, and I, look forward to serving and working with all of you.
Thank you. Members, during my long term in office, I made a couple other recommendations. I'd like to take those up. During this process, one of the things I've sought to do, and I believe we will continue to do, but I think there needs to be a clear path so that clear path to members to be able to advance things on the agenda, and I'm sure Member Ma would be supportive of that. And so I made basically two other recommendations, three actually. One was that every member have an opportunity to bring any issue that they want to the board, to have it discussed in the public. I think it's healthy for the public debate, and to have that. There was one, I think in the 5 years I've served, there was one misunderstanding as to whether or not I was to bring the organization of the board to the table. The fortunate thing about being the leader or being the chair, and as it relates to the agenda, you're sort of responsible for trying to figure out what the consensus of all the members, and certainly consensus of these 5 members is not an easy thing to attain. And so in that process, it may appear as if though you're denying one member when you're actually taking in consideration of what happens with the other members. But a clear policy that simply allows members to advance things to the agenda with the request, I think would be appropriate. And I would make a motion that be the policy. Is there a second?
Second, is that, just to clarify, so on each agenda there would be an item called like members' items?
No. On each agenda, any item that the members would want to bring forward, there are some particulars that, things that are under the jurisdiction of a committee should go to that committee and be respectful of the chair of that particular committee to process it. But they should be able to advance that agenda. I don't think any of you have had a challenge with that, but some folks have expressed concerns about whether or not SEIU, whether or not they can continue to advance their agenda. And I think it's important that we do that. So the motion.
I'd like to offer a little clear. I think if an agenda item to the board comes by two members, is maybe a little easier to handle from a chair position, because then at least it has some support. I'm just thinking we could get really bogged down with items here.
Well, the challenge with that, Member Harkey, is that our members, to their credit, are advancing items in the legislature and advancing items here. And oftentimes, it is the process of debating it in the public that allows us to get to a point of consensus. We very well may not start out, and may not be able to establish that consensus And the inherent danger of having two members agree on anything is that there's always that third member in violation of Bagley-King.
Well, you don't have to violate Bagley-King to know that you've got an idea and somebody else wants to support it, to bring to an agenda. So, but whatever you want to do.
Again,
I'm
I'm supportive of the concept. I'm just trying to figure out what that means right now from what you're saying. Because if you don't have an agenda item that says like members' items, and a member wants to put something on the agenda, I'm trying to get what that means.
Let me be helpful. The process would be similar to the process of getting any item on the agenda and assuring that it has been, that it meets the timeline of the PAN.
Right, I get that part, right.
And so the members, what I would recommend is that the members would submit their idea to be placed on the agenda to the executive director, have it reviewed by chief counsel to assure that it's legal, have it reviewed by the impacted department, just so that they sign off and give the member some insight into what their perspective is, and then move it to the agenda, then have the executive director simply place it on the agenda.
I'm actually okay with that. The only trouble I have with it is it seems to me that members ought to be able to be the ones putting it on the. Again, I can't think of an example, but maybe I'm just trying to think. If I'd hate to have an
I
item.
can give you a number of them.
No. I mean examples of things to go. I mean, the idea of having the department sign off that you just said concerns me a little bit. I'm not sure what that means.
Let me see if I can be helpful. The review by legal is
I get review by legal.
Is simply to advise the member whether or not it is within the legal authority of the Board of Equalization.
I get review by legal.
The review by the impacted department is to provide the board member with insight into, and arguably, based on my experience with all of the members here, they do this anyway.
Right.
I mean, I have not seen too many ideas that have not gone to the department, and the department's done some analysis and provided that member with their best expertise.
Right.
It is not an impediment to the process.
Okay.
It is just a
You're just saying
review.
that it would be good to have them review the issues.
I'm saying that they should review the
Yeah.
issues, and then once the member receives that information, it's up to them whether they want to advance it and move it forward.
Okay, the member's up to the member.
Up to the
I
member.
got it. Okay, that clarifies for me. I just don't want the members have to go through hurdles trying to get staff permission, you know what I mean? But if what you're I think what you're laying out is a smart thing to do, and that is,
Okay.
first of all, you want to make sure it's legal. Second thing, you want to make sure what hurdles staff would have, and then you go on to the agenda. So I get it.
Thank you.
That's fine.
So there's a motion and a second to that effect. Discussion, members, further discussion, hearing none. Such would be the order. Members, to the issue of the rotation, I clearly believe that every member should have an opportunity to serve. This is member John Chain, who is currently what is John? John's our treasurer. Saw the wisdom in that. When he served on the Board of Equalization, a number of other members have seen the wisdom in that, and I certainly would be supportive of that and would make such a motion if there was a second.
Is that a motion?
It's a motion.
Can I-
It's a motion. It's a long way to get there, but it's a
Yeah.
motion.
What's your motion?
The motion is to have the chairmanship rotate, and I believe Chief Counsel is here to kind of speak to the history if the members like to hear that.
I'll second that.
Okay. Second by Member Runner. I would ask Chief Counsel to come and just brief us on the history. Pursuant to the request of Mr. Runner made the request that Chief Counsel would provide some guidance on how that has happened historically.
Yes, Randy Ferris, Chief Counsel. Yeah, there have been 5 instances where the chairship has rotated through the 4 district elected members within a given 4-year term. And it's been done in a variety of ways. Sometimes there appears to have been a plan to do it in some sort of sequential order, and other times it appears to be random. So.
Chair?
Well, that's some history. Member Stoll.
Mr. Ferris, when they did it, did they do it at the start of the 4-year term or midway through the 4-year term? Could you tell from that data?
Right. For purposes of the memo, I focused on the 5 instances where within a given 4-year term, an elected term of a member, that the chairship rotated amongst the 4 district elected members within that given 4-year term. If you just expand it to a wider thing of within any given 4-year period that didn't necessarily completely overlap with the term of a sitting board, where maybe 2 different boards rotated around through the 4. There might be more instances than these 5, but my understanding of what you all were contemplating would be within your 4-year term, not necessarily binding future boards as to what they want to do.
I would say, members, that we can't bind future boards, and so and I can share historically what pretty well happened. Treasurer Chain simply said that he thought it was that everyone should have an opportunity to do this after his experience, and provided that opportunity. And then what happened was there was a dispute over a franchise tax board matter, and the majority of the members took that back and said, "Whoa, wait a minute here." But I think that was an unusual action by an unusual member, which doesn't seem to be reflective of the members that we have here. I've actually, one of the things that I've had appreciated here is that is the nonpartisan that primarily takes place when it comes to the administration and the staff issues here, and our ability to discuss these items. Member Ma and Member Runner have worked together on a number of significant issues and have advanced a number of issues here at the Board of Equalization and so forth. I've had an opportunity to work with other members as well. And so the role of the chair is facilitating these meetings. Whether you're chair or not, your ultimate vote is what you end up is entirely up to you. The other role that I sort of adopted as chair was not really to make motions and to try to listen to the members and allow as much of the debate as we can, and then to the extent possible bring some clarification to the law without taking a position unless I absolutely felt I had to. But everyone will handle this position differently.
I understand what you're saying, and obviously it doesn't affect me at all.
Hey, we could include you now.
But I just think
let me ask that question, if you don't mind. Could the deputy serve? Probably not.
I don't know about that. There have been times where the controller, in the history of the board, there have been times where the controller has been the chair of the board.
Yeah.
No, it's going to get confusing.
1872. So before
1872.
Before it was a constitutional office.
Okay, so
well, there's
Constitution, he could not.
There's a young lady by the name of Miss White might like to see that. Anyway,
my thought is that rotation could be good, but I just think at this juncture it's a little premature, and it's something that the board should consider at the start of the next 4-year term. So I can't do the math on that. That would be 2.5 years from now.
It'd be 2018, but I mean that
January of 2019, right?
Yes.
Yeah, I mean that would.
Well, I'll be the only one here.
Well, I was trying to figure out a way to make that point, but I think that's clear enough. Okay, I mean we got it. I still think that my motion stands to rotate the chairmanship. I believe Mr. Runner has seconded. Ms. Richmond, please call the roll.
Mr. Horton?
Aye.
Ms. Harkey?
Aye.
Mr. Runner?
Aye.
Ms. Ma?
No.
Ms. Stowers?
No.
Motion carries.
There is now we have to somewhat figure out how to do this. Any thoughts, members?
Yeah, let me suggest a rotation process. And it might be a bit logical even in that sense. And since Ms. Mom right now is chair, that we start with District 1, or excuse me, we just start with District 2 as she's chair, and go backwards 1, and then we would go 4. Then we go 4. Then we go 4.
Oh, Mr. Runner, you are so transparent.
That I think is a reasonable way to do it.
Okay, well,
I would also suggest that because we're doing this in the midterm almost, in March, and normally organization is in January.
Well, for the last 5 years, the organization hadn't existed.
Well, right, but again, it's going to be a new board. It'd be a new board.
So.
I would suggest, and I would be open to then, going from March to March in this first year with Member Ma. In the rotation to the first district, I will be glad to take the shortened term in order then to get us back on schedule for a January reorg.
You know what? I really, I'll be honest
members,
with you, I really don't
members.
care. Let me tell you why. Because anytime this board doesn't want to reorg, it doesn't have to.
Right. Well,
So even if we say we're going to reorg, we don't have to. And if
Members,
we've seen, I mean, that's just the way it is. You got to have 3 votes. You got to have 3 votes.
Right.
So.
Okay.
I don't really care.
Members, I don't necessarily see the logic in going backwards and then forward, and then skipping. What would happen is that you're at 2, you would go back to 1, you would skip 3, and jump to 4. And
not if you're going backwards, you're not, but that's fine.
Oh, you just roll backwards.
Yeah, just go backwards.
Yeah.
So George is next.
Cars don't do that very well. But anyway, I mean, I appreciate, the desire to be next in line. I
Well,
get
anything
that.
we're gonna do is gonna be
But I think if
arbitrary,
you
so-
just follow the historical, way of just, we're at District 2, we go 3, we go, skip me, which I'm cool with, because I've served my term, but it would be in order, and it would be in a logical order, then 4, and then back up to 1, and the decision as to whether you split the period, and I don't think it really matters when we can be consistent in doing the reorg. And then if member runner's prepared to take the short period, you got the short period.
I'll take the short period. If that's the way the board wants to go, I'm willing to go ahead and take the short period.
That would be my motion, that we move in numerical order 2, skip 3, go 4, go 1. I presume member Harkey would second that. And discussion, members? Hearing none, Ms. Richmond, please call the roll.
Mr. Harton?
Aye.
Ms. Harkey?
Aye.
Mr. Renner?
Aye.
Ms. Ma?
No.
Ms. Dowers?
No.
Motion carries.
One other item, is it one other?
Let me assume then that the incoming board member would serve as vice chair. The assumption would be the incoming chair, or
Well, as Member Ma has said today, and quite eloquently, let's not make any assumptions here. So I would be supportive of that.
I'm fine with that. I mean, I think it makes logical sense.
Harkey being vice chair. So there's a first and a second with her being the vice chair.
Well, actually, I'd like the policy in place, not only that
me?
that the incoming chair the following year would become vice chair. That way there's not a discussion every year.
All right.
It
Does
just
that mean we
becomes
won't vote for
automatic.
vice chair now?
We're going to vote now.
We will vote for vice chair now.
Vice chair now. Ms. Stowart, vice chair?
Yeah, I nominate Mr. Runner for vice chair.
Okay, well, Mr. Runner has nominated Diane Harkey, so.
That's why I wanted to get clarification.
Yeah, there's a motion to go in the order of that as articulated. Mr. Runner has expressed his okay with that. Second by Mr. Runner. And so unless there's a subsequent motion that would say that, you disagree with that. But it seems that there are consensus. I mean, we got an opportunity to start out on a fair and equitable stage here. So I would suggest we do that. Ms. Richmond, please call the roll.
Mr. Horton?
Aye.
Ms. Harkey?
Aye.
Mr. Runner?
Aye.
Ms. Ma?
Aye.
Ms. Dowers?
Aye.
Motion carries.
And the last item,
And just a point, there will be an issue in the fourth year because there won't be an incoming chair. So you'll have to vote on vice chair
Oh, and that
in the
incoming
last
year.
year.
Yeah.
So
Right.
just a point of clarification.
well, we have, we would defer that to the incoming members.
You could assume the rotation, I guess, and then let it happen or not.
In March of 2018,
Right.
Member Runner would move from vice chair to chair, and for the remainder of 2018, you would need to elect a vice
Right.
chair if you want one.
You could assume the rotation and then,
Right.
right?
All right, we'll figure that out.
Okay.
The last issue, and members, let me be clear here. I'm not necessarily moving these issues because I think this is something that my own personal opinion, this is what I actually think is the consensus of the board. In fact, I don't even see a need for the second one. Any other discussion, member? There's another item I recommended. If members want to take it up, they can. If not, well, the item was to, it's the way I currently do this, which is the assignment of the chairs, the various different committees. I am hopeful over the next 2 or 3 years that we can figure out a way to do what Member Ma has done with the Legislative Committee and Member Harkey has done with the Business Tax Committee, and that is actually have them involved in more interested parties meetings and engaging and changing as a change agent, as these two individuals have done. And certainly in the absence of chairing the board, I look forward to that opportunity. But the recommendation was to have that be a public discussion so that we have that public sign-off of those members becoming chair of the various committees. So in this case, that the chair would make the recommendation, be ratified by the board, which is the way I've basically have done it to the extent that I had restrictions of Bagley King. Quite frankly, I just asked Member Ma, what do you want to do? She said legislation. What do you want to do? She said business tax. Mr. Runner said, what do you want to do? Customer service. And I just take whatever left, which is property tax, which is another one of the roles of leadership is to submit to the other members and what their desires is. So I'd make a motion to that effect. Is there a second?
No, I'm not going to say. I have a question on it.
Question.
I don't know how that actually works. I guess, I don't know how that actually works.
The chair would recommend that the chair of the various committees, this is the way it currently works, and then that recommendation would come before to the board, and the board would ratify it.
No, that's not the way we're currently doing it, is it?
No, that's the
I
informal way that we currently do it. I mean, currently, I don't do much without having a consensus of what the
So
other
I guess my
members
question
wanna
is,
see
why don't we
happen.
just keep doing it the way we're doing it then, if that's, that would be my issue.
I think what
I just-
Mr. Horton is saying is that he's concerned for potential Bagley Keene because it's, he's circulating around members, and I don't think he's had that problem because nobody really wanted to do a whole lot with these chairs before, these committees before, and now we're all very active. So I think that's what he's trying to avoid, but I don't know that we will have a problem with that.
Yeah, I think Member Harkey has articulated, I'm trying to get it into the public purview so that there's a discussion so that we don't have to try to figure that out. Now, I'm also saying that it doesn't have to be figured out at all. You know what I mean? Nobody has to discuss it. We just roll with it because the unfortunate inherent nature of these positions, I don't know if anybody really, well, I don't know how much members actually serve on these committees currently. And
We
so,
Staff does.
and so I think staff does a yeoman's job in that regard. But I got a suspicion that members will begin to serve more if we begin to structure it differently. And quite frankly, I'm looking at not necessarily this term, but as we go forward, it's just a good message to the general public that it is something that's discussed. But that's, I mean, I get the.
What does Ms. Ma?
Member Ma.
our next-
Can I ask, I brought this up late last year that I wanted to form a standing committee for audit and budgets, to go over the audits and also during budget time especially. And, we never had a discussion publicly about this. And I know that Ms. Stowers and I formed kind of a subcommittee to review the RFP. I still think that we as a board need more oversight in terms of what's happening internally with the audit, and
Those.
and also the budgets as we approach, the Assembly Sub 4 coming up. I think that is important that members get engaged and not just let it go like, without some sort of oversight from our board. I just see with the last audit that the controller did that there is a need, and whatever, I've been on the Board of Supervisors, I've been in the Assembly, I've been on nonprofit boards, and there's always a budget and audit committee. They take that very, very seriously, and so I don't know how we want to address this.
Let me ask the chief counsel a quick question on that. There's nothing that would prohibit us from having, in fact, we've done it, assigning two members to a subcommittee with a subject and that they work on and then report back to the board.
No, there's nothing that prohibits that.
Because that might not be a full-time job, or.
I mean, so
well,
I mean, if indeed we felt that there was a need for a subcommittee could identify, for instance, the committee that laid out here that Fiona was just talking about. A budget and audit committee could be the subcommittee of two members who would then work with appropriate roles at that point, and then would come back and report to the board as a whole for any actions that needed to take place.
Yes, and the board can also just tell the executive director or chief deputy that's on the agenda every month and here are the questions we want you to be addressing before us this month. So you have mechanisms in place to have oversight.
My question, I guess, then is to Chair Ma. Are you looking for something like that, or are you looking for actually which would be a committee of the whole, which I'm not sure I'm supportive of a committee as a whole to deal with that issue.
Members,
I'm interested.
One second. We would have to maybe we can discuss whether or not, because it's on the agenda, we can discuss whether or not we should take the item, the assignment of committees up for ratification by the board. We cannot discuss whether we're going to establish any other board. I think we can have clarification. The board has established committees before. We recently established a committee by a vote of the board to oversee the audit process, of which Member Ma and Member Stowart was on the committee. We can do that. The committee assignment process is open to the board, open to the interpretation of the board as to how we accomplish that. Relative to the request of if part, let me see if I can frame this, if hypothetically a matter was to come before the board on any committee, that's one of the reasons I recommended it, as articulated by Member Ma, that I think it gives the board to have all the input that they need to have and in the public so that they can establish those committees. So if any member wants to bring that before to the board, they can, and you provide for ratification. Just by way of process, I guess I can discuss this, is that the recommendation was to establish an internal audit committee. And quite frankly, I thought that was a violation of a number of different laws and would have put the organization at huge risk. And so the desire at that point was to shifted back to maybe a potential budget committee, which is something I would be supportive of. So this discussion itself is why I made the recommendation and why I think it's of value that we have these types of discussions in the public about committees, that committees can be recommended by any member and then ratified and discussed in the public and then ratified by the board. And when it goes through the legal process, legal will certainly counsel us as to whether or not that's a workable thing. So again, you know.
I'm not sure if Member Maura.
I think that
The answer is yes.
Member Ma will have her opportunity to bring anything forward
Well,
that she wants.
The tradition of the board is that the chair has the authority to establish ad hoc committees at the chair's discretion, so.
So she can establish one.
An ad hoc committee by definition is two?
What?
An ad hoc committee is a minority?
No, I think an ad hoc committee is a committee in addition to the 4 regular committees of the board for whatever special purpose that is within the purview of the board.
So then how do we do that without violating Bagley-Keene? So last year, Senator Runner and I, went to the Assembly and represented our agency in front of the Assembly or Joint Budget Committee. I thought it was helpful for us to be there, but realistically, we were not involved in the presentation, nor did we really know what the staff was going to present. I thought that was not helpful for us, and I would like to see members more engaged if we are going to do things like that. Like, we need to be brief, we need to be, part of it, not just sitting there listening to someone give a report where we didn't really know what was going to come out on the report. So I'm just saying to the board members, I think we need to have more input. We do need to take more oversight if we are going to really, ensure that, the integrity of the board as well as, the audit gets finished. I'm okay with having an ad hoc. I don't know how we can do it without violating Bagley-Keene. Do we kind of volunteer to be on an ad hoc committee? Or, I know the chairman kind of said who wants to work on it. We worked, Ms. Towers and I worked on the RFP for the CPA firm. So what would you suggest?
Well, in order to avoid Bagley-Keene problems, you would only want to have 2 members working together and then reporting in public session to the other 3 members what your committee is doing and whatever actions you're recommending.
Members, I would suggest, first, to being able to get any information that any member wants before appearing before a committee, I think they simply have to ask. There does not need to be a committee. You simply ask, and
the mechanism exists presently.
This exists to do that. Second, I think the discussion, having that discussion in the public is of value, as we have demonstrated here, and why, I've made the recommendation. Absent of having it, having 2 members serve on a committee is inherently challenging because the issues that may be discussed in the committee, those 2 members would be prohibited from being able to shift around and have discussions with other members that they think they need to have discussions with, being cognizant of the fact that the 2 members on that committee may not always agree. And when they don't agree, if they were not on the committee, they would have privy to the information and be able to go to another member that's not on the committee and have that discussion without violating Bagley-Keene. So having 2 members in this environment is relatively challenging. It works on the city council when the council is made up of 9 members because establishing a quorum is a little more complicated. So
can I just clarify though, in terms of the path that I think?
Well, one of the things. So I like to go back to my recommendation last year to form an audit and budget standing committee so that we all can sit on it, like we do for ledge, like B&P, like property taxes. That's what I initially, threw out there, and haven't really had the opportunity to discuss it. But now seems to be the time, and maybe we can agendize it and talk about it.
Before any members discuss that, Madam Chair, if that's your desire, I would suggest that you express that to the executive director and then have it placed on the agenda, and would suggest that it be placed on the agenda for an open discussion. And I would probably say, without even hearing or saying my opinion on that, I would say that there probably would be some consensus to that regard.
And kind of following up on a more practical path, because I think the example you used was, all of a sudden the legislature was meeting, there were hearings going on, there were concerns in regards to some aspects of the BOE budget and whatnot. It seems like what I'm hearing right now is that a chair has the ability to then work with staff and bring up, and again, work with them in regards to that presentation, can call another member in to be a part of that, I guess, what would you do? I'm sorry, you called it an ad hoc committee to go and represent the board then on those issues, working along with the staff on that presentation. Is that, but I mean, that would be, right, we have a path to do that now.
Yes.
Okay.
I mean.
But you also can talk about it, the five of you, with a fifth committee that you established.
Right.
That would follow the same normal
Five of
rules
us.
that all the other committees are following and get agendized.
Yep.
Okay.
And the reality, members, these members aren't restricted. They can show up anytime they want, anywhere they want, and I think they all know that.
Yeah.
So I think you guys have all made the case for the necessity to have this and have a public discussion. So I will, and I thought that was the consensus when I put it on the agenda, but after. So I would return to the motion to have committee assignments discussed in the public and ratified in the public under the direction of Madam Chair. Is there a second?
There's a second.
There's a second. Ms. Richmond, please call the roll.
Mr. Horton?
Aye.
Ms. Harkey?
Aye.
Mr. Runner?
No.
Ms. Ma?
Aye.
Ms. Dowers?
I'm sorry, it's late. What was the motion?
To have the committee discussed at the board and decided by the board.
Oh, aye.
Tonight or?
No, we can't do it tonight. We can't do it tonight.
I would like
Okay.
to offer one more thing, Mr. Chair.
We're voting, and the last thing I want to do is exit out of here with a violation of Bag of the King, anything like that. So the vote is taken. Ms. Richmond,
motion
please.
carried.
Motion carries. General discussion of any item on the agenda.
Not, this is
Well, let me
just-
do this. The meeting of the Board of Equalization is, well, I can't do that either. I still create the same problem. Let me just hear what you want to say.
Yeah, it's pretty simple. You were saying some of the items that you'd like to see, and this is not really necessarily for a vote, but for consideration.
Even consideration, might want to, if it's
Something-
not on the
something-
agenda, I might suggest we just bring it
Well,
back.
because it's based with the reorg and everything else, and it's just the order of the agenda. I think the agenda that we see at each week, probably, I'd like to see more of the items where the taxpayers get in a little bit quicker, and maybe we rotate that. I'd like to have the chair consider such an item. I think it's real hard for me to sit here and take half a day with people sitting and waiting, and so that's something I'd like to see.
I think that's a question of Chief
It's-
Counsel, without discussion, members, if we may.
Don't we have the ability, though, I think we can discuss, this is,
The chair has the discretion to take items in any order.
yes.
There you go.
There you go. See, I think we can, right.
I think Chief Counsel can handle it.
Yeah.
Chief Counsel?
Yeah.
Okay.
We're good.
All right.
No violations.
Violation.
It's all out in public if it was.
We're talking about a
Members,
procedural-
the meeting of the.
So it's done.
Members, I'd like to close this meeting in memory of Mr. O'Connell, and offer our condolence to his entire family and thank him for his service to the board. Oftentimes, we speak about a guardian angel. I truly believe that he will be as such and watching over the board as well as all of the men and women who serve in the military. With that, the meeting of the Board of Equalization is adjourned. Thank you.
What time's my flight?